Good morning and welcome to the University of St. Thomas Law Journal Symposium. My name is Rachel Tebow-Hampson and I'm the symposium editor here at the Law Journal and third year law student here at the University of St. Thomas. Thank you for joining us today. We have over 200 community members, legal professionals, and law students attending virtually. The Q&A function is active, and if you have questions, please submit them. Time permitting, our presenters will respond. We're going to start our program today with our host professor, Mark Osler, sharing a few words of welcome. Thank you.
All right, well, thank you, Rachel. And I do want to thank Rachel for all the hard work that she's put in preparing for today. It's been months in the making, and a lot has gone into it by not only you, but so many members of the journal. On May 25th of this year, George Floyd was killed by police officers, not far from where I sit right now. I realize that we have people from around the country who are going to be in on this today. But the proximity to the harm that happened is important. That we're a law school that's of a place, and our place was sorely wounded by what the police did that day. It was wrong that reverberated around the world, that we saw foster a discussion of race that was unprecedented in recent memory, and one that was needed. Unfortunately, like any discussion of race, it runs into a faltering where people are scared to continue the discussion, where there's fear of what it means, our racial history, that we don't want to look at troubling things too often. And this is a series of deeply troubling things, the great tragedy of our nation. That unprecedented discussion of race has to continue, that we can't stop cold and say, well, we dealt with that, because we have not dealt with that. And the mistake we've made in our nation over and over and over again is reaching that conclusion that things are better now because we had the discussion. Real change has to be affected, and we have a long way to go to get there. In law, this is a problem that's embedded in law. As lawyers, as scholars, as students, part of the challenge that lies in all of our futures is to figure out how race and law are going to interact in a way that addresses the problems in our country. One of the things that makes that problematic is that too often there's this veneer of race neutrality, that if the law doesn't say there's one rule for African Americans and another one for white people, that there isn't a race problem. And that's deeply troubling. We need to look at what actually happens in this machine that we call the law. In my own specialty of criminal law, it's undeniable that there is systemic racism, because that system produces racially disparate results. Whether on the face of it, it says it appears to be race neutral, it's undeniable at this point that what it produces is racism. And that's part of the question that the death of George Floyd, the tragic death of George Floyd, raises. It's a question that we have to grapple with as a society, as individuals, as professionals, as lawyers, as, for many of us, people of faith. I want to talk about that for a minute. We're a Catholic law school, and that means many things. But one of the things it means is that we conceive of time differently in some ways. There's a lot of places where you can go where they look back to their history. I studied as an undergrad at William and Mary in Virginia, which of course goes back to the 1600s. And there was often reference to that. And you take classes in a building that was built in the 1600s. But the faith that this institution is centered on has a different time frame. And it's that of millennia, going back to really the start of recorded human history, when we started telling the stories of our formation community. And That sense of time over millennia offers us some perspective. And one thing that it shows us when we look at it and we study it and we engage with it is that not all moments are equal, that there are some moments that are more important than others, where terrible errors are made, where great victories are won, where people make a right decision or a wrong decision, and also times of lost opportunity. Looking at things that way, we realize that all moments aren't equal. And this is an unequal moment because it's a moment of great tragedy. And it's also a moment of great opportunity that we have seen in those 9 minutes in which George Floyd was killed, the worst of us. But we can hope that it brings out the best in us walking forward. Now, as we go through the day, there's many topics that are going to be explored. I'm particularly looking forward to it because this involves some of my current students, like Rachel, and we're going to see others of our current St. Thomas students playing a role as moderators as we go through the day. One of my current colleagues, Uhuru Williams, is going to speak. My former student, Leslie Redmond, is going to speak, and I certainly look forward to that. One of my writing partners is going to speak, the Honorable Mark Bennett. And one of my classmates in law school, Cornell William Brooks, is going to be our keynote. And I really look forward to that. Speaking of time, that goes back 30 years, over 30 years, that he and I sat as students, the way many of you do now, in our classes and learned about constitutional law, learned about contracts, learned about torts, learned about criminal law, and had aspirations and dreams. And probably for the two of us, one of the things that we hope for more than anything else is that we can be a part of the hard discussions that matter. And it brings great joy that that's true, and I can share that with someone like him who's inspired me for over 30 years as a friend and a classmate. More than anything, what today represents is that we have a moral imperative to continue the discussion. There's many kinds of moral imperatives, things that we must do if we're to live true to our deepest values. But one of them is to continue engagement even when we're tired. And one thing I hear that is a legitimate statement very often is that people are just tired of talking about it. Now, there's different kinds of exhaustion. I think that the exhaustion that people feel when they've been the victims of oppression is very different than people that have not been the victims of oppression who are just tired of talking about it. But we can't give ourselves that excuse. If especially those who haven't been parts of groups that have been victims of oppression, we have to engage, we have to change, we have to create a society that does not generate machines of tragedy that so many parts of our law are today. And so we will continue this discussion. And I'm so proud of my school that we're embracing this and that Rachel, you and others have taken this on to lead us forward. Because one thing I've learned as a professor is very often our students do lead, and they lead us as well. And this is one of those times. So do we have Father Dan, Rachel? Is he? No.
Unfortunately, Father Dan had an emergency this morning.
Okay. Then I'm gonna start us out with a prayer. Lord, you gave us eyes to see and ears to hear. And too often we don't use them. We turn them off. We ignore the tragedies that surround us and the beauty that's there as well. If we're to fully see you, we have to fully see the wrong that is around us. because you also provide us with a way to fix it, to address it, to make it better. Guide us today as we have those hard discussions, as we talk about deep tragedies. Let wisdom flow, and let love prevail. Amen.
Well, thank you, Professor Osler. We truly appreciate your leadership and guidance.
Thanks.
All right, so now I have the honor of introducing our first presenter of this morning. We recognize that the protesters' demands from this summer are not occurring in isolation. They are indicative of a larger systemic issue that is national and international in scope. To that end, we wanted to start today's program with a global perspective and end with the local application of reform. Our first speaker, Fernando Travesi, is the Executive Director of the International Center for Transitional Justice, an organization that, quote, works with victims to address the root causes of conflict, massive human rights violations, and systemic crime, and thereby end cycles of violence once and for all. Fernando Travesi has over 20 years of international experience in transitional justice, human rights, and rule of law. His prior experience includes working for the United Nations, other international organizations, and NGOs. He is a specialist in international public law and holds a master's degree in conflict resolution and negotiation. This summer, he wrote about the death of George Floyd. He encouraged the United States to consider the holistic nature of reform that constitutes transitional justice. Part of that process, he said, is to, quote, acknowledge the ways in which oppression, racism, and discrimination have persisted for centuries. He will begin our program today with a presentation of the potential application of transitional justice to the United States and share the work that his organization is presently undertaking. So thank you so much for joining us, Mr. Travesi. The floor is yours.
Thank you very much. And thank you very much for the invitation. Very happy and honored to be here, part of this tough conversation, but needed conversation as well. I'm gonna try to summarize a few points in the 30 minutes that I have, and I hope they are engaging enough through the screen. And it's a pity that we cannot be together, but that's the world we are living now. Thank you very much for this invitation. As you were saying, the killings of George Floyd and Breonna Taylor at the hands of police have really set off a wave of national and international protest, demanding that the United States confront its and address legacy of slavery and racial discrimination. And it's true that compared with previous protest movements in the United States, this time it seems more attention is being paid to the historical roots of the grievances being voiced. So we do think that to understand what conditions led to the killing of George Floyd and so many others before him and since, it is very, very important to analyze the past and put current grievances in historical perspective. And to that end, transitional justice can guide the discussion to focus on root causes of violence and racial injustice and provide ideas for what steps can be taken to undo systemic abuses and redress harms linked to the legacy of slavery. To that effect, the United States could look to and learn from other countries that have undertaken efforts to address systemic human rights violations or to provide reparations and to advance reforms to stop and prevent the repetition of those violations. I think many of you know that transitional justice encompasses a variety of approaches developed precisely to address massive structural and systematic abuses. With an emphasis on truth, justice, reparations, and reform, these approaches have helped many countries emerging from periods of conflict or repression deal with large-scale or systematic human rights violations and take steps to prevent the recurrence of violence. But it's true that there is a common misconception that transitional justice can only be applied to achieve justice and redress in the aftermath of war or authoritarian regimes. However, over the past decade, the general understanding of transitional justice has evolved, and it is now seen relevant to well-established democracies and has been increasingly applied to address legacies of abuse and historical injustices in Western democracies. For instance, in Canada and Australia, or the Scandinavian countries, they have undertaken transitional justice processes to deal with past violations against indigenous peoples. As we speak in Belgium or the United Kingdom, there is also a growing recognition of the need to confront their colonial past and their role in slavery. So we could say that the United States now finds itself in such a moment of reckoning as protest and citizens demands to have a broader discussion on how to unravel the legacy of slavery and white supremacy in the United States, and to reform institutions such as the police or the criminal justice system. As Rachel was saying, the International Center for Transitional Justice is an organization that has accompanied societies and victims and activists in their quest for justice, and has advised and assisted policymakers and governments in their efforts to effectively deal with past human rights abuses and lay the foundation for a more just and inclusive future. We know that every context is unique and it requires a tailored response, but we do think that experiences from transitional justice processes from all over the world in places such as South Africa, Colombia, Tunisia, Canada, and many others, and many lessons from ongoing work in the United States could be useful and serve as an inspiration for what can be done in the United States. I'm gonna address 3 points that I think they are important from the international perspective to be applied in the United States. They are already a part of the current work on the United States, but I just want to make the relationships between the international sphere and the domestic work that is done here. One is acknowledgement and truth-seeking. The second one is reparations, and the third one is the police reform. Regarding the truth-seeking and the acknowledgement, we've heard constantly the refrain, say their names, in the protest and on social media. And this is a call to acknowledge the individual victims and to overcome the inhumanity by which their lives were taken. And this is because even well-written laws and comprehensive reforms are not enough on their own to get real change. Real change also requires a transformation in the nation's narrative. And in this case, beginning with how the United States history is taught and learned, particularly as it relates to race and how it was constructed to serve as a system that implicitly and explicitly marginalizes people of color. So central to all transitional justice efforts all over the world are the need to know the truth of the victims and to connect the dots between the violations, the suffering they have caused, and their impact and consequences through years or even generations. This would not be the time, and I really wouldn't be the right person to look in detail the history of slavery, discriminatory laws, policy, segregation that have been socially accepted, and that still exists now in the U.S. History and the U.S. present. But I just want to underline that as an essential element of any comprehensive transitional justice process, truth-seeking goes far beyond the traditional fact-finding or clarifying individual cases. If I may quote Professor Pablo de Greve, the former special rapporteur for transitional justice, truth-seeking is an undertaking to understand comprehensively the root causes, circumstances, factors, context, and motives of countrywide situations of repressions or violence. And by doing that, by publicly calling attention to previously suppressed or marginalized narratives and piecing together past incidents in a way that explains the root of current injustices, we try to, as Professor Ignatieff would say, narrow the range of permissible lies to erase the possibility of denial or limit the possibility of denial. This is crucially important, and then because truth-seeking in that sense also helps create the political will and the public support for reparations and for institutional reforms. There are more than 40 truth commissions worldwide, and there is a vast array of examples from which we could take inspiration. And depending on the context and the nature of the violations, truth-seeking processes have being very different in their forms and scope. And for instance, in Tunisia, the Truth and Dignity Commission focused on affirming human dignity in the wake of the dictatorship, repression, and marginalization of certain people and regions. In Guatemala, for instance, the Historical Clarification Commission sought to reveal the systemic nature of the massive attacks on the indigenous population. And in doing so, it dispelled the popular misconception that those whom the military killed were criminals. And therefore, the Commission's final report cleaned the name of many victims, restored the dignity of many victims, but also revealed systemic repression against indigenous Guatemalans within several state institutions, in particular the judiciary. So early truth commissions largely gathered testimonies and documentation behind closed doors and presented their conclusions in written reports. It was the South African Truth and Reconciliation Commission, the first one of its kind to emphasize the public education and incorporate that in its work. And all of its hearings were broadcast live on national radio and television station. And these hearings triggered a national conversation about the brutal realities of South Africa's apartheid regime, forcing some citizens who had looked the other way to finally acknowledge the inhumanity of the system. And as I said before, limiting the possibility of the denial. Since then, most subsequent truth commissions have held public hearings in their work. So in the United States, there are many different options that can be considered at the local, state, or national level, many ongoing. And it's important that these truth-seeking processes are devised in a flexible way. They are able to examine full range of atrocities perpetrated, and they use multiple approaches to reach a diverse audience. And there are a wealth of existing initiatives in the United States, work done by Black historians, authors, sociologists, universities, artists, musicians, filmmakers. So all these has to be brought together in a way that can amplify this national debate and conversation. And I do think that while the truth of the United States legacy of slavery and racism and its connections to present day injustices are well documented in scholarly materials, it has not been officially nor formally acknowledged by the government or adequately integrated in the country's collective narrative. Instead, it is often overlooked and in some circles is still actively denied. So in the absence of a meaningful national process, several local truth-seeking processes have been launched at the city and state level. And there are many examples in the Truth Filing Project in Ferguson, Missouri, the Greensboro Truth and Reconciliation Commission in North Carolina, the main Wabanaki State Child Welfare Truth and Reconciliation Commission. Some others are starting now in Philadelphia, Boston, and San Francisco. But whether local, national, or state level, truth-seeking initiatives must strike a balance between raising broad public awareness and providing a space for survivors and those most affected by the systemic injustice to heal. Both objectives are important, require different approaches, and in some cases might contradict each other. It's not an easy way, but a truth-seeking process can really help to issue recommendations for the way forward, to end ongoing violations and to prevent their recurrence. And of course, to ensure that the harms are repaired, which is my second point on reparations. Many of you would know that reparations is considered a fundamental right under international law. They embody a society's recognition of remorse and atonement for the harm suffered by victims of human rights violations. And there is a significant body of research and practical guidance on reparations, as well as numerous reparation programs around the world, from which stakeholders in the US can draw when deciding how to provide redress for the wrongs committed against people and communities of color in this country. It's very important, though, to recognize the inherent paradox of reparations, that it's impossible to fully repair all past harms. Reparations are most commonly understood as payments of money to victims for the harm they suffered. However, the monetary compensation is only one form of the reparations. As laid out in the UN Basic Principles and Guidelines on Reparations, there are other forms that might include restitution, rehabilitation, satisfaction, guarantees of non-repetition. They can encompass material compensation, but symbolic measures, individual, but also collective benefits, urgent and long-term programs, and comprehensive or targeted benefits. So there is a lot of possibilities to think and to take examples from all over the world where we think this approach in the United States. Considering that injustices in this country perpetrated against people of color have spanned generations and have taken many forms, a very comprehensive approach might be needed. There are other countries' experiences with administrative reparation programs that can serve as an example for the US. The scope, size, and diversity of approaches of a number of them are even on par with what should be considered in the United States. For instance, in Colombia, there was a victims' land and restitution law and reparation law that was passed in 2011, consolidating previous reparative measures into a broad state policy that provides comprehensive reparations to victims for the 50-year-long internal armed conflict with a estimated 8 million victims registers for reparation. It's a massive program, it's enormous. It includes monetary compensation, but also comprehensive psychosocial and healthcare services, housing, land restitution, debt forgiveness, and access to educational training and employment. And it also includes collective reparations to communities. So before defining specific reparative measures in the United States, or even considering those that have already been floated, it will be important to establish the general parameters of the policy, including the scope of what should and can be done, and what would be the qualifying criteria. There is immediately, when this conversation comes up, there is immediately a lot of critics saying that if the category of victims is too broad, reparations become impossible or very expensive. However, there are programs on similar scale, such as the various post-World War II reparations program. The German government, to give just one example alone, has paid out over 80 billion since 1952 in pensions and social welfare payments to some 800,000 Holocaust survivors. And then is in addition to other reparations payments that was made directly by the government. And even here in the United States, there are some interesting precedents that we can look at. In 1988, the Congress allocated 1.25 billion for individual reparations after President Ronald Reagan signed a bill providing reparations to the approximately 65,000 living Japanese Americans who had been interned during the World War II. So other programs in the United States have been much smaller in size and scope, but there are also others that have gone beyond the payment of individual reparations, going into the symbolic reparations or using different measures. Just one interesting example that happened in Chicago in 2015, when the city council passed the reparations for victims of torture, which went along with an apology from the city. There was the ordinance officially acknowledged the torture that occurred in the city during the tenure of John Graham Burge, the commander in the Chicago Police Department. And in addition to the reparations fund that the city established of $5.5 million, provided 100,000 compensation to each eligible living victim, but also the reparation package included formal apology from former Chicago mayor and some tuitions waivers to city colleges, and also a public memorial, and also that the public schools educated students about police torture under Burge, and it's part of the curriculum. So there are a lot of different possibilities that can be included beyond the financial reparations that are also needed. And as reflected in Chicago's reparation program, these symbolic measures are also important to repair past harms, in addition to financial compensation. An official apology, it's important. And it's also other measures like building the memorialization, building memorials to honor the victims, but also, which we have seen here in the United States, but all over the world, revisiting others that glorify a racist history. And then across the United States, but also, as I said, around the world, local and state governments are beginning to take such measures, removing, contextualizing, or resignifying statues or other monuments to colonialist or racist leaders, and removing their names from streets and other public property to rename them with other individuals that portray other values. So these symbolic reparations are very important. An official apology can really be a benchmark on for reparative measures and can facilitate the path for transformative reforms. Of course, to be meaningful, an apology should reflect a societal reckoning with the past and present crimes and help unite the public behind common goals for moving forward. There are many precedents in the United States and out of the United States of leaders offering meaningful apologies in Sierra Leone, in Australia, in many, many countries. For the sake of time, I will not give many examples, but it's important to underline that in these examples, we can see what an apology should be, but also what an apology should not be. Because an expression of regret as that is not sufficient. And the most effective apologies are those who consider the victim's present and future well-being. So there's been a lot of legislature that have passed some resolutions, the state houses that have passed some resolutions on this regard in Virginia, Alabama, New Jersey, Florida, many others. But the truth is that the US government has yet to apologize to African Americans for the profound harm they suffered as a result of slavery and the centuries of systemic racism and discrimination. And even if there are both the House of Representatives and the Senate have issued apologies in several resolutions, neither have ever been signed by a president. An adequate response to this moment of national protest and reckoning would require a formal public and nonpartisan public apology by the federal government that can reaffirm the founding principle, as we heard at the beginning, that yes, all people are created equal, but it materializes unequivocally in the reality of all the North Americans and all the citizens of the United States. And that we can really get the political commitment to materialize such principles and make transformational changes. And when speaking about transformational changes, I'm gonna address my last point because one sector that merits particular attention in this process is law enforcement, which has been, as it was mentioned at the beginning, a flashpoint in the discussion of race for decades, but is the focus of the current discussion. So I would speak briefly about police reform. And again, I don't think I'm the right person to review the many years and ways law enforcement and the criminal justice system have discriminated and targeted Black people, particularly young Black men. And I know it's very, very sad to repeat and to hear, but we all know that George Floyd is only one in a very long list of individuals whom police killed while under arrest, while in custody, or during police operations. Criminologists concur that race and gender remain determining factors in police violence in the United States. And recent data from the US Bureau of Justice Statistics on contact between police and the public confirms that civilians' race, age, and gender is the most significant factors associated with the police use of force against them, with Black men representing the highest proportion of victims. So unsurprisingly, the public trust on which law enforcement depends to maintain law and order has eroded in recent decades, particularly in communities of color. Many in the Black community are very skeptical that the police would implement whatever reform is adopted, or have lost hope that any reform would produce real change. This growing distrust is evident in the debates around defunding the police, with some of the more radical proposals going as far as abolishing the police altogether. So given this context, it will be challenging to bring about the fundamental changes needed to instill public trust in law enforcement. But again, looking around in the world, this is a challenge other countries have already faced. In South Africa, in Kenya, in Northern Ireland, for example, the success of similar reform efforts is measured by the capacity of the police to abandon the practice of treating population as a threat to be managed through force, and then focusing on the protection needs of the community, and eventually winning that trust across the society. And at the end of the day, for any government institutions to gain society's confidence, they must demonstrate a commitment to a process of institutional reform at the local, state, or federal levels, as well as to measures that hold individual wrongdoers in their ranks accountable. So current narratives, and this happens in many other countries of the world, current narratives in the United States, but in other countries, of police brutality must also change. Many reports on police brutality tend to explain police officers' excessive use of force as individual decisions made in a particularly stressful and difficult situation and under institutional constraints. It's the bad apples theory. And according to this theory, in using the excessive force, these officers disregard clear limitations or otherwise deviate from the official code of conduct. The concerned police officers are sometimes diagnosed as having a problematic personality, often resulting from the intense pressure and constant danger of their work. Fine. However, instances of police brutality cannot always be explained as the actions of a few bad apples, because by doing so, we overlook the role that the institutional culture can play in shaping how police officers interpret and unfolding a scenario, define the level of risk, and decide on the appropriate course of action. In the field of transitional justice, the aim of institutional reform is to establish and develop civic trust between citizens and state institutions by transforming institutions that are abusive or apply discriminatory policies and defend partisan interests into agencies that uphold and respect the rule of law, protect human rights, serve the public at large, and thereby safeguard democracy. It's true that society's mores and norms evolve over time, and practice once considered appropriate can gradually become objectionable or prohibited. Accordingly, law enforcement agencies must undergo periodic institutional changes to better reflect current social values. In many countries emerging from conflict or repression, reimagining of the police is totally necessary to distance the institution from the legacy of past abuses and ensure that moving forward, it upholds and protects human rights and serves all members of society. This is certainly not an easy process. It's neither short or easy, as institutions tend to resist adapting to sociocultural changes, but experience shows that it can be done. For example, in Italy, finally demilitarized its police force in 1981. After 4 decades of debate and controversy, the police became a civil division at the service of citizens rather than against them or against some of them. The same happened in Spain, that the armed police, the Policía Armada, was one of the most feared agencies of the Franco regime and functioned almost as a secret service, but it was transformed to embrace the new democracy, and it was demilitarized and placed under civilian oversight. In Kenya, the 2010 constitution, which was adopted after the devastating electoral violence in 2007, provided for the establishment of a national police. And also, following the collapse of the Soviet Union, countries in Central and Eastern Europe subjected their security and police forces to broad and deep lustration processes as part of their democratic transition, to make sure that the police is at the service of the public and not at the Communist Party or at the state. So in each of these contexts, the reforms sought to change law enforcement's purposes, not only its organizational structure, but also the operating procedures. Similarly, reforms in the United States should aim to redefine the mission and scope of the police. I'm going to finish saying that when structural abuse is suspected in a law enforcement agency, it might be recommended to undertake a wide-reaching, time-limited investigation of all personnel to identify officers who might be responsible for past misconduct and abuses, or who actively supported the abusive culture within the institution. This is known as vetting, and it aims to remove some individuals at all levels of the hierarchy who are not fit to perform the relevant duties in accordance with those social or ethical values with which the reform process intends to align the institution. From our experience around the world, that have pursued police reform, even the best disciplinary measures depend on a combination of improved police office training and greater cultural awareness among officers to succeed. The disciplinary measures must therefore be accompanied by tailored awareness raising and professional development programs that help officers enforce the law and avoid engaging in abusive or criminal conduct, while upholding the rights of all members of the society as the absolute and foremost imperative. I finish here by saying that experience in the United States and other countries where ICTJ works have shown that any meaningful changes to laws and policies or institutional reforms must be grounded in a recognition and understanding of the society's past atrocities and its connection to present-day injustices, grievances, and violence. Countries grappling with historical or ongoing injustice should consider applying transitional justice principles and approaches to help identify and address the root causes, acknowledge and redress the harms caused to victims, reform institutions, and prevent the repetition and future recurrence of violence. The US and other advanced democracies advocate for and support these transitional justice principles as part of their foreign and international development policies. So I think it is now the time for the United States to apply them domestically to at last recon with its legacy of slavery and racism and build a more just future for the country and all its citizens. I want to thank you all for the attention. We, as in the International Center for Transitional Justice, we are going to publish in the near future a briefing paper reflecting on these ideas and some more examples for which I have to give the credit and thank my colleagues Virginie Lattis and Ana Maria Rocatello for their work on the elaboration of such briefing paper and this presentation. I hope this has been useful. I think I'm right on the time, and thank you very much for the attention.
Thank you, Mr. Trevisi. We really appreciate you starting us off today with an international perspective on reform and how it has been effective in countries across the globe. And thank you everyone for joining the symposium today. My name is Brandon Mickelson. I am a second-year law student here at the University of St. Thomas. I'm an associate editor of the Law Journal and member of the symposium committee. I'm excited to introduce our next guest speaker, Uhuru Williams. Dr. Williams is a distinguished university chair, professor of history, and founding director of the Racial Justice Initiative at the University of St. Thomas. Dr. Williams received his PhD from Howard University in 1998. His work is focused on education, civil rights, and the Black Power movement. Dr. Williams began his career as a high school teacher. Since then, he has advocated for educational reform through curriculum and testing change. He has authored several books, including Black Politics, White Power, Civil Rights, Black Power, and Black Panthers in New Haven, Rethinking the Black Freedom Movement, and Teaching Beyond the Textbook, 6 Investigative Strategies. Dr. Williams has appeared on a variety of national radio and television programs, including CNN, C-SPAN, NPR, and Fox Business News, to name a few. He was featured in the Ken Burns PBS documentary, Jackie Robinson, and the Stanley Nelson PBS documentary, The Black Panthers. He's also one of the hosts of the History Channel's web show, Sound Smart. Dr. Williams is a frequent contributor to Progressive Magazine, and his scholarly articles have been included in numerous publications. Dr. Williams is also presently finishing a new book entitled In the Shadow of the Whipping Post, Lynching, Capital Punishment, and Jim Crow Justice in Delaware, 1865 to 1965. Dr. Williams, it is a pleasure to have you here with us today, and I'll hand it over to you.
Thanks, Brandon. I appreciate it. I am very excited to be with you today, and I'm just going to jump in and follow up on many of the points that were made in the previous presentation. The title of my talk today is The Special Favorite of the Laws, Black Lives Matter Moments in American Constitutional and Legal History, which is a little bit of a misnomer because I'm not really going to talk about moments in American constitutional and legal history, but I am going to try to establish or set a historical context by which we can think about the challenge to dealing with questions of systemic racism in law enforcement in the course of American history. And of course, because the title of this program, this entire conference is Protest and Reform, How Lawmakers in the Legal Community Are Responding to the Killing of George Floyd. Of course, we can talk about that in the context of reform, which you can see represented in the Mike Lukovich cartoon at the left. I love this. It shows a blind lady justice, and the caption reads, "She also needs a body camera." But then you have the dual problem that's presented by the cartoon by Hammond on the right. Mom, is Lady Justice really blind? And then mom responds, or maybe we're just invisible, which is really powerful when you consider in some sense that it took the killing of George Floyd captured on video cassette, or captured on cell phone camera, excuse me, to finally illuminate what activists have been saying in the United States, at least in terms of Black Lives Matter since 2012 with Trayvon Martin. The thing that's important about this in some sense leads us to engage some conventional wisdom from Thurgood Marshall, who said, in speaking about Brown versus Board of Education in 1977, I had thought, we all thought that once we got the Brown case, this thing was going to be over. You see, we were always looking for the one case to end it all. And the reason I think that's important conventional wisdom for us in this moment is that we should have no expectation that George Floyd is the case that is going to end it all. It may spark the conversation, which should lead us to interrogating ways that we can ensure the type of transitional justice that Ferdinand just talked about, so that we can ultimately be in a position to say never again for anyone. But that's not going to come without deep and persistent struggle. This is going to be a difficult process, and we have to be prepared for that process. When we consider where we are with regard to education today, for example, it's important to remember that in that euphoria that occasioned the Brown decision, you had Little Rock, and then later on you had Ruby Bridges, and then later on you had James Meredith at Ole Miss, even though we're talking about higher education there. Sheff versus O'Neill case in Connecticut, and today, Minnesota that lags behind the rest of the nation, 50th in terms of educational outcomes for African-American students, for students of color. This is a long struggle, and one that requires us to think longitudinally and not in terms of what we can do in terms of the immediate moment. Having said that, I also want to offer some wisdom from James Baldwin, who said the world changes according to the way people see it. And if you can alter even by a millimeter the way that people look at reality, then you can change it. For many Americans who do not experience the wound, the trauma associated with the presence and persistence of systemic racism in the United States, the murder of George Floyd caught on cell phone camera was just such a moment. For many of us, however, it was just a reminder of this deep wound that continues in many ways to remind us of this two-tiered system of justice that is indicative of a much larger problem that goes beyond just what happens in terms of violent encounters between Black men and police, but that really impacts all segments and all sectors of American society and culture. And so I want to begin today by saying that when we talk about this in the context of history, one way that we can do this is by looking at American history specifically. So we looked at the global, but if we kind of narrow our gaze to American history, there's some interesting moments that we can point to that illuminate the persistence of the problem and perhaps will shed a light for us on what we should be thinking about in our contemporary moment so that we can learn from the past. Much of my work with the Historical Racial Justice Initiative is around the work of historical recovery. And That's not just about familiarizing ourselves with the past, but hopefully finding an avenue to re-examine and reimagine past efforts at reform, why they failed and what we can do to bend them toward working in this moment to ensure the type of the equal justice that we've been talking about, that activists have been talking about since the murder of George Floyd, but for many, even beyond the murder of George Floyd. Last but not least, I conclude that a fundamental shift needs to occur in the way we're thinking and talking about law and policy that bottoms on the need to embrace the necessity of a sustained legal intervention to achieve equality. And I'll talk more about what I mean by that in just a second. By the way, the cartoon on the right is from 1965. It shows an Alabama state trooper who's just beat up a protester who was participating in the famous Selma March. And again, this is just to make the point that we're talking about a long history here, and we need to connect that history. Having said that, when we think about historical recovery, it's important then to understand this through the lens of not just what's happening in our contemporary moment, but to be able to look back and to make connections that will allow us to see the ways in which this problem has persisted and what has really fueled it, what has added fuel to the fire, what has created pathways for this pathogen to continue to infect the American Republic. And in order to do that, I'd like to begin with you today, and many of you probably rightly already noticed this, with the Supreme Court's decision in the civil rights cases of 1883. You probably recognize the title of my talk coming from the majority opinion, which is issued by Justice Bradley, in which he writes for the majority, when a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state, there must be some stage in the progress of his elevation when he takes the rank of mere citizen and ceases to be the special favorite of the laws. And when his rights as a citizen or a man are to be protected in the ordinary modes by which other men's rights are protected. It's interesting just to talk about that, to think about that in this context, because he's writing this opinion in 1883, 20 years after Lincoln issues the Emancipation Proclamation, 18 years after the passage of the 13th Amendment to the Constitution, which abolishes slavery, 17 years after the passage of the 14th Amendment, and in very close proximity thereof to the 15th Amendment passed in 1870. So we're not talking about a great deal of time that's passed, and yet here is Justice Bradley saying, you know, there has to be a time when African Americans, Blacks, the formerly enslaved, cease to be the special favor of the laws. That, if that strikes us as odd today, knowing what we know about the history of that period, it also struck the only Southerner on the court, Kentuckian John Marshall Harlan, the great dissenter, as odd. And in his response to his colleagues, Harlan wrote in dissent, "My brethren say that when a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state, that there must be some point in his elevation where he's to be protected in the ordinary modes by which other men's rights are protected." But Harlan continues, "It is, I submit, scarcely just to say that the colored race has been the special favorite of the laws. The statute of 1875, now adjudged to be unconstitutional, is for the benefit of citizens of every race and every color. What the nation through Congress has sought to accomplish in reference to that race is what had already been done in every state of the Union for the white race, to secure and protect rights belonging to them as freemen and citizens, nothing more." Now, what's particularly powerful about Harlan's dissent and construction here is this idea that we perhaps should be thinking about in this context, that we talk about the civil rights cases of 1883, the Supreme Court's declaration or determination of the Civil Rights Act of 1875 as kind of the last of the death knell or death throes of Reconstruction in the South, the first Reconstruction. By declaring the Civil Rights Act of 1875 unconstitutional, the Supreme Court in essence stripped the only federal law that undercut racial discrimination by individuals and by private businesses, which left African Americans who were victims of private discrimination to seek legal recourse in unsympathetic courts, state courts. Racial discrimination in housing, education, and places of public accommodation, in the absence of equal justice, remained the norm, at that point then enforced by law. And so in some sense, and we need to talk about this, and scholars talk about this in great detail, but we must remind ourselves at various points why this is significant. The law or the evolution of law and criminal justice in this country grew up alongside of emancipation And when we think about, for example, commissioners of public safety, their jobs weren't only to enforce the law, but to enforce separate but equal after 1896, which really has its origins, as C. Van Woodard and others have observed, in this period where there's some fluidity in race relations, but it's hardening around the stripping of these rights by the United States Supreme Court. I want to be clear here that it would take more than 80 years for the federal government to again attempt to outlaw discrimination, and that won't come until the Civil Rights Act of 1964 and the Voting Rights Act of 1965, what we commonly call the Second Reconstruction. And what I want to suggest to you today is that George Floyd's murder may be the start of the dialogue around the need for a third Reconstruction, a dialogue which actually began way back in 2012 and 2013, first with the murder of Trayvon Martin, and then second with the Supreme Court's decision in Shelby County versus Holder, which many have called Roberts' Crow, the enactment of the new Jim Crow, then in the form of Justice Roberts' majority opinion in that court. We can see Trayvon Martin in some sense is tied to conversations about Emmett Till, which connect the first and second Reconstruction, but more substantively, this is also a moment where we have the emergence of a national Black Lives Matter movement, which comes both in response to the murder of Trayvon Martin and the killing of Black and brown people in public spaces, represented by this very haunting cartoon from 2015 here, and by the Supreme Court's decision in Shelby County versus Holder, and they work in concert. We can see here, for example, that we weren't simply talking about the murder of Black and brown people, but we were also talking about police practices and policies which perpetuated inequality in those spaces as well. And the reason that's significant is that when we think about Shelby County versus Holder, and I love this cartoon, the Supreme Court done washed away my racism. At the core, the response of Congressman John Lewis was critical and should be critical in helping us understand why that was such an important decision and why that should help frame our conversation about George Floyd, a third Reconstruction, and looking forward. What Congressman John Lewis said in the aftermath of Shelby County versus Holder, which ties to Fernando's presentation, brilliant presentation on transitional justice, is this: I was disappointed because what I think the court did today is stab the Voting Rights Act of 1965 right in its very heart. It's a major setback. We may not have people being beaten today. Maybe they're not being denied the right to participate, to register to vote. They're not being chased by police or trampled by dogs. But in the 11 states of the old Confederacy, and even in some states outside the South, there's been a systemic, deliberate attempt to take us back to another period. Lewis continues. My message to the members of the United States Supreme Court is, remember, don't forget our recent history. Walk in our shoes, come and walk in our shoes, come and walk in the shoes of those 3 young men that died in Mississippi while registering in 1964. Walk in the shoes of those who walked across the bridge on Bloody Sunday. I didn't think that one day when President Johnson signed the Voting Rights Act that I'd live to see 5 members of the Supreme Court undo what President Johnson did with those pens. So it was a powerful response by Lewis to Shelby County versus Holder, but I like to have these 2 images of John Lewis here because he paid in blood, in some sense, at the hands of Southern law enforcement officers for agitating for the right for African Americans to be able to register and ultimately to exercise their constitutional right to vote in the South. If there's any problem with this argument today is that when Lewis focuses on those 11 states of the old Confederacy, but then acknowledges that it goes beyond that, that would let Ohio and Pennsylvania and Minnesota and Connecticut off the hook. And the reality is that racism and systemic racism is a national problem, which we know Congressman Lewis understood, but it's important to reiterate that in many of those communities, policing has been used to enforce the same type of de facto discrimination that the civil rights movement was mobilized to prevent. I think that's important because if we go back and we look at this in the context of John Marshall Harlan's dissent, and we think about the language that Justice Bradley used. In 1883, there is in no way is it possible to talk about Blacks being the special or favored of the laws. Special meaning better, greater, or otherwise different from what is usual, which was not the case. Certainly not favorite, preferred before others of the same kind, which was certainly not the case. And then finally, as Justice Harlan pointed out, not only was that not scarcely just, it would have been more appropriate to talk about African Americans in that moment as uniquely degraded and those legal interventions, the 13th, 14th, 15th Amendment, the Civil Rights Act of 1966, of 1866, the Civil Rights Act of 1875, the Ku Klux Klan Act of 1871, the Enforcement Acts of 1870 and 1871, were all passed to ensure that same modicum of or effort at ensuring for African Americans the equal protection of the laws, which was more often than not denied, mostly denied. In fact, it would be more appropriate to talk about not the special favorite of the laws, but the uniquely degraded by the laws as an accurate measure of what was happening in that moment and what continues in many sectors today. And I'll give some concrete examples of that in just a second. I say that to you because if we think about the timeline of someone like Congressman John Lewis, he's born in 1940 into a world in which segregation is the norm, where segregation laws and white and colored signs predominate in the nation. By 1965, you have the passage of the Voting Rights Act of 1965, a Civil Rights Act the year before. And yet by 2020, Congressman John Lewis dies in a world in which, when he talked about in 2013, a systemic attempt to roll us back, we're in the midst of a national Black Lives Matter movement. We are at that point that he died in July, only a few months removed from the murder of George Floyd, with massive protests taking place across the United States, and with people having to have as their mantra the slogan Black Lives Matter, to say something that one could have assumed that the second Reconstruction would have been sufficient to achieve. And I say that to you because if we look at it in that way, and we kind of interrogate what Harlan meant to challenge what his brother were saying, African Americans were not the special favorite of the laws. In fact, as I noted, they were uniquely degraded, and we can see that in various forms. If we look at this historically, look at the position of chattel slavery, law created to ensure the bondage of human beings in the United States of a particular color, a particular race. So by definition, uniquely degraded. The failure of Reconstruction, I mentioned no less than 11 major pieces of legislation, 3 constitutional amendments, and yet by 1877 with the Hayes-Tilden Compromise, special favorite is uniquely degraded. The advent of Jim Crow, not just with Plessy versus Ferguson, but with Gallagher versus King, and a host of other cases that we could talk about. Even with those cases like Berea College versus Kentucky or Gwynn versus the United States, which outlawed the grandfather clause, the totality of this period was to leave African Americans in a position whereby they were second-class citizens. We have to interrogate that, not the special favorite. And then last but not least, in this period where we have witnessed the maintenance and persistence of systemic structural anti-Black racism, a continuation of those same themes. Now, I think that's important because later today, there's a panel or a keynote on Kentucky. I'll talk about that in a few minutes as well. But Breonna Taylor cases from Kentucky, I want to talk about the special place that law has in us and just give you a couple of snippets. So let's talk about chattel slavery. Although we talk about slavery as primarily an economic system, the legal validation by courts and political institutions was essential to its maintenance and survival. And when we think about the mental gymnastics that lawmakers and judges and jurists had to go through in order to justify that system, it's mind-boggling, but in some sense, it helps to explain the mantra of Black Lives Matter even today. Why do you say that? In the case of Turner versus Johnson, 1838, Kentucky court, for example, was forced to concede what it called the dual character of slaves. Slaves, the court wrote, are property and must under our present institutions be treated as such. But they're also human beings with passions, sympathies, and affections with ourselves. Now, at that point, the paradox, the weight of that paradox you would have assumed would have overwhelmed the justices, particularly given the rhetoric that we associate with the founding of the United States and our founding documents like the Declaration of Independence and the preamble to the Constitution. But the reality is, in order to rationalize and maintain chattel slavery, lawmakers ended up constructing a law or constructing a series of law that borrowed heavily from areas such as the keeping of animals and employees and servants and free persons that ultimately contributed to what we call the peculiar institution. The legal construction of race aside, the fact of the matter is that the condition of the enslaved was worked out in a framework of creating a peculiar set of laws to deal with the paradox that should have been evident and yet wasn't, because the intense desire to maintain white supremacy and perpetuate slavery was the overwhelming compulsion of those in power. I share that with you because then when we think about a move to the period after the Civil War, those efforts that I mentioned to ensure absolute equality before the law, 13th Amendment, the 14th Amendment, ultimately the 15th Amendment, prove insufficient to meet that challenge, not only because of the hostility of the United States Supreme Court, but because of state governments after the close of Reconstruction that are left to their own devices and then really allow the perpetuation of unequal treatment in a host of a variety of areas. Again, I'll talk about those in just a second. It's a very disturbing political cartoon from 1863, but I think it captures the essence or the crux of the problem. The cartoonist poses or pictures 4.5 million formerly enslaved people as this giant behemoth that's being ridden by an officer from the Union Army. And the caption reads, "The man who won the elephant at the raffle." But the question is, what am I to do with the creature? If I were to interpret this cartoon for you, I would say that ultimately what the cartoonist was asking was this: congratulations, Mr. Lincoln and Republican Party. You just emancipated or half emancipated 4.5 million people who were once enslaved. Now what? What's their social status going to be in the Republic? What's their political status going to be? What's their economic status going to be? And oh, by the way, if you're not prepared to answer those questions in a way that's affirmative of their human dignity and their citizenship, you will have introduced into the Republic a source of chaos that will not easily be resolved. In fact, we know that to be true because this is 1863, fast forward to 1963, and we've got Martin Luther King at the March on Washington making an appeal for the same dignity of the human person and for citizenship for African Americans, not second-class citizenship, but first citizenship. And he's joined on that day, of course, by Congressman John Lewis. So the cartoonist captures the essence, the crux of the problem, the paradox, whatever you want to call it, very well, very aptly. And the response to that, and the response to the efforts to ensure absolute equality before the law might aptly be described as what Al Sharpton called the knee. And I'm going to play Al Sharpton, or at least a few seconds of Al Sharpton's eulogy for George Floyd here in Minneapolis in just a minute. But if we think about the knee or the tied hands in American history, what do they represent in this period after the Civil War? The Black codes are the knee. Poll tax, literacy tests, grandfather clause, sharecropping, the crop lien system, debt peonage, convict leasing, segregation laws. These are things that by definition restricted opportunities for African Americans to enjoy the full fruits of freedom and absolute equality before the law. And when we look at it in that context, then this mocks Justice Bradley's notion that at some point the ordinary modes by which other men's rights are protected would be sufficient to protect the rights of African Americans because of the law and culture, which at that point had deeply informed the way that Black people were seen and treated in the United States. A couple of really great cartoons from the 1930s here. One that shows, one that deals with mob rule and lynching, the other that talks about Hitler's terror here, and they both depict Mississippi. Again, part of our challenge is not to view this as a Southern phenomena, but an American phenomena, a national problem, as Gunnar Myrdal called it in An American Dilemma. Having said that, I like to talk about these in the context of what I like to call the 6 degrees of segregation. What are those barriers that deny equality to African Americans that we see emerge after the Civil War? Well, those barriers are in housing, and we see that in the Black codes. We can see that in restrictive covenants in the 1920s. Of course, we all know and teach about and litigate cases that deal with efforts to restrict access to housing for communities of color even today. We see that in terms of education. We see that in terms of access to places of public accommodation. We see it in terms of voting rights, which I just shared by virtue of talking about Shelby County versus Holder. We certainly see it in unfair labor practices, and we see it in the most intractable of those 6 degrees of segregation, Jim Crow justice, which would encompass a wide variety of issues, from felony disfranchisement to the school and prison pipeline, to the stop and frisk and the policing of Black and brown bodies in public space, to the murder of African Americans at the hands of law enforcement, and the failure to prosecute the same. And if we look at that in a much larger context, then all of a sudden, what Al Sharpton shares on June 4th, 2020, perhaps we can see in a slightly different light. Going back to James Baldwin, the world changes according to the way we see it. Going back to John Marshall Harlan, African Americans have scarcely been the special favorite of the laws. I'm going to play 2 minutes of this and I'll pick up on the other side.
George Floyd's story has been the story of Black folks, because ever since 401 years ago, the reason we could never be who we wanted and dreamed to be in is you kept your knee on our neck. We were smarter than the underfunded schools you put us in, but you had your knee on our neck. We could run corporations and not hustle in the street, but you had your knee on our neck. We had creative skills. We could do whatever anybody else could do, but we couldn't get your knee off our neck. What happened to Floyd happens every day in this country, in education, in health services, and in every area of American life. It's time for us to stand up in George's name and say, get your knee off our necks. But I'm more hopeful today than ever. Why? Well, let me go back. Reverend Jackson always taught me, stay on your text. Go back to my text, Ecclesiastes. There is a time and a season. And when I looked this time and saw marches where in some cases young whites outnumbered the blacks marching, I know that it's a different time and a different season. When I looked and saw people in Germany marching for George Floyd, it's a different time and a different season. When they went in front of the parliament in London, England, and said it's a different time and a different season, I come to tell you, America, this is the time of dealing with accountability in the criminal justice system. George.
So it's a powerful speech by Reverend Sharpton, but what I don't want us to do, and I know for some people, Reverend Sharpton can be a polarizing figure, but if you focus on what he says and you look at this in the context, Al Sharpton is in conversation with people like Frederick Douglass and Martin Luther King and Mary Church Terrell and Ida B. Wells and other African-American leaders in the past who've also raised the issue of what the knee or the tied hands or what those obstructions look like. And this is critical to our conversation about dismantling, because we can't really get a sense of what the animal is until we can wrap our arms around it and understand it from the intimate perspective of those who've dealt with it over time. Let's just take this notion and apply it to the Reverend Dr. Martin Luther King on the eve of the Montgomery bus boycott and what he shares to those who were in attendance at the church that evening about what is compelling them to move forward with the protest at that point in support of Rosa Parks, although it could have been many other people. But what King says on that evening in question is this: we're here in a specific sense because of the bus situation in Montgomery. We're here because we're determined to get the situation corrected. But note what King says next. This situation is not at all new. The problem has existed over endless years. For many years now, Negroes in Montgomery and so many other areas have been inflicted with the paralysis of a crippling fear on buses in our community. On so many occasions, Negroes have been intimidated and humiliated and oppressed because of the sheer fact they were Negroes. And I'll hold you there for a second. I want to share with you that King doesn't say it, but he doesn't have to say it, that we would assume that it's not just the segregation laws or the badge of inferiority that comes with being asked to remove yourself to the colored section of the bus or the back section of the bus. It's the fact that law enforcement exists in those spaces to enforce that, and often does so with great brutality. That's what explains the paralysis of the crippling fear that King is talking about here. Listen to what he says, because I think this is important for young people in particular. King says, I don't have time this evening to go into the history of these numerous cases, but I would suggest to you that just like today, as we can tick off names like Tamir Rice and Breonna Taylor and Sandra Bland and Raynette Turner, in that moment, King could easily have talked about people like Claudette Colvin and Rosa Parks and countless others who had encountered just the same treatment on buses, not just in Montgomery, but throughout the South, throughout the nation. Watch where he goes here. Many of them, those cases are now lost in the thick fog of oblivion, but at least one stands before us now with glaring dimensions. In 1955, that was Rosa Parks. In 2020, that's George Floyd. And what should be very compelling to us in listening to King and being able to connect King and John Marshall Harlan and Al Sharpton in this way is this idea that when we consider it in that context and we understand policing in that context, we can then kind of unpack this from some of the rhetoric we hear, kind of focus squarely on the problem. Police have always been used to enforce bad law and bad policy, which segregation is and was. Brutality has historically been treated as secondary or as a result of the offense. It's a very famous image of the Reverend Dr. King being shoved up against a desk in a police station, treated brutally at this point, not for having committed a crime, but for protesting. So the brutality becomes incidental or just becomes part of the job, the way that the job is done, right? Not bad apples, but baked into the proposition because of what the law was constructed to do, which, as I mentioned earlier, if we think about this in the context of people like Eugene Bull Connor, Commissioner of Public Safety, if we think about this in the context of the slaughterhouse cases and the idea that the states fell within the logical exercise of the police powers of the state to deal with public health crises in their own border, and segregation was seen as part and parcel of that ordered, there you go. Last not least, the punishments have been unequally applied or disproportionate to the crimes over time, and that helps to frame this discussion. In that sense, when we see comparisons like this, which makes some people uneasy, rightfully, because I think it's not fair to say that murder of Black and brown people by police today is like modern day lynchings, but they're echoes, they rhyme, and we want to be able to talk about this. In this particular cartoon, the subject was Mumia Abu Jamal, who many people don't know, and I don't have time to talk about today. But what I love about what the cartoonist has done is he says, look, the history of American lynching, whether the instrument of injustice is the noose and is done by men who come in white hoods and robes, because in 1870, they feared the retribution and intervention of the federal government. Of course, the Supreme Court helped to eradicate that in a series of decisions, US versus Reese and US versus Cruikshank and US versus Harris, or whether that injustice comes in our present contemporary moment by individuals that wear Black robes and who accomplished that through the instruments of injustice that we associate with our modern criminal justice system. The end result is the same, injustice. Our focus has to be on how do we root out the injustice? How do we talk about ensuring that we're dismantling those elements of the system that perpetuate the injustice? I want to give you a good example of this, at least from a historical standpoint, in talking about this notion of the special favor of the laws by talking about Elizabeth Jennings. Many of you know Rosa Parks, but I want to give you an example from 1854, and that's the case of Elizabeth Jennings. I love her case because we actually have her deposition. In 1854 in New York City, Elizabeth Jennings ended up having to sue the city because she was forcibly removed from a segregated trolley car in New York City. I want to read her deposition to you. Sarah E. Adams and myself walked to the corner of Pearl and Chapman Streets to take the 3rd Avenue cars. I held up my hand to the driver and he stopped the cars and we got on the platform when the conductor told us to wait for the next car. I told him as I could not wait as I was in a hurry to go to church. He then told me the other car had my people in it and that it was appropriated for that purpose. I then told him I had no people. It was no particular occasion. I wished to go to church as I'd been going for the last 6 months and I did not wish to be detained. If I had more time with you, I'd unpack this whole thing, but I want to point out 3 things very quickly. Number one, what you had in New York City, 1854, is de facto segregation, not by law, but by custom. It was customary for the conductor to have to ask the passengers, could a Black person ride in the car? This is a segregationist impulse without the law. Number 2, ordinary people don't wake up in the morning and decide they're going to make history. Ordinary people go about their lives and sometimes are placed in positions whereby they simply have to stand and fight. And that's what we have with Elizabeth Jennings here. And I love that. And number 3, it is the trauma and the horror that comes with the ordinary experience of being Black in America, which Elizabeth Jennings captures for us, not in 2020 in the case of Ahmaud Arbery or Breonna Taylor or George Floyd, but in the case of a person who lived more than a century ago, that illuminates the crux of the problem. Listen to the next part of this. He insisted upon my getting off the car, but I did not get off the car. He said I should come out or he would put me out. I told him not to lay his hands on me. He then took hold of me and I took hold of the window sash. He then ordered the driver to fasten his horses, which he did, and come and help him put me out of the car. They then both seized hold of me by my arms and pulled and dragged me flat down on the bottom of the platform so that my feet hung one way and my head near the other nearly on the ground. I screamed murder with all my voice and my companion screamed out, "You'll kill her, don't kill her." I want to stop there and just mention that, remember, this is all because she wants to go to church on a Sunday morning on a trolley car. And because the driver doesn't observe custom, this is the situation that results. Sometimes it's easier for us to glimpse these things in a historical context than in our contemporary context because we don't bring the baggage associated with it. And we can kind of divorce it from our contemporary desire, or some people's contemporary desire, to talk about the criminality that they perceive in a situation as opposed to the facts of that situation. Follow the next part of this. The driver then let go of me and went to his horses. I went again in the car. And the conductor said, "You shall sweat for this." Then he told the driver to drive as fast as he could and not take another passenger in the car. Drive until he saw an officer or a station house. They got an officer on the corner of Walker and Bowery whom the conductor told, listen carefully, that his orders from the agent were to admit colored persons if the passengers did not object, but if they did, not to let them ride. When the officer took me, there were some 8 or 10 persons in the car. Then the officer, without listening to anything I had to say, thrust me out and then pushed me and tauntingly told me to get redress if I could. Elizabeth Jennings sued in 1854 and she won. I want to say that again. Elizabeth Jennings sued in 1854 and she won. What would have been an anomaly in 1854 should have become the law of the land by virtue of the Civil War and Reconstruction and the passage of that legislation and those amendments I mentioned. And yet by 1877, Elizabeth Jennings' victory is rendered nugatory, not only by the hostility of the United States Supreme Court and unsympathetic state courts, but by state lawmakers and terrorist organizations that operate within the United States that are part of this deliberate attempt to roll back. I want to be clear here, and I felt it was important to share that document with you because we can find this strain running throughout African-American history in the most unexpected of places. Frances Ellen Watkins Harper, I know back in August we celebrated the passage of the 19th Amendment, commemorating that. Frances Ellen Watkins Harper, in talking about trying to win the right to vote for women, Black women and white women, famously in a speech said, "You white women speak of rights, I speak of wrongs. I, as a colored woman, have in this country an education which has made me feel as if I were in a situation of Ishmael, my hand against every man and every man's hand against me." Listen to where she goes. "Let me go tomorrow morning and take my seat in one of your cars. I do not know what they will do in New York, but they will in Philadelphia, and the conductor will put up his hand and stop the car rather than let me ride." George Floyd's story, Al Sharpton said, has been the story of Black folks in America. If we are willing to do the work and to understand it and to tell it and to weave it through history, we can see that that has been true, even in the moment, this is 1866, where we would have assumed that there should have been the greatest opportunity. And Frances Ellen Watkins Harper and Elizabeth Jennings are not an anomaly. We could talk about the case of Mary Miles in the Philadelphia and Westchester. It's no surprise that Frances Ellen Watkins Harper points to Philadelphia because the following year in 1867, we have the case of Mary Miles versus the Philadelphia and Westchester Railroad Company. So these are important moments. I also want to be clear that as we talk about fatigue, as my colleague Dr. Osler said in the beginning, we can't in this moment become fatigued about this dialogue. It is too important. We can't allow ourselves to become distracted. We have to understand the ways in which historically that fatigue has undermined these movements and how historically division has done that. Elizabeth Cady Stanton and Susan B. Anthony, rather than dealing with those who had denied them the right to vote, turned their attention not to the white men, their husbands, fathers, brothers, and sons who crafted the language of the 15th Amendment, but to African Americans and to follow what Stanton says in 1869. American women of wealth, education, virtue, and refinement, if you do not wish the lower orders of Chinese, Africans, Germans, and Irish with their low ideas of womanhood to make laws for you and your daughters, to be your rulers, judges, jurors, to dictate not only your civil but moral codes, by which will be governed, awake to the danger of her present position and demand that women too shall be represented in the government. But she cut out Black women, Irish women, Chinese women. I want to be clear because Frances Ellen Watkins Harper speaks to that too. In that first part of her passage, she says, I do not believe that giving the woman the ballot is immediately going to cure all the ills of life. She is now in conversation with Thurgood Marshall about the importance of understanding the longitudinal nature of struggle. And she continues, I do not believe that white women are dewdrops just exhaled from the skies. I think that like men, they may be divided into three classes. And what she says here applies to us all, the good, the bad, and the indifferent. The good would vote according to their convictions and principles. The bad is dictated by their prejudice or malice. And the indifferent will vote on the strongest side of the question with the winning party. What's powerful about that for us, as I mentioned, is that being indifferent or being bad is really what has perpetuated this. This is the history that Dr. King knew but didn't have time to share that evening. These are representations of it in political cartoons from that period, one from Philadelphia from 1867, a handbill from Memphis, Tennessee from 1868, a cartoon from Washington, DC from 1868, all showing African Americans being insulted and unsafe from harassment in places of public accommodation, right? With the law to back them up in that. And we're not talking about 1896. We're not at Plessy versus Ferguson yet. I want to be clear that then if we understand this in context, then we can talk about the wound, the knee, the untied hands, whatever metaphor that you want to use in the context of these 6 degrees of segregation and how it encourages not just the de jure aspects of this, so residential segregation laws, but the responses of people who begin to believe that any effort by African Americans to assert equality by definition becomes a denial of their liberty and freedom and equality. And what's critical about this and a larger conversation about truth and reconciliation is that, as Fernando mentioned earlier, in interrogating what we mean by that, this past weekend I was on a panel in Delaware. I obviously am writing a book on Delaware, and I was sharing the case of a lynching that took place in 1861 that actually took place as a result of an attempted break-in at a home of a very prominent family. I don't have time to share that with you. What I do have time to share with you is an editorial that was published in the Delaware Journal and Statesman by what I assume to be its editor, Henry Eckel, in response to this argument that the good people of Smyrna, Delaware, needed to lynch this man, even though the evidence against the person that they lynched, this Black man they lynched, was wanting. But what Eckel does is he moves away from talking about the direct violence, and like Al Sharpton, like Martin Luther King, like Ida B. Wells, like Mary Church Terrell, like so many, like Thurgood Marshall, like Charles Hamilton Houston, like so many of the people that we talk about and so, like Roy Wilkins from here in Minnesota, was able to see the way in which the intersections there between criminal justice and other areas are really, and this is 1861, let me share this with you. He wrote, the wholesale persecution of Blacks in the state is disgusting and lamentable. It's inhuman and unlawful. In some towns, there's a curfew bell and no Black must be upon the street for any purpose after it tolls, on pain of, listen, imprisonment and 12 lashes. It is so at Dover and Milford and Locofos and other towns who would not let such an excellent precedent go unfollowed. Does a Negro pay a place pass a place where a political meeting is being held? Be his intent charitable or necessary for medicine or a physician? Does he possess a rusty gun barrel? Off he goes to prison, fined $20 and imprisoned till paid. Does he worship his maker after a certain hour? Down upon him pounces the fee-greedy officer. It's almost as if Eckel in 1861 is describing Ferguson after Michael Brown, after the Ferguson report in 2017. Does he come before a jury, whatever be the evidence, there is no sympathy, no mercy, no acquittal? Does a white man refuse to kick and cuff and to beat? I mean, really, he's laying this out and saying the lynching is just the tip of the iceberg. The violence is just the tip of the iceberg. And in what ways does law reinforce that inequality in other meaningful ways? I share this with you because many people ask, how did you end up writing a book on Delaware? I wrote a book on Delaware because I went to Delaware State University as my first university job. And in 2001, a Black man by the name of Reginald Hanna was killed in police custody less than a mile from my home. I ran that path every day. It was by the Delaware State Archives, and everybody in that community was destabilized by the death of Reginald Hanna. Many people suggested that it had occurred under suspicious circumstances. I remember waking up that Wednesday and reading an editorial in Delaware State News, which declared, quote, "In America, it should be like when I was a little girl. Kill them. Take them out and hang them on trees or the whipping post. Why don't they still do that?" If we don't get it right in this moment, as we haven't gotten it right in the past with regard to moments like this, as Fernando talked about, what we're helping to perpetuate is this. I was shocked by this in 2001. And what I was even more surprised by is that no one wrote in to respond to her. No one wrote in, that the newspaper didn't take a position and say, in 2001, which is not that long ago, 19 years ago, this was still the norm. And people talked about it. And it's what compelled me to want to write that book. It's what compelled me to want to talk about what for some people is a matter of Delaware exceptionalism. You may or may not know that Delaware maintained the whipping post until 1952, and the last state to abolish whipping, and the pillory until 1911. You may not know that in every couple years, Delaware would bring up the whipping as a potential crime. And the last time was 1989, where a state legislator proposed whipping for drug dealers. But think about the racialized nature of that, right? Because always, and I could go into the history of this if I had more time, but I don't. The reality is that the governors of Delaware would routinely suspend the punishment of the whipping portion of punishment for white offenders, so that the only people who were ever whipped or pilloried were African Americans. This cartoon, in some sense, from the New York Times is misleading. These images are far more accurate in terms of who was punished and how they were punished, and who did the punishing and who did the witnessing in Delaware. But it's not Delaware exceptionalism, because we can look at the platform of the Niagara movement from 1905. What do those women and men ask for? I want to run through these very quickly. Number one, they demand courts. We demand upright judges in courts, juries selected without discrimination on account of color. So remember that Boston, Kentucky panel later today. Don't miss that. That's going to be great. And the same measure of punishment and the same efforts at reformation for Black as well as for white offenders. We need orphanages and farm schools for dependent children, juvenile reformatories for delinquents, and the abolition of the dehumanizing convict lease system. Again, I could almost see this through the lens of contemporary conversations about defund, where if you don't get hung up on the language of defund the police and you think about where people are talking about reallocating resources to mental health, drug interdiction programs, and other things, they're actually in conversation 1905 and 2020. Public opinion, read this to you very quickly. We note with alarm the evident retrogression going back in this land of sound public opinion on the subject of manhood rights, Republican government, and human brotherhood. We pray God that this nation will not degenerate into a mob of boasters and oppressors, but rather will return to the faith of the fathers, that all men were created free and equal with their certain unalienable rights. Now, which gendered problematically so, this is 1905, but I want to be clear and get at the larger principle here for us, this idea that even in 1905, they hadn't lost faith in America's ability to deliver, but they recognized the need for reform, substantive reform, which brings us to the last one, as we're talking about this in the midst of COVID-19 and this dual pandemic of racism and the epidemic of violence against Black and brown bodies, and how COVID-19 has disproportionately impacted communities of color. And what do they plead for? Health. But they don't just talk about health in terms of disease. They say to live in decent houses and localities, they're looking at it broadly. I share all of these with you to bring this back to, in my last 4 minutes, this idea of police brutality. And I want to end with you by talking about James Baldwin, who in 1965 talked about the problem of police brutality in a way that I think maps beautifully to this cartoon from Daryl Cagle from 2014 after Michael Brown was killed. And what Baldwin wrote was this: similarly, the only way to police a ghetto is to be oppressive. None of Commissioner Kennedy's policemen, even with the best will in the world, have any way, listen to the word, of understanding the lives led by the people they swagger about in twos and threes. Listen to the word, controlling. My good friend Leslie Redmond had the opportunity to present with her a couple of weeks ago at the Minneapolis YWCA, and she showed me a video of a police officer encountering a person of color. And I'm not gonna, she might be talking about this in her address, so I'm not gonna share it. But if she does share that today, through the lens of this, it's powerful. He continues, their very presence is an insult, and it would be even if they spent their entire day feeding gumdrops to children. It's interesting that Baldwin frames it that way in 1965, and look at what Cagle does in the cartoon. Because you can't feed gumdrops and talk about community policing and say, have all these platitudes about doing better when you're decked out with the surplus gear from the failed war in Iraq and Iran, and the police look like an occupying army, as the Black Panther Party was famous for saying, rather than those who are there to serve and protect, and they're not representative or reflective of the communities they serve. That is part and parcel of the problem as well. And when you arrive at that conclusion, then you have nowhere to go but where Baldwin goes. They, the police, represent the force of the white world, and that world's real intentions are simply for that world's criminal profit and ease. Keep the Black man corralled up here in his place. The badge, the gun in the holster, and the swinging club make vivid what should happen should his rebellion become overt. Rare indeed is the Harlem citizen, from the most circumspect church member to the most shiftless adolescent, who does not have a long tale to tell of police incompetence, injustice, or brutality. But I want to be clear, because Baldwin is, that is not simply about just what happens with the police. That incompetence, injustice, or brutality is often connected to one of those other 6 degrees of segregation that bring the police to the community in the first place. Look, I am out of time, so I want to say to you that we could think about Harlan's dissent as a form of aspirational justice to get us through this recurring American nightmare. That if we understand and appreciate the language that it's scarcely just, that there's never been the special favored laws, that maybe we need to think about in this moment creating laws that will equal the playing field, but then also being of a mindset that this isn't a 20 or 30-year proposition, but this is something that's going to require a much deeper commitment. I say that because, as I mentioned Harlan earlier, and I want to go back to Delaware, if we don't, then just as after the Civil War in Delaware, the governor of Delaware in 1865 pleaded for the maintenance of slavery because he said, quote, slavery was the only punishment to which Blacks would respond. They needed speedy and public punishment. I've heard similar arguments in the aftermath of George Floyd that, well, it's horrible what happened to George Floyd, but we still have to deal with crime. And when that becomes our lens, we're unable to then go back and to grasp what Baldwin, what Frances Ellen Watkins Harper, what so many other people that I talked about with you were talking about. The brutal nature of the system and what it reinforces, and why policing has problematically become synonymous with it, even though it is representative of other tentacles of oppression associated with this murderous octopus that we call racism, or systemic racism, anti-Black racism in the United States. I also want to conclude by talking very, very briefly about one of the cases that inspired me to write that book, and it also has Justice John Marshall Harlan involved. He wrote the majority opinion Neal versus Delaware, a case from 1881 that witnessed the overturning of the conviction of a Black man for rape in Delaware because no African Americans had served on juries. And what Harlan did in that case, led by a brilliant argument from a brilliant attorney who would eventually become a candidate for governor in Delaware, was to argue that the fact that no African American had ever served on a jury in Delaware was prima facie evidence of the denial of the enforcement of the 14th and 15th Amendments. And it was a great precedent. And the reason that was important is that William Neal claimed from the very beginning that he wasn't guilty. But the fact of the matter is, and I'm just going to show you this slide, I don't have time to talk about it. Look at the executions for rape for Black men in Delaware at this time. I could make this even more plain by just sharing one statistic with you. The only white man to be executed in Delaware history for rape was a man named Ralph Ernest, who was executed in 1942. If you just looked at the statistics, rape was the exclusive preserve of Black men. Black men were the only people who committed rape. On this list, and I don't like talking about innocence as a metric for talking about criminal justice, but there are at least 4 cases here of men who were executed for crimes where there was substantive evidence that I found in the governor's papers of that state that would have exonerated those men. And yet in the case of 2 of them, the governor refused a petition for their release and ultimately allowed the execution to take place for the principle of ensuring the principle of white supremacy. When we understand that and we talk about truth reconciliation in that context, that also has to drive our conversation. the reason I mentioned Neal versus Delaware, and the reason I tie that to this conversation, is that later today, Mark Bennett of Drake is going to do a panel on Batson versus Kentucky. You will know immediately why I think that's important, because it illustrates these echoes of the past that I've been talking about in our contemporary moment. And what it shares with us, or what it should reveal to us, is what Professor Osler started out with in the very beginning. And I know I've been all over the place, but sometimes you just got to do what you do. The bottom line is that we have to recognize that we can't allow this moment of George Floyd not to become a full-fledged movement that, as part and parcel of that work, incorporates the difficult conversations necessary to reimagine criminal justice as reflective of the principles we would associate with the second Reconstruction. The third Reconstruction can't end in the same way, with a kind of lackadaisical approach and the assumption that the law alone will be sufficient to conquer these ills. That we have to think about reforming all aspects of American society and culture in order to achieve that level of success. And at the core, we have to move away from conversations about exceptionalism. I talked about Delaware, and not simply to indulge my research, but to say that we can't afford to talk about Minnesota exceptionalism in this case. It's not just about what happened to Jamar Clark or Philando Castile or George Floyd. It's about what happens to Black and brown people every day in the United States, and how we build a more equitable, just society, a beloved community, by recognizing, talking about that, and then doing the hard work of creating the legal interventions necessary to ensure that that doesn't happen. And we also need to demand more from our leaders. This is a very disturbing political cartoon from 2020, and I apologize if anybody's offended or thinks that I'm being political. I'm simply making the point about two pieces of historical content. On the left is a cartoon from Herblock from April of 1956. Shows Uncle Sam talking to Dwight David Eisenhower, who's pictured as the police chief. The nation is in flames over civil rights, and the Uncle Sam says to Eisenhower, "Tisk, tisk, somebody should do something about that." And of course, the reaction is, "You're the fire chief, what are you doing?" We're living in a contemporary moment where, even as I propose that it will take massive will at the state, federal, and local level to help to reimagine this moment and think about a third Reconstruction, we currently don't have that at the highest level of government in the United States, and that's a problem. And we will not be successful in dismantling systemic racism unless we understand the ways in which even conversations about racism is a public health crisis. And I love this image. Look at how it shows the tentacles again in housing, healthcare, employment, interpersonal, internalized, institutional, instructional racism have to be at the core of our conversations about criminal justice, have to be at the core of our conversations about dismantling, have to be at the core of our conversations about how we move forward as a society and culture to emerge on the other side, a more civil society, and one which lives up to the promises of American democracy and doesn't mock the same in its denial of basic rights and freedoms to all of its citizens. Thank you very much.
Thank you so much, Dr. Williams, for taking time to speak to us today. We are going to take about a 15-minute break right now, and we'll return at 11. We know there's been some questions about registration, so I believe Rachel just posted the Eventbrite link in the registration, or for the registration, in the chat if anyone else is needing to join. Like I said, we'll take a 15-minute break and then be back at 11.
Hello and welcome back, everybody. I'm Mary Susan Gerber, a third-year student at the University of St. Thomas School of Law and the editor-in-chief of the Law Journal. It is my pleasure and honor to introduce our next keynote speaker, Leslie Redmond. Leslie is an attorney, community leader, civil rights advocate, and strategic problem solver, both locally and nationally. In 2018, she became the youngest ever president of the Minneapolis NAACP. She's also the founder of the Don't Complain, Activate campaign. The idea behind Don't Complain, Activate is anyone can be a leader, and there is no one right way to activate your community. Rather, we need only to take a position. Leslie stood on the front lines after the unjust killings of Jamar Clark, Philando Castile, Justine Damond, George Floyd, and Breonna Taylor. She was one of the Louisville 87 who were arrested in July while demanding charges against the officers who killed Breonna Taylor. Leslie also gave a groundbreaking speech during the George Floyd protests that gained national attention and shifted the narrative from looting to uprising. Leslie is also an alumna of the University of St. Thomas School of Law and College of Business, class of 2019. Leslie will be speaking with us today about taking action during a global health pandemic and combating racial inequities. She's a dynamic and engaging speaker, and we are all really excited to have her speak with us today. Welcome, Leslie.
Thank you, Mary. Grace and peace, everyone. Again, my name is Leslie E. Redman, and Mary gave. Can you all hear me now? It said I was muted. Grace and peace, everyone. Again, my name is Leslie E. Redman. Mary, thank you so much for that introduction. I did want to just provide you all with a little bit more context about who I am, right? I'm originally from the inner city of Washington, D.C., born and raised. I am a first-generation college graduate. My parents have high school diplomas. My grandparents grew up in the South, North Carolina, South Carolina, Houston, Texas, where they attended segregated school systems and received about up to a 7th and 8th grade education before migrating to Washington, D.C. in hopes of better opportunities. So I often tell people I really am the hope and the dream of the enslaved African, with my great-grandmother Lily actually growing up in a plantation in South Carolina. This is what fuels me, right? This is what makes me put my foot on the ground and continue to activate in a very meaningful way, right? I don't think we can just talk about social justice, but we have to actively produce it every single day. Today, I want to talk to you all about a campaign that I created. It's called Don't Complain, Activate, right? And I often tell young people the idea is that you don't have to be President Barack Obama or Beyonce in order to activate your community, right? You could be a mom or a dad. And I know we have some moms and dads on a call, and you all know you are superheroes, especially during this global pandemic, right? You could be an artist, you could be an activist, or you could be a lawyer, right? And that's what we're going to talk about today, because the legal profession is so important when we think about the history and the future of where we are going in America and the global impact that it is going to have, right? With Don't Complain, Activate, there are 3 C's of activation: communication, collaboration, and compassion. For the first C, communication, we know that communication builds relations, right? And we also know that the opposite is true. If we're not communicating, we're not able to build effective relationships. What we are communicating is so important. I can't overstate that. Something I constantly think about is the need to separate facts from myths, right? One example is race. Race is a myth that we all have bought into, but racism is a real reality. The roots are white supremacy. Nowadays, we're hearing a lot of propaganda around reverse racism and how diversity and inclusion training can be offensive. And I really warn people to be cautious about that. I have to remind them that abolishing enslavement of Africans on American soil was very offensive to plantation owners, right? Justice is sometimes offensive. And what I want to communicate and urge you all as attorneys and as decision makers to choose justice over process, right? And when I was thinking about activators in the Twin Cities specifically, and when I was thinking about people who have done an effective job of communicating and leaning towards justice, or maybe the opposite, 3 people came to mind. Now, one, let's start off with Judge Pam Alexander. I'm sure you all know about Judge Pam Alexander. She is now retired. She was actually the first African-American female judge in Minnesota, right? One of the things that I know Judge Alexander for the most, and you all probably know as well, was in 1990, she took a very courageous step, right? She called out the discriminatory practices and sentencing of crack cocaine versus powder cocaine. Now, at the time, this was an extremely courageous decision for her to make. And thankfully, the Minnesota Supreme Court validated her sentence. However, she was labeled an activist judge, right? When the late and great Senator Paul Wellstone put her name up and nominated her to be a U.S. district judge, she was thrown to the side. Not only was she thrown to the sides, but her push to make us actually deal with these disparities in the law weren't taken serious. Now, why is that important? Because today we're here because of Brother George Floyd. Had he not been murdered here on Minnesota soil, we probably wouldn't be having this conversation today. I need you all to know that the knees that are on the necks of Black people go far beyond the police system, right? The legal system has their knees on the necks of Black bodies every day. The reason why Judge Pam Alexander pointed this out was because during those times, we know that the Black community were the ones who were being prosecuted, sentenced, and charged for crack cocaine, and the white community was being sentenced and charged for powder cocaine. For the same offense, Black people were getting sentenced to 20 plus years, and white people were getting sentenced to 5 plus years. Instead of doing the right thing, the Minnesota legislator, they decided to just increase the sentencing for powder cocaine. Now, what this did lead to at the time was better drug courts and actually acknowledging the humanity, right? Because we know when white people are involved, there's an amount of compassion that comes out. What I hope any young lawyers are looking at and law students can think about is that sometime when you stand on the right side of history, you're not going to get an award for it. You might not be validated until 17 years later, like Judge Pam Alexander, when the U.S. Sentencing Commission made the same decision that this Black woman came to 7 years prior, right? So when there's a hashtag, listen to Black women, this is what we are talking about, right? Because, you know, to put it in perspective, Judge Pam Alexander, she put her career on the line. She was labeled an activist judge. She would have been a federal judge, but for her standing up for Black people. Now, I really want you all to put that in perspective. Calling out injustice and standing up for Black people have led some of the top officials to being gaslighted, being targeted, being crucified. It's not enough to just be outraged when you physically see an officer sucking the life out of a Black man, George Floyd, for over 8 minutes. We have to look into the laws, the policies, the practices that exist in America. Charles Hamilton Houston, he once said that as a lawyer, you are either a social engineer or you are a parasite to society. You have to pick a side. And I remember I said that one day when our friends at the ACLU gave the Minneapolis NAACP an award. And a lot of the older white lawyers in the audience, I noticed they laughed because they thought about so many lawyers that they knew that were parasites on society. And what I want you all to do right now, I don't want you to think about other people who are parasites on society. I want you to think about how you all have played an active role. I want you all to think about a time that you stood with precedence over justice, a time that you picked process over justice, right? Because all of this contributes to white supremacy. All of this contributes to the oppression of Black people on American soil. And so what I urge you all to do, what I wanted to make sure I communicated to you all today is be like Judge Pam Alexander and do the right thing, even when it's not convenient, even when your job is not going to increase and you actually may be in a negative position after you stand up for justice. Do the right thing because it's the right thing to do. We are in a climate right now, a feel-good moment where people are activated, and I'm excited about it. But I want you all to really activate. Not just in your missions, not just in your statements, not just in what you say, but in real life, in real time. Lawyers are some of the most powerful people in this nation, and how you use that power will decide where our nation goes. Understanding that every legal doctrine we have, every institution we have is deeply embedded in white supremacy. Did you all hear me? Every legal doctrine we have, every institution we have is deeply embedded in white supremacy. And if that's something that we're not teaching law school students, if that's not something that we are acknowledging, we are doing the world a disservice, right? So I want to talk about another person who at the beginning of this year, I didn't know. But now we have each other's phone numbers. We're actually on really good terms. You all know her, Senator Amy Klobuchar. You all may remember that in January, myself and Nikema Levy-Armstrong and Associated Press, we called out, and I don't like to say call out, I like to say called in Senator Amy Klobuchar about the case of Mayan Burrell. If you all don't know Mayan Burrell, please go Google him. He was a 16 to 17-year-old young man who was convicted of a life sentence for a crime that he likely did not commit. And Senator Amy Klobuchar had talked about this when she ran for senator, right? Because it was an 11-year-old girl, Taisha Edwards, who was murdered. And we all had an extreme amount of compassion for her mom and her family and all the violence that was going on in the community. But we were so focused on getting theoretical justice. We didn't care who we were locking up. We just wanted a warm body. And people's political careers were able to soar through the roof, right? Senator Klobuchar didn't just use that to get elected as senator, but she was using it on her campaign trail, right? And by the grace of God, it just aligned at the same time that the Associated Press came out and brought a lot of new evidence to the surface. Now, this was a very critical moment, right? Especially for a young attorney like myself. It was funny because I had just finished working at the Attorney General's office and had turned down a position of being a prosecutor. Now, and me and Attorney Keith Ellison actually talk about this. Historically, prosecutors have been looked at as ministers of justice and supervisors of public safety, right? Like, we actually have to be about justice and public safety, not just prosecuting for the sake of prosecuting, not just upholding laws and not asking, you know, is this ethical? Is this going to push us forward and closer to justice or further away, right? And I want to say thank you to Senator Amy Klobuchar, because one of the pleas that I reached out in January and said was that we have never gone too far to come back, right? Brian Stevenson told us that we're not as good as the best thing that we've ever done, and we're not as bad as the worst thing that we ever done. And so I always knew that there was a path of redemption for Senator Amy Klobuchar. And while it took us a while to get her attention, when we did get her attention, she met with the family of Mayan Burrell. She helped to humanize that situation. She publicly spoke out and said that the case should be looked into again. We all are working to make sure that the justice system is moving in the right direction, right? We have to do more than just follow business as usual. As lawyers, we have to disrupt business as usual because we recognize that the system is not broke. It is operating the way that it was created. And a lot of it has to do with hindering and keeping its knees on the necks of Black bodies. And it's not just police officers. If anything, they are the pawns. And if they are the pawns, I ask you all, what are the lawyers? And as lawyers, Where do we want to stand in history? Right? Senator Amy Klobuchar decided that she wanted to stand on the right side of history. And she wanted to speak up about Mayan Burrell. And she's reached out to me since when George Floyd was murdered and has reiterated her commitment to helping rectify the past, right? Now, this last person, we're still in communication, you all. This last person I want to communicate to you all about is someone who I haven't had the pleasure of meeting and talking to. Actually, back in March, I reached out to her about the Mayan Burrell case because President Derek Johnson, the national NAACP president, was coming to town, and he was going to meet with Mayan Burrell, and he wanted to meet with some local officials as well. And then COVID-19 hit, unfortunately, he wasn't able to come. However, we reached out to Justice Gilday, who you all know, and she denied our request for a meeting. And she stated, you know, she couldn't meet about the specific case, but she also didn't want to meet about criminal justice reform. And again, this is not me calling her out, but I would urge you all to call Justice Gilday in, right? And recognize that she serves in one of the highest positions a lawyer can serve in as the Chief Justice in the Minnesota Supreme Court. And how is she using that power to rectify past wrongs? How is she using her power as 1/3 of the Board of Pardons, right? If you all need to know about clemencies and the lack of pardons Minnesota's passed, and I urge you to talk to Professor Mark Osler, who is an expert in it and who can really break it down for you to really understand how we are really failing the state of Minnesota. And Justice Gilday is playing a tremendous role. Now, I know many of you on this phone probably have a great amount of respect for Justice Gilday, and that's phenomenal. And I hope that when you sit down with her, you'll bring up this conversation and ask her, have you ever thought about doing mass clemencies? Have you ever thought about retroactivity, right? Because we know that retroactivity is a form of reparation. And in order to have reconciliation, you have to have reparations, right? And so it's not enough to talk about what's going on in the White House and what's going on in DC. We have to talk about what's going on right here in Minnesota. We have to talk about Mayan Burrell and the many other Mayan Burrells that exist, right? We have to talk about how we have our needs on the necks of Black people, right? I want to salute the Minnesota Sentencing Guideline Commission because they've been doing a great job. I was able to testify and they put a 5-year cap on probations, but it's not retroactive. Again, that is something Justice Gilda can help with if she wanted to be about justice. Because when we think about probation, when we think about the criminal justice system, this is another form of slavery. If you all have not read The New Jim Crow by Michelle Alexander, I urge you all to. That should be a mandatory reader for all lawyers, for all law school students. Because we recognize if people are still on probation and have these extensive probation sentences, they cannot vote. That's voter disenfranchisement. And we know that a lot of these people, not coincidentally, are African American, are the descendants of enslaved Africans, the same people who America has historically denied our humanity and denied our constitutional rights, right? And so we need to do more. We need to do better. It is not enough. I want to say I'm thankful to all of you all who are joining us and being concerned now about not just civil rights, but human rights. But we have to do action. The Bible says faith without work is dead. And you have to ask yourself, what work are you doing? What conversations are you having? To whom much is given, much is required. And I pray that as you all are listening to me today, you will receive something and pass it on to rooms that I'll never enter, to people who will never hear me speak or maybe do not want to hear what I have to say. And I believe in translating. Maybe you all can say it in a nicer, more politically correct way. As long as the outcome is income, power to the people, right? And so to wrap up communication, I just want to remind you all that it is very important what we are communicating and also what we are not communicating. I remember when I was president for the Black Law Student Association at St. Thomas, I said that. I said, you know, men lie, women lie, numbers don't lie, but they can be misleading. And in the state of Minnesota, where we have more Fortune 500 companies per capita than any other state, this is the nation of foundations, this is the nation of nonprofits, right? But yet we have some of the worst racial disparities in the nation. And we continue to perpetuate those injustices. And I'm not just talking about Justice Gilday. I'm going to talk more about St. Thomas during my compassion section, but I do want to urge you all to take a deep look at yourself and remember the quote that I gave you all by Charles Hamilton Houston that says, you are either a social engineer or you are a parasite on society. There's no in between. You have to pick a side. Right now is such a critical time. 2020 has been the year of awakening. Professor Osler said earlier, we have eyes, but all of us are not seeing. And we don't see because we don't believe, right? Fernando earlier talked about how we have to validate the experiences of the victims. Do you all know what that means? It means believing us. Because we could scream to the mountaintop, but yet you don't hear us. You don't see us. You don't believe us, and you don't stand with us. Imagine if 1990, if people had stood with Judge Pam Alexander, the amount of justice that could have happened. I think about what could have happened when I was at St. Thomas if people had stood with me more. But I don't want to go past myself because we're going to talk about that. We're going to talk about that. Okay, this second section that I want to talk to you all about is collaboration, right? So we talked about communication. I want to talk to you all about collaboration. So one of my business professors, he said, people like to do business with people they know, they like, and they trust, right? And I think that that is like dead on. And a lot of the problem has to do with the fact that we don't even know each other, right? We live in a very segregated society. And while social media exists and we're theoretically more connected than we've ever been before, we also are extremely disconnected, right? And it's crazy to me that this global uprising, what happened during this global pandemic, but I also recognize that the uprising may hadn't even happened had the global pandemic not happened, right? I tell people all the time, COVID-19 shut the world down and George Floyd opened it back up because we recognize that Black people who can even survive a global pandemic that is disproportionately impacting them can't survive white supremacy, right? And that is why we need to all stand together. My brother, Dr. Yahuru, played a video. And Al Sharpton talked about how now you see as many white people, if not more, on the ground standing up for justice, right? And that's because of collaboration. That's because young white brothers and sisters are recognizing that there's only one race, which is the human race, and that we are all in this together. At the protests, I often tell people, this is not white people versus Black people. This is everyone against white supremacy. This is humanity against white supremacy, right? We have to collaborate and recognize that this nation, when it was built, it didn't include a lot of people at the table. We know white women weren't at the table. We definitely know Black people that was considered property and that was utilized to build up this nation weren't at the conversation. Native Americans weren't at the table. So many people were not at the table. And so we have this hypocrisy. This nation built on justice for all without having justice for all. Right? And that's why we have to take a deeper look, and we can't just depend on precedent. We can't just depend on history because we know history has gotten it wrong, right? And so, as I said earlier, in order to have reconciliation, you have to have the reparations. And I urge you all to think about how you can help to repair society using your legal degrees, using your expertise. So I want to give you 3 examples, just like I did with communication. I want to give you 3 examples of collaboration that I hope you all can find some kind of empowerment or liberation from. Right? So my first one I want to talk about is my friends over at the ACLU. I actually wore this shirt just because of that. I hope that you all by now have heard of our War and Forgiveness Days that we have. So back in 2015, the ACLU, they did a report, right? And in their report, they talked about how all of these warrants that Hennepin County had basically were based on low-level offenses. Now, when I say low-level offenses, it was people driving without a driver's license, people not having insurance, people loitering, right? Disorderly conduct. And obviously, this was disproportionately impacting Black and Brown people. Right. And so when the NAACP saw this, and I want to shout out to the president before me, Jason Soul, who I worked with on this, when he saw this, we decided, and this was under the leadership of Nikema Levy-Armstrong, we're going to start doing warrant forgiveness days. Right. And so we wanted to call it Amnesty Day, but nevertheless, we settled on warrant forgiveness days. And this was a collaborative effort. So it was started with the ACLU and the Minneapolis NAACP. Right? We used their report, came to them, decided to join forces. And then we reached out to commissioners, we reached out to judges. It was a huge collaboration, right? And we have been able to do several warrant forgiveness days. We have been able to clear hundreds of warrants and tickets in one day, right? We've had them in Hennepin County, we've had them in St. Paul, we've had them all over, multiple. Dakota County, we've had multiple warrant forgiveness days. And this is just people who believe that we can be better than what we currently are. But we couldn't have done it without collaboration. The ACLU did the research, the NAACP came up with the ideas, and we joined forces to make sure we had a more just society. Because we recognize that these warrants were being given based on poverty. People couldn't pay their tickets a lot of time. Missed court and bench warrants were put out for their arrest. Now, if you know anything about what's been going on in America, a warrant could lead to the death of a Black person. So when I see lines wrapped around the corner of Black people showing up to get their warrants forgiven, right? Now, mind you, this was at a community space. We assured and said no one would get locked up. A lot of people thought it was a scheme. I'm sure some people still probably are a little cautious, but because we put the NAACP name on it, it brought credibility, right? We were able, again, everyone brought something to the table. And that's how we have to do to grow. We have to recognize that we can't do it alone. There's an African proverb that says, if you want to go far, go alone. If you want to go forward, go together. I want to go forward, which means that I need you all to work with us. I need you all to be like our friends at the ACLU and collaborate with us. And don't look at me like we looked at Judge Pam Alexander, like the activist judge. Don't look at me like the activist lawyer. Just look at me like as a human being who cares about justice. How about that? And I hope that you all care about justice too. But you can't just say it and you're talking rhetoric. You have to live it. You have to breathe it. We need you. Humanity needs you. I came here today to plead with the legal community to stand up and do your job. You all should be out there when protesters, human rights are being violated by the police. I got tear gassed on multiple occasions. And I can guarantee you I didn't throw anything. We need you. Be like the ACLU. Be like Judge Pam Alexander. Be like Senator Amy Klobuchar and help to right some of your own wrongs. And we are here with open arms to help you. Okay? Sorry, I just want to check my time and see how I'm doing. We have about 30 more minutes, you all. Don't stay with me, okay? Stay with me. We going somewhere. We're going somewhere here. We just warming up. So be like the ACLU. Be willing to collaborate with the Minneapolis NAACP. And speaking of the Minneapolis NAACP, that's going to help me go into the next person I want to talk to you all about. So I often have a lot of people come up to me and they say, Leslie, you know, some of my white brothers and sisters, they'll say, Leslie, can I join the NAACP? And I'm like, of course you can join the NAACP. One of the things that people don't always realize about the NAACP is that it was founded by white and Black people, right? Who recognized that the brutality that the Black community was facing, that Dr. Yahuwah Williams just walked you all through, that's not the plight of ours alone. This is a plight that all human beings have to stand up and fight for, especially lawyers. So I want to tell you all about one of my favorite lawyers ever. And it's a man who we don't talk enough about. This man's name is Morfield Story. Write that down. I hope you all have heard his name before. His name is Morfield Story. They don't teach about him too much. He was an amazing constitutional attorney. He was the former ABA president, and he was also the first president for the NAACP. How many of you knew that? Go ahead, put it in the comment section. Did you know who Morfield Story was? Did you know that he was a constitutional lawyer, that he was a former president for the ABA, and he was the first president for the NAACP? This white man with a lot of privilege, a lot of money, and a lot of resources thought that it was his duty, not his chore or not his choice, but his duty to stand with Black people, to stand with the Black community and use and leverage his law degree and his expertise to pour into the Black community and to help prosecute certain cases, to help move forward, to push the needle forward for justice. Morfield Story. Be like Morfield Story, law school students. Use your legal degrees to help come fight with the NAACP, just like our first African-American Supreme Court Justice, Thurgood Marshall, another NAACPer, another lawyer, right? You all are in good company. Charles Hamilton Houston, who was the teacher of Thurgood Marshall, who was from Washington, D.C., just like me, who created the argument for Brown versus Board of Education, the landmark case that changed the world. And now we need to continue the fight. John Lewis told us to get in a good trouble. Get in a good trouble in your law school classes. Get in a good trouble in the courtroom. Get in a good trouble, you all. To whom much is given, much is required. And Morfield Story understood that. He understood that he didn't have the luxury to just get this law degree, to be this constitutional lawyer, to be the past president of the ABA and not stand with the Black community. He didn't have a choice. He felt like it was his duty. I feel like it is my duty. How many of you feel like it's your duty? Go ahead, write in the comment section if you feel like it is your duty to stand up for justice. Write in the comment section how you are going to activate your community. Write in the comment section how you are actively using your degree to change the landscape of America. Write in the comment section. Because it's not enough to just show up. You all have to think, and you all have to act, and you have to stand with us, just like Morfield Story, in a real, meaningful way. Right? Okay, so now I told you I had 3 for you. So we just talked about Morfield Story, we talked about the ACLU. Now I want to say collaboration. Collaboration is very important. You all know that a lot of the reason why we're here today is because of Brother George Floyd. And I have to say his name, and God rest his soul, God rest Breonna Taylor's soul, God rest Ahmaud Arbery, and all the names that we don't even know to call. November is going to mark the 5th year anniversary of the murder of Jamar Clark, which I'm going to talk about more in my next session. But we have to keep saying their names. Now, with that, many of you might not know where I stand with police. You might not know, where the tension is, X, Y, and Z. I want to talk about my collaboration with Chief Arredondo, right? I love Chief Arredondo. If any of you have ever seen me speak on any platform, I don't speak on platforms about anything in relation to police without making sure that I acknowledge my love, respect, and appreciation that I have for Chief Arredondo. I would argue that Chief Arredondo is one of the best police chiefs in the nation, if not the best police chief in the nation. The amount of leadership that he showed during this very challenging time is something that we could all admire and take notes from, right? I remember when Brother George Floyd was murdered, I got calls and texts from Chief Arredondo. He was the first one to notify me about it, actually. And he called for a meeting with Black leadership. And, you know, many of you might not know this, but Black people, we're not a monolith, right? Like all Black people don't think the same. And so when I say Black leadership, there were a lot of Black leaders in the room and Black leaders that disagree on a lot. But we could all agree that what happened to Brother George Floyd was a modern day lynching, right? And we expressed how we felt, and Chief Arredondo expressed how he felt, and someone from the FBI came in, and the Mayor Jacob Fry, and thank you to Mayor Jacob Fry for all that he's done in standing with Chief Arredondo and standing with the community. And so we had this meeting, and you know, he told us that he would call us back in about 2 hours for a press conference where he would announce his decision, and he decided to fire the 4 officers. Talk about precedent. This was unprecedented, right? This was something that had never been done, to see what happened and to say what happened and to immediately make sure that the consequences are there. And then we had another courageous leader, our Attorney General Keith Ellison, right? Because we knew that we didn't want it to go to Mike Freeman. We wanted Attorney General Keith Ellison to step in, and he did. And he pressed charges against all 4 of those officers. And, you know, we're still in the process of that right now, but I have an extreme amount of respect for Attorney General Keith Ellison. And, you know, obviously I'm thankful that he has been courageous and that he really is a minister of justice, right? And that he is taking his rightful place, I believe, in history, unlike Daniel Cameron in Louisville, Kentucky, in the Breonna Taylor case, right? And I just want to say, we fought very hard, and I critique Mike Freeman a lot, but I also want to give him credit for leaning into the right side and finally deciding with the community to not use grand juries and police-involved shootings, right? Which was one of the issues that arose in Louisville when Daniel Cameron used a grand jury and then didn't even provide them with the proper information for them to make a decision, right? And so I just want to say, while I know that Minnesota has such a long way to go, there is hope. There is real tremendous opportunity, and I am optimistic that we can all work together. We can communicate, we can collaborate, and we can be compassionate towards each other in order to get justice done. Now back to Chief Arredondo, right? Because not only did he fire those 4 officers, but when the uprising was going on, you know, I got calls from my Bishop Howe over at Shallow Temple International Ministries. I got calls from the mosque on West Broadway. I got calls from a lot of people talking about the threats of what happened to South Minneapolis happening to North Minneapolis. And you all know that that is a very predominantly Black community. And I was concerned. You know, West Broadway and North Minneapolis is home for me. I love North Minneapolis and West Broadway. It reminds me of my home in Washington, D.C. and H Street. And if you all know anything about the history of D.C., it was historically Black and has been very gentrified now. And a lot of that gentrification was allowed to come by way of a lot of the burning down of our community when Martin Luther King, Dr. Reverend Martin Luther King, was assassinated in the 60s. West Broadway burned to the ground, similar to South Minneapolis. And I refuse to let that happen in North Minneapolis, right? And we know that, again, as I said on CNN, this was not young Black people doing it, contrary to what the media was showing. People were breaking the doors, and then the Black people in poverty were going in the doors, just if you all didn't know that. These young Black people didn't have the tools or the resources to burn these buildings, right? There were a lot of white agitators coming into the community and burning them down. that was a lot of my belief, and it was verified when we went out there. And initially, I was thinking we were just going to sit out, right, and make sure no one was coming with gasoline to burn the buildings, right? And so we had white and Black people coming out, sitting on the corners. We were able to stop people from breaking into the ATMs. We were really doing public safety work, right? And unfortunately, one of the volunteers ended up getting shot at by a white man who was trying to burn a building and who got caught. And so then we had to call people to come and be armed out there with us. And I'll never forget the day, one day, Chief Arredondo was out there with us and somebody started shooting, right? And Chief Arredondo, when he came and stopped by, I felt so protected. I felt so humanized for probably the first time in America. And I know some of you are like, what do you mean for the first time in America? We're going to talk more about that in the section of compassion, but I just want you all to know that your lived experience as white people is vastly different from our lived experience as Black people in America, right? And having a chief that I believe truly wants to protect all Minnesotans, it matters, right? And so, you know, Chief Arredondo made sure the police didn't bother us. The National Guard, he made sure the National Guard didn't bother us. When they ushered them into town, they waved at us. It was like, you all had to see this to believe it, because I was in denial of, like, we were staying out there occupying North Minneapolis for like 2 weeks, making sure it didn't burn down, and no building burned down since we were out there. 3 had previously burned down on West Broadway. And when we occupied, nothing else burned down. And I remember one night, apparently some kids had stole a car, went joyriding. They came and drove into where we were, got out the car, and then the police from St. Louis Park were chasing them, hopped out, guns blazing. And you have all these Black men and women who are armed to protect the community, but they don't know this because they've come from a whole different district. And I have to come up with my hands like, I am the president of Minneapolis NAACP. We've been out here for 2 weeks. We don't mean you any harm. And it was crazy because I didn't know what was gonna happen, but it ended up being good and we were able to talk and it all worked out. But I just want to reiterate the importance of collaboration and us working together, and how, you know, history only repeats itself because we repeat ourselves. If we stop doing the same thing, different things will happen. I always urge myself of, like, when I grow up, I'm going to make a difference. And I'm not going to allow communities that I'm around to be gentrified and to be burnt down and to be violated. And I had the opportunity to stand up. And I want you to stand up, right? And you don't have to stand up the same way that I stand up. All I'm asking for you to do is collaborate and to use your gifts that God gave you to help us to advocate and activate in a real meaningful way, right? Okay, so now I'm going to go to my third C, right? I just want to do a little quick time check. We're at 11:43. You all can almost get rid of me, but not just yet, okay? So this is my favorite C, you all. Thank you for sticking with me, okay? This is compassion, right? And Reverend Dr. Martin Luther King, he told us that darkness cannot draw out darkness. Only light can do that. And hate cannot draw out hate. Only love can do that. And that's what I think we need. We need to lean into love and lean into compassion, right? And so when you all watch that video of Brother George Floyd being murdered, or you watch Philando Castile be murdered on Facebook Live, and I want to just salute Miss Valerie Castile and all the work and advocacy that she's doing, that is amazing. When you all watch those, I think it's easier for you to, like, see the injustice, to see the lack of compassion. But I want to bring it back. I want to bring it back to law school. I want to bring it back to lawyers. And I want to give you all a little bit of my experience and the lack of compassion that I felt when I was a law school student at the University of St. Thomas, as the only African-American student in my actual first year of law school. There were 2 other Black students in the other section, but none in my actual class. There was an older Somalian gentleman, but I was only African-American in my class. And the following year after me, there was not one African-American male or African male that entered the class, which I noted because I remember there were only LLM Black male students, right? And after me really raising this awareness, the following year, more Black students came in than ever before. And I ended up graduating with that class in 2019. And so I do want to commend St. Thomas. Why I had a lot of issues and I had to really fight through the system and serving on diversity and inclusion committees. I think that we were able to get some good work done. But I do want to talk about what it was like, right? I remember my first year of law school and taking constitutional law. And I remember us talking about President Abraham Lincoln. And I remember us talking about the 13th Amendment that theoretically abolished slavery, but continued to create a caveat to say, except if you're duly convicted of a crime, which created a mass incarceration of Black people. I mean, he didn't talk about those things, but I acknowledge those things. I remember when we talked about fugitive slave laws and the idea of enslaved Africans as being property. But I remember how we didn't talk about the injustice in it. I remember how we didn't talk about the fact that these enslaved Africans were really humans versus property. There was no context provided. There was no understanding of the injustices that had actually existed. And I don't know how you all feel, but could you imagine being a Jewish person sitting in a class talking about the Holocaust and never talking about the injustice and inhumanity of it? Could you imagine, being a woman sitting in a class talking about, anything related to being violated and no context of humanity being mentioned? It is very important for us to realize the many ways that we have our knees on the necks of Black people and the lack of compassion that we show Black students. And I want to, share a transparent moment with you all. So I talked about Jamar Clark and how we're approaching the 5-year anniversary of his murder. And I remember, the night of Jamar Clark being murdered was also the night of the Mabel Gala, right? The Minnesota Association of Black Lawyers. And I was receiving the William B. McGee scholarship, right? And I remember that next morning, Nakima reaching out to us and saying, hey, an unarmed Black man had been murdered in North Minneapolis. And I remember going there and, we stayed out there for 18 days in the dead of winter. And I was out there when, these white supremacists came and shot peaceful protesters, right? I was out there when the police came over the precinct walls with ski masks on. They were identical to the protesters. And I talked about that in the Democracy Now! Interview. And I remember the lack of compassion that I felt from St. Thomas. I remember Virgil from the clinic and Dean Bishop being the only 2 people to reach out to me about it. I remember the compassion that Professor Neil Hamilton, though, showed me during my class with him, because I remember one night I couldn't come to class because I was literally in the hospital with one of the protesters who had got shot. And I don't even think I really felt how I felt about it until President Trump was in office. And this has nothing to do with politics, you all, so don't cut me off. I remember being in business school and President Trump being elected. And the next day, they connected it to his marketing campaign, the impact it was going to have on economics. They connected it to everything, right? Without talking about politics. And seeing how they humanized the students and their experiences reminded me that we didn't talk about Jamar Clark in any of our classes, that there was no moment, that there was no compassion, that there was no acknowledgement, right? And I remember just going nonstop. And when break came, I crashed. And I remember coming back for a J-term class with a professor who I'd taken for 2 other classes and gotten B and B pluses in. And I took him for that J-term class and I was like a zombie. It was like I wasn't even there. And I remember writing a paper like the night before it was due, and I did horribly, as you all could imagine. And I remember talking to him and then going and talking to one of the deans about how I felt like the grade was not an indication of the work that I could do at all, but it was an indication of the state of mind that I was in and the conditioning. And I remember the lack of compassion I felt, right? And I remember at that same meeting with that dean that I was telling him about like how I really felt about like how it had nothing to do with my performance, but like how I just mentally was not there and that I probably needed help and how no help was ever offered. No, you should go to therapy. No, you should talk to anyone. None of that was ever offered. But what he did bring up next was a miscommunication that I had with another white man. These are all white men that I'm talking about, right? Another white man who I'd asked to look at my resume, and there was an issue of what was stated, because the previous semester I was on the dean's list, and I was on the dean's list for the whole semester, and I was also got a dean's award for the civil rights clinic, and it was misstated on my resume, basically making it seem like I was in the top of the class overall versus in the top of the class for that specific semester. But it was an easy mix up that could be easily corrected. But the Career Center reported it to the dean as if it was actually something shady going on. And when the dean brought it to me and I explained it to him, he like, oh, I could see how you can make that mistake. But can you imagine going into a room asking for compassion about being in the Jamar Clark situation and not receiving any of that? And then at the end of the meeting, basically like, oh, why have you here? Let's talk about this so you can get in trouble. This is what I experienced, not in the South. This is what I experienced at St. Thomas. Right? No compassion whatsoever. And that was actually the reason why I ended up withdrawing. I had such anxiety about coming back to St. Thomas for my last semester. Even when I had over 3.0 in both the MBA and the JD program, I withdrew because of my anxiety and worry about coming back to an institution that I did not feel like valued my humanity. And I thank God for prayer, and I thank God for people reaching out to me. And I remember when I came to the epiphany of I needed to go back, and I told Nakima, because the MBA program welcomed me back, and they didn't say that I really needed to do anything, but the law program, required me to have a meeting with the bishop and, wanted me to send in a statement. And I remember not even wanting to go into the meeting with Dean Bishop by myself and asking Nakima to come with me. And we had a very emotional meeting, and I was thankful to Dean Bishop because he did show me compassion, and we did meet for the rest of the semester. But my law school experience was very traumatic as a Black student. And I did feel like St. Thomas had their knee on my neck. And I don't mean to be getting emotional, but it's real. But it's really real what Black people are going through in America and what Black people are going on in the legal system and even at St. Thomas. And I know there's probably some decision makers and people on this call. And I hope that you all challenge the system, because that's what I tried to do. But these systems have built-in immune systems that will push you out the moment that you try to challenge them. Hello, President Brooks. It's good to see you again. I can pass it over to you. I just really urge you all to have compassion towards Black people, to see our humanity and to validate our experiences and to see us as more than statistics, because it's a lot of harm and pain that's caused. President Brooks, I think they need to introduce you, but I'll wrap up, and thank you all for having me. I just urge you all to don't complain, activate. Grace and peace, everybody.
Thank you so much for speaking with us, Leslie. We will now go to our next speaker. It is a pleasure to welcome Cornell William Brooks to speak with us today. Cornell William Brooks, the former president and CEO of the NAACP, has consistently fought in the battle against racial discrimination and economic injustice. Under his leadership, the NAACP has secured 12 legal victories, including laying the groundwork for the first statewide legal challenge to prison-based gerrymandering. He has also reinvigorated the activist social justice heritage of the NAACP, dramatically increasing membership, particularly online and among millennials. As a civil rights attorney, a social justice advocate, and a fourth-generation ordained minister, it is clear that he desires to put himself on the line in service of the greater good. He has graduated from undergrad at Jackson State University. He went on to receive his Master's of Divinity from Boston University School of Theology. He then earned a JD from Yale Law School, where he was a senior editor of the Yale Law Journal and member of the Yale Law and Policy Review. He is a professor of the practice of nonprofit organizations and professor of the practice of public leadership and social justice at the Harvard Kennedy School. He is also the director of the William Monroe Trotter Collaborative for Social Justice at the School Center for Public Leadership and visiting professor of the practice of prophetic religion and public leadership at Harvard's Divinity School. We are thrilled to have you here with us today. Please join me in welcoming Cornell William Brooks.
Thank you so much. I really appreciate those warm words of welcome. And before I commence with my formal remarks, let me just say to my sister Leslie that the few moments and minutes, few words of testimony that I heard just a moment ago really brought to mind my experience at Yale Law School many years ago. And so I just commend your courage and your guts for speaking up, for calling us into account, calling us to do the things that we are all called to do in this work. So I would not want you to hasten your moment without me just saying I recognize the moment and recognize your words and your courage and your moral and emotional transparency. So thank you. So I just begin with a few words of gratitude. Appreciation to the University of St. Thomas, the law school, the faculty, the staff, the practitioners, most importantly, the students who've gathered today to discuss, to engage, to morally imagine what we do in the wake of the tragic death, murder of George Floyd. And so I begin with this word of appreciation. I also extend gratitude to Mark Osler, whom I've known since my days in law school. He struck me then as someone who understood where he wanted to go as a lawyer. And over the years, I've come to admire the work that he's done, the students he has engaged, the causes that he's taken up. And having had him speak at the Harvard Kennedy School, I'm just delighted, honored, humbled to have the opportunity to come and share with you today. So for a few moments, I simply want to take note of the moment that we're in, offer a few words of encouragement, inspiration, moral direction, and legal guidance, if you will, in terms of the anguishing hour in which we find ourselves. We find ourselves at a moment where, were you to survey the length and breadth of our country, you would take note of the fact that there is a generation of young people, young activists, but also lawyers, law students, practitioners who have lifted up the words Black Lives Matter, understanding profoundly that Black Lives Matter is the moral predicate to the ethical conclusion that all lives matter. Unless the first is true, the second can never be true. It is a moment in which we have seen in the wake of George Floyd's death, no less than 26 million Americans across 550 jurisdictions, 3,800 localities across the globe engaged in protests, demonstrations, nonviolent direct action, who laid down their bodies, lifted up their voices, issued a call to the country, a call to the globe to stand on the side of those whose lives have been taken, whose lives have been brutalized, whose voices have been muted, whom history has seemingly lost. In this moment, all across the country and across the globe, we have seen again and again and again demonstrators and activists standing in the gap. It is a moment in which we have literally seen activists facing tear gas, facing truncheons, facing batons, facing hostile police, hostile governors, hostile mayors, and even, yea, a hostile president. It is a moment in which there has been a generationally unprecedented level of activism, the likes of which we have seldom seen in American history. It may well be, and it has been described as the largest mass demonstration, certainly in American history. It is a moment in which so many have been tempted to hand-wringing despair, head-spinning cynicism. It is a moment in which even in America's leading law schools, in America's leading graduate schools, in communities across the country, in villages, cities, and suburbs, many are tempted to despair. Many are tempted to be cynical about the possibilities of reform and indeed transformation of American policing. It is a moment in which some are tempted to hopelessness. I simply want to respond on behalf of the students at this law school who have stood in the gap, the students at this law school who have taken up the cause of defending and representing protesters who've been arrested in the streets. I want to speak on behalf of the students in this law school who have taken up the cause of seeking pardons and clemency on behalf of those who have been damned and doomed in the bowels of America's criminal justice system. It is a moment in which I want to simply lift up a word of hope in this moment. And if you chose to entitle these brief, modest remarks, I might entitle them or caption them, if you will, George and Jesus, Policing an Insurrection of Hope. George and Jesus, Policing an Insurrection of Hope. In this anguishing hour of our democracy, where so many of our citizens in Minneapolis, in Charleston, in Louisville, in Baton Rouge, in Berkeley, in Oakland, in Washington, New York City, in Boston, in this moment when so many of our citizens are tempted to despair, I'm reminded of the words of Abraham Joshua Heschel, the spiritual and prophetic soulmate of the Reverend Dr. Martin Luther King, who once said that words are worlds. In other words, the words that we speak, the nouns and verbs, adverbs and adjectives that we enunciate and articulate can transform our worlds. In other words, the words that we speak can give us hope. In other words, the words from our sacred text can give us hope. The words from protesters and demonstrators who have illustrated by the eloquence of example their hope for this country can give us hope. I would dare say to these law students, these practitioners, these lawyers, all you need do is remember the words you wrote on your application to law school to give you hope, because those words remind you of who you are, what you stand for, what you aspire to, the country you envision, the social justice dreams that lie before you. Those words speak to your soul. Those words speak to who you are. Abraham Joshua Heschel said that words are worlds. I want to suggest to you that in this moment, that hope cannot be empirically demonstrated, it must be morally chosen. That is to say, we cannot demonstrate the reality of our hope based upon statistics, based upon data, based upon current circumstances. We choose to be hopeful. We choose to stand in the lineage and legacy of Septima Clark. We choose to stand in the lineage and legacy of Bayard Rustin. We choose to stand in the lineage and legacy of the Reverend Dr. Martin Luther King. We choose to stand in the lineage and legacy of Fannie Lou Hamer. We choose to stand in their legacy, and we choose to be hopeful. We choose to believe in ourselves. We choose to believe in our fellow students. We choose to believe in our faculty. We choose to believe that we have the capacity to bring about the world that we deserve. We choose to believe that. So hope is not empirically demonstrated. It is morally chosen. In this moment, were we to simply read the dry statistics, we might despair when we take note of the fact that a young Black man is 21 times more likely to lose his life at the hands of the police than his white counterpart. We could choose to despair were we to take note of the fact that the 6th leading cause of death among Black men is police homicide. That's not unlike cardiovascular disease or diabetes or any of the chronic maladies of the poor. Police homicide is such a threat to Black lives. Were we to simply survey the social scientific literature and take note of the fact that Black men are the most prominent and perhaps tragically preeminent victims of police homicide, but we also note that migrants are victims of police brutality. We also note that immigrants are victims of police brutality. We also note that members of the LGBTQ community are victims of police homicide. We also know that trans folk are particularly victims of police homicide, that Muslims are victims of police brutality. We take note of the fact that there is this multiracial, multi-ethnic community of victims of police brutality. We could despair if we take note of the fact that every year, year in and year out, 1,000 people lose their lives at the hands of the police. But I want to remind you that on this day, we are convening a symposium to take up what we can do, how we can stand, how we can lawyer. And so I want to say to you, the mere fact that we are gathered virtually, and the fact that we are gathered virtually on this digital platform does not in any way suggest that we can't smile at one another, that we can't applaud the progress that we are making, that we can't cheer the steps that we are taking, that we can't commend the dreams that we are envisioning, that we can't celebrate what we can do in this moment. That gives us hope. That gives me hope. Now, somebody who spent a little time in Minneapolis after the death of Jamar Clark, is somebody who went to the home of the mother of Philando Castile. And I went with a group of ministers to pray for her. And she took it upon herself. She had the moral temerity to pray for the preachers, to pray for the ministers, to pray for me. That gives me hope. So I am not inclined, and neither are you, and neither can we give up in this moment. So we choose to be hopeful. In this moment, I want to suggest to you that there are a number of things that we can do to transform American policing and certainly seek justice in the name of George Floyd, in the name of Breonna Taylor, in the name of an Afro-angelic 12-year-old Tamir Rice, in the name of Walter Scott, in the name of Sandra Bland. There are things that we can do. I want to suggest to you at the very outset that we think about, that we morally imagine a shift, a tectonic shift in the model and modality of policing and indeed criminal justice in this country. Moving away from mere punishment, from mere incapacitation, a mere deterrence, to a transformative justice model of policing. And yes, that could mean, should mean defunding policing that does not work in favor of policing, or to say funding public safety, broadly conceived, morally imagined, that does work. I want to suggest to you that we take up what I might call a Hippocratic model of policing. And what I mean by that is when we consider that for every police homicide, for every hashtag, there is the victim immediately before you, the family immediately before you, but beyond that family, beyond that victim, surrounding that victim, surrounding that family are children. So when we think about Tamir Rice losing his life at 12 years old on a playground carrying a toy gun, losing his life to a police officer who issued a police command inside a vehicle with the windows up, and then disembarked the vehicle and assessed Tamir Rice's dangerousness in under 2 seconds. Tamir Rice lost his life, but what about his schoolmates? So when we consider police homicides, the victims of police homicides and their families, we also have to consider the sea of children who are witnesses to this tragedy. And what social scientists tell us is that children's grades decrease, school attendance contracts, college enrollment literally is circumscribed and diminished, emotional disturbances increase. So in other words, for every instance of police brutality, for every instance of police homicide, there are undiagnosed, unrecognized, unseen victims that we call children. And so I would argue in this moment that we consider these victims, that we consider these patients undiagnosed and untreated called children, and that we consider the oath that doctors take, that is to say the Hippocratic oath, to do no harm. So in other words, if we had a form of policing that put the accent on the preservation of non-police lives, that is to say civilian lives, citizen lives. In other words, when police encounters a person on the street, the accent is put, the moral emphasis is put on the preservation of life. Do no physical harm, do no emotional harm, don't do no communal harm, do no psychological harm, do no harm to the person before you, the family before you, the community in which you police, the nation in which you police. In other words, an emphasis on a non-violent form of policing that has radical implications for how we define the appropriate use of force, excessive use of force. It radically redefines, reimagines how we police our communities in terms of the deployment of policing resources, in terms of over-policing, the allocation of police resources. It broadly, imaginatively brings more tools to the table. In other words, thinking about public safety in terms of social safety, community health, public safety. Yes, the social determinants of health, which also coincide with the social determinants of public safety. So in other words, radically reimagining how we police our communities. So I want to suggest a Hippocratic model and modality of policing. Related to that is, of course, disrupting the school to prison pipeline. Related to that is radically diminishing the ways in which we police our communities. So that literally Black folks are not regarded as the objects of suspicion, but rather subjects of protection. I want to suggest to you in this moment, in this symposium, that we think about the full range of tools. We, of course, have to think about how we ensure the police. When a city like Chicago, in the span of but a few years, pays out $750 million for police brutality. When a city like New York spends literally $500 million in a few years for police brutality, in small towns and medium-sized cities, we have to think about ensuring the police departments in ways that call for accountability. So in other words, it's activists calling for accountability in the streets, yes, but also insurance companies calling for accountability in the suites, through premiums, through radical changes in policing. That we can do. I want to suggest in this moment that we bring an imaginative set of tools to the table. That is to say that we have the empirical beside the narrative, those who engage in storytelling beside those who engage in data collecting. In other words, we need economists, we need activists, we need demonstrators, we need lawyers, we need social scientists, we need teachers, we need doctors, we need nurses. We need a full range of professionals and laity at the table, and of course, the faith community calling for radical transformation of policing. In other words, we have to be multidisciplinary in our advocacy strategies. But in being multidisciplinary in our advocacy strategies, we've got to be multilingual, which is to say the folks who engage in data collection need to tell stories on occasion. And the folks who engage in storytelling have to cite data on occasion. In other words, when you think about this conference, when you think about this symposium, when you think about this diverse collection of voices and moral actors, we have to think about breadth and depth in this moment. And in so doing, within us, there's an agency, a power, a vigor that allows us to hope and to believe and to transform our present and our future. I've said a little bit, but I'd be less than the clergy person I claim to be if I didn't end on a benedictory note. And of course, you recall, and I know Mark, Professor Osler, as a lay preacher, knows all too well that benediction simply means good words. So I want to leave you with benedictus, some good words. Some of you may recall in the Christian scriptures, a story found in the Gospel of John about an arrest. And you understand that with an arrest, to effectuate arrest, quite often police officers identify themselves and then apprehend the suspect. In the book of John, a militarized police force, that is to say the temple guard, as well as regular police, the Roman soldiers and the temple guard or temple police, church police, if you will, went to apprehend Jesus. And so we have this militarized police force armed with spears, armed with lanterns and swords, roughly equivalent to tear gas, tasers, and guns. And so this militarized police force goes to apprehend Jesus. And the reason they seek to apprehend, to arrest Jesus, is because he's guilty of fomenting an insurrection. It was thought to be a political insurrection, to a plot, an effort, a threat to subvert and undermine the political order of the day. This was the reason given for taking Jesus into custody. But you'll recall in that story, rather than the police posing the question to Jesus, that is, give us a solid form of photo ID, give us some government issued ID, prove who you are, say who you are. You recall in the story, though the police go to apprehend Jesus, Jesus poses the question of, who do you say that I am? In other words, Jesus asserts his identity, calls into question the arrest. I want to suggest to you that this modest little story in the gospel speaks to us in the present moment as we grieve and advocate in the name of and on behalf of George Floyd, which is to say, in the same way that Jesus demonstrated a holy boldness, he challenged authority. In the same way that Jesus was apprehended, he was arrested. He was subject to the death penalty because of his perceived threat to the present order, so will you. If you engage in prophetic lawyering, that is to say, if you lawyer if you litigate, if you file briefs, if you draft complaints in the spirit of Isaiah and Jeremiah and Amos, that is to say, if the subtext to your text is let justice roll down like waters and righteousness like a mighty stream, you will come under suspicion. You will be challenged and threatened by the present order. So I want to suggest to you that as prophetic lawyers, as prophetic law students, there will be those who challenge you. But may I suggest to you also that Jesus was not guilty of a political insurrection as such. He was guilty of fomenting an insurrection of hope. He was guilty of upending the present order to free people, to bring about justice, to give people a sense of dignity. And as such, he was guilty as charged. And so to this symposium, on this day, I want you to be guilty of inciting, igniting, inspiring an insurrection of hope. Don't apologize for it. Don't be in any way feel ashamed of it, because what you do is critical to the kingdom of God in this moment. And I say that for those of you who are agnostic, for those of you who may be atheists, for those of you who may be Catholic or Protestant, Jewish or Muslim, anybody of any faith who has faith in the moral agency of humanity, foment, incite, inspire an insurrection of hope. You give me hope in this moment. And with that hope, we can literally bring about fundamental change, fundamental transformation in our criminal justice system and in American policing. I can't empirically demonstrate that, but I can say, in the name of, on behalf of, in the spirit of our foremothers, our forefathers, our forebears, and this present generation, we can do that. And in the work that you do, the words that you speak, I have my hope, and I ask that you place your hope there as well. With that said, thank you.
Thank you so much for taking your time to speak with us today. We will now be breaking for lunch, and we will come back around 1. Thank you.
Thank you.
President Brooks, that was extraordinary.
Hey, my friend, how are you?
I'm great. Thank you so much. You captured the spirit of what we hope for here. So I hope to see you soon.
I hope to see you. And thank you for just phenom work.
Well,
phenom.
Right back.
I just want to echo those sentiments. Great job, President Brooks.
It's good to see you, my sister.
Good to see you. Well, you know, I've been with a lot.
I got to get my gear right. You know, I'm just a suit and tie kind of guy, but I'm seeing you in that.
Don't complain, activate hat.
You said what?
We have to get you a don't complain, activate hat.
Yep. Send me a hat. You know, my address is online. Just send it to me.
Okay.
Yeah, I would be blessed by that. And look, be encouraged. Yeah, I remember my law school days.
You know, and honestly, I am so encouraged. God is good. Honestly, you know, you never know what you're going to be triggered on. I wasn't even expecting that. But, you know, everything happens for a reason. So it's out there.
It's out there. It's out there. Well, thank you.
Good to see you.
Good afternoon and welcome back. We'll now present our first panel of this afternoon, State Legislative Reforms, moderated by Professor Rachel Moran. Professor Moran is the founder of the Criminal and Justice Defense Clinic here at the University of St. Thomas. She is a much sought after mentor among the students and a role model. Thank you, Professor Moran. I will turn the microphone over to you.
Thanks so much, Rachel. And thank you to our panelists. If they don't mind turning, if you're a panelist for today, if you don't mind turning on your video, that would be great. I am really excited for the next hour, our panel discussion this afternoon on legislative efforts to improve police accountability. I'm an associate professor here at University of St. Thomas. My area of research and scholarly focus is on police accountability. So I'm especially delighted here today to play the small role of moderator in a panel featuring three women who have been in the metaphorical trenches of state and local efforts to improve police accountability. So I'm going to begin by just introducing our panelists, and then we can get started with the questions. Our first panelist today is Colorado State Representative Leslie Herod, if you don't mind waving. Representative Herod was elected in 2016 as the first LGBTQ African American in the Colorado General Assembly. In those 4 years, she has passed 68 bills addressing criminal justice reform, mental health, addiction, youth homelessness, and civil rights issues. Some of her signature work includes ending cash bail for minor offenses, defelonizing drug possession, providing free menstrual hygiene products to inmates in Colorado's prisons and jails, and what we'll be focusing on mostly today, passing a comprehensive police accountability bill following the murder of George Floyd. Representative Herod is a chair of the House Finance Committee, vice chair of the House Judiciary Committee, chair of the Committee on Legal Services, and chair of the Colorado Black Democratic Legislative Caucus. Thank you, Representative Herod, for being with us today.
Thanks for having me.
Our next panelist is Cynthia Conte-Cook. Ms. Conte-Cook is a civil rights litigator and former public defender, most recently at the Legal Aid Society of New York. In that position, Ms. Conte-Cook led civil rights, federal and state actions, and also pioneered a first-of-its-kind public database called CAPSTAT that tracks misconduct by New York City police officers, providing a critical means of transparency to an issue that has historically been shrouded in secrecy. That's originally how I got to know Ms. Conte-Cook's work, is through shared scholarship on issues of access to police misconduct records. Her work on CAPSTAT has been featured in the New York Times, the New York Daily News, El Diario, and is being replicated by public defender offices across the country. From 2018 to 19, Ms. Conte-Cook served as a Data and Society Fellow, where she worked on topics related to surveillance in the intersection of technology and social justice. And she's currently a tech fellow with the Ford Foundation's Gender, Racial, and Ethnic Justice team, working to support the mass incarceration team's efforts to advance police accountability and better understand and respond to algorithmic biases in bail, sentencing, and parole considerations. Ms. Conte-Cook is speaking today in her personal capacity and not on behalf of Ford. Thank you for being here. And our final panelist today is Minnesota's own House Representative Rena Moran. Representative Moran is the chair of the People of Color and Indigenous Caucus, the United Black Legislative Caucus, and the Health and Human Services Policy Committee of the Minnesota House of Representatives. In 2010, Representative Moran became the first African American to represent District 65A, which includes the St. Paul communities of Rondo, Frogtown, Summit University, Thomas Dale, Midway, North End, and Cathedral Hill. She holds a Bachelor of Science in Early Childhood Education from Southern Illinois University and is a graduate of the Bush Foundation Fellowship, the Humphrey Policy Fellowship, and the Henry Toll Fellowship. On a national level, Representative Moran serves as the Executive Secretary of the National Black Caucus of State Legislators, the Midwest Region Coordinator for the National Organization of Black Elected Legislative Women, and the Minnesota State Director for both the Women Legislators Lobby and the National Foundation for Women Legislators. And although Representative Moran and I share the same last name, we are unfortunately, for my sake, not related. So you can see that we have a really impressive group of panelists today. What I'm going to ask you to do is start off with a relatively simple question. Well, it feels simple to me, but just asking you to describe for the audience the recent efforts you've been involved in to reform policing through legislation. And for that question, I'll start with Representative Herod.
Well, thank you so much for having me. I'm excited to speak with you all today and to be on this panel and learn from the panelists as well. I'm State Representative Leslie Herod. I represent House District 8, which is in Central and Northeast Denver. I'm also proud to be the first African-American LGBTQ person to hold elected office in Colorado. And I bring that to my work every day. So I will start by saying I'm extremely proud to chair the Black Caucus and to be able to pass Senate Bill 217 with my Black Caucus members leading the charge alongside my Latinx caucus colleagues. Senate Bill 217, the Law Enforcement Integrity Act, really came about after the murder of George Floyd, but also grew after the murder of Elijah McClain and Devon Bailey. Both died at the hands of law enforcement and first responders, and both have yet to receive justice because our system does not guarantee it. And so what we did was we ran Senate Bill 217 immediately after the protest started, because we heard clearly what Coloradans were asking for. They were asking for accountability for law enforcement. So what Senate Bill 217 does, it does a lot of things, quite frankly. So I'll try to keep it short. But what we did was we required body cameras by all law enforcement officers that are interacting with the community. By 2023, we also were requiring the release of the body camera footage within 21 days in most instances, and 45 days if there's an ongoing investigation, 45 days max. Additionally, we have a lot of racial profiling data that we are now going to be collecting in the state. We have changed the entire use of force statute so that fleeing felon is no longer something that is a justifiable excuse for murder in Colorado. So we rid ourselves of the fleeing felon laws, which was directly related to the Devon Bailey case. We also got rid of chokeholds, which was also used in the Elijah McClain murder, along with the ketamine, which we're still going to be dealing with in the future. And then we also said if there is an officer who has excessive use of force ending in serious bodily injury or death, and that they actually are no longer able to work as a law enforcement officer in Colorado again, their post-certification, peace officer standards and training certification will be removed and revoked. We also required a duty to intervene. So law enforcement officers have to intervene when they see their fellow officer acting with excessive force, and they must report it. If they don't, the minor offense that they could get is a misdemeanor offense, but they could also be charged with the higher crime if the evidence supports that, which could be a murder as well. And then they also could stand to lose their certification if they didn't act to intervene. Additionally, one of the bigger pieces is, well, let me say first, we also gave pattern and practice investigation authority to the Attorney General in Colorado. That provision is already being used in Colorado. The Attorney General immediately, within days after announcing the passage and the signing of this bill into law, put Aurora Police Department under a pattern and practice investigation, and basically said that if they don't change their policies and shape up, that they will be sued. And that investigation is still ongoing. The Aurora Police Department was over the Elijah McClain incident, but also some of you might remember in Colorado after Elijah McClain, the protest where there was a peaceful violin protest, they came and raided that protest and caused harm to the community. So they are immediately under investigation. And then what I think everyone really is interested in is the qualified immunity. So we are the first state by statute to eliminate qualified immunity for law enforcement officers at the local level once and for all. So we no longer have that as a defense and keeping cases from moving forward. Additionally, if an officer acts in bad faith, they have a $25,000 personal responsibility or 5% of the entire settlement. So that's huge. So we dealt with both the civil and the criminal side, as well as internal policies and practices in this bill. Of course, there are a lot of other provisions, but those were the main provisions that I wanted to touch base with you all on today. But we're really proud of the work that we've been able to do in Colorado. A lot of the provisions are immediately went into place upon passage. The governor signed the bill into law on Juneteenth, acknowledging the historic significance of the bill, but also the direct impact it has on the African-American community. And so just really proud to be able to lead that effort along with my colleagues. We passed the bill with bipartisan support, meaning that we had Republicans actually sign on as co-sponsors of the bill, but additionally, we had only 2 no votes in the entire Senate of 35 members, and I believe 11 no votes of 65 members in the House. So we plan to continue to work on reform, and again, that's why I'm so excited to hear from you all today about the efforts you're working on, and I will definitely probably be putting them in my pocket to bring back to session in January. So thanks so much for having me. I look forward to the discussion.
Thank you, Representative Herod. And I'll just say briefly, I taught for 3 years at the University of Denver Law School before coming out to Minnesota, and helped run a criminal defense clinic that did a lot of litigation against the Aurora Police Department. So I have some feelings about that department as well, and I'm thrilled to hear about the pattern and practice investigation. I'm going to turn to Ms. Conti Cook next and ask you the same question: recent efforts you've been involved in to reform policing. And I'm particularly interested, of course, in your work around New York Civil Rights Act 50A, which you can, I'm sure, tell the panel all about.
Yeah, I'm happy to. And thank you again so much for having me here to speak in my personal capacity. So 50A is a New York state law that was enacted in 1976 with a wave of police officer Bill of Rights campaigns happening across the country. And it was also in response to new public access laws that were passed in New York State in 1974 and in a 1975 court holding that found that on-duty police misconduct is not an unwarranted invasion of privacy under the public access exceptions. The 1976 law 50A in New York State was basically a prohibition on getting public access to police misconduct records. There were some arguments up until recently that it could be sort of narrowly read, but in 2018, there was a Court of Appeals, which is New York State's highest court. There was a decision that sort of slammed down all of the narrow ways to interpret 50A and was like, nope, 50A is a privacy law. It's a statewide privacy statute that gives officers like a blanket prohibition on all information of their misconduct histories being released publicly, period. And so really as a result of that decision, it became very clear that there was no more remedies that courts could really give us, that the remedies had to come from the legislator. To back up a little bit and give you some background as to like how I became involved in this work, I was a civil rights attorney for 7 years, starting in 2007. And then I went to the Legal Aid Society in 2014. And I really went to the Legal Aid Society in order to expand access to police misconduct information, because I felt like it was such a large unknown piece of the equation of what is happening in communities all across New York City and all across the nation, really. And secrecy laws have been implemented by police across the country in order to make it that way, right? This wasn't just like accidentally an unknown thing that we haven't really been paying attention to. Prosecutors were supposed to get access under 50A. There was a small exception under 50A that allowed defense attorneys to petition courts for judicial subpoenas in order to get that information. But the reality on the ground before 50A was repealed was that police misconduct info was very hard to get, even in court cases, because judges would deny access and claim that our attorneys were on fishing expeditions, and cases were often, like civil rights cases were often settled before information about police misconduct was turned over. And then police wouldn't even sometimes share that information with prosecutors until their case was going to trial. There was a public letter from the Manhattan District Attorney's Office to the NYPD in 2018 saying like, hey, we realize that you don't think we need misconduct information until the day before trial, but we think we need it earlier in our investigation, and you have to give it to us. And they almost litigated that issue. So the first thing that we did at Legal Aid to sort of push back against 50A, like you said, was to create a defender database that served our attorneys in fighting and winning more motions for police misconduct information. And then when we would win that information, we would have it stored in our database so that other attorneys could just go to it and advise their clients like way before the day before trial about what their trial might look like and about what types of risks the officer who was going to be the witness on the stand brought to their case that they should be aware of when considering whether to plea or whether to fight. This also is something that we used to seed investigative reports with journalists, and there were big reports from BuzzFeed about history of disciplinary information, and also from the New York Times about the history of perjury happening inside of the courtrooms, and how many officers had like repeat histories of lying in court, and we're still on the force, and we're still making arrests, we're still hauling people into court. And then we made a version of this database public. So capstat.nyc was the first database in New York City before the many that followed sort of the repeal of 50A. And we didn't have all the internal misconduct information. So if you look at cities like Chicago that has the Invisible Institute Citizen Police Data Project, that has 30 years of internal misconduct information that they've made public. But because we didn't have access to some data set like that, we took what we had, and we had federal civil rights lawsuits. And so we were taking that information and making a database of all the lawsuits that officers have been named in. We were tagging things with the type of misconduct. So you could sort of like really identify patterns across multiple precincts. You could identify patterns across officers. We had a social network that showed you how clusters of officers operated together. And that was really the start of dispelling this myth that transparency around police misconduct is somehow a dangerous threat, which is what a lot of the police unions often argue. At the same time, my advocacy was really generating a lot of lost lawsuits. Most well known was the lawsuit we brought for the misconduct history of Daniel Pantaleo, the man who killed Eric Garner with a chokehold and left him to die on the ground. We initially actually won that lawsuit in court, but Mayor de Blasio's law department appealed, and we lost on appeal. But this did put the issue in a spotlight, right? How come New Yorkers can't know the very relevant fact about whether the city and the NYPD, and not just Officer Pantaleo, contributed to the event of Mr. Garner's death by ignoring very visible red flags about that officer's prior behavior? A leak to a media outlet actually showed that Pantaleo did in fact have more substantiated misconduct than average officers, and specifically a history in unlawfully stopping and frisking people, which was the type of encounter that he started with Mr. Garner. And so that led to a series of law review articles and scholarship that you referenced. And I wrote about the subject of police misconduct transparency, but more importantly, the harms of police secrecy and how many ways a family is re-traumatized when the reputation and the image of their loved one is smeared by police in the press, when they are accused of being violent, or they're accused of being any number of things, right? Like we've all seen the news and how they really weaponize their public relations unit against people who've been harmed by police in order to try to win in the court of public opinion. And in scholarship, this was also something that was sort of a fight, right? I had to push back against some arguments that police misconduct information should not be something that's public, that it should remain in the forum and leave judges and lawyers as the gatekeepers of that information. In 2014, there was an Open Government Agency report, which was a watchdog of all like freedom of information, public access issues. They named 50A as an obstacle to public oversight and made 2 recommendations for addressing 50A. Both of these became separate bills introduced by Danny O'Donnell in the Assembly. They sat with like no real activity happening until a grassroots community organizing coalition got involved around 2017. And it was around then that they really took this over. And I was involved in a lot of the organizing and a lot of the advocating in Albany as well. But these efforts were strategically designed by and led by the community groups, and most importantly, by the families who lost loved ones to violence. And that wasn't just a capacity issue. It was really a strategic decision for the voice of the families to be the loudest in this call for repealing 50A.
Thank you so much. And just to put the law that Ms. Conti-Cook is referring to in context for the Minnesotans in the audience in particular, there's been a lot of you may recall a lot of consternation after shortly after Mr. Floyd's murder, when people learned that Derek Chauvin, the officer most directly responsible for killing Mr. Floyd, had a history of 18 prior misconduct complaints, and that the public couldn't get much information about most of those complaints. So Minnesota has a different law than 50A. It's not as extreme, but it is a law that has nonetheless been the subject of quite a bit of controversy, because it does shield the public from accessing any specific information. While we could access the number of complaints and the resolution of those complaints, all of the ones that resulted in no discipline for former Officer Chauvin, the public could not access specific information about the basis of the complaints or the investigation. So that's Minnesota's equivalent records law that is not as extreme, but in some ways very similar to the law Ms. Conti-Cook is referencing. Now I'm going to turn to Representative Moran, who has been very involved in efforts to pass legislation since, well, certainly before Mr. Floyd's murder, but also since, and just ask you to describe some of the efforts you've been involved in.
All right, thank you. And again, thank you, Rachel, for the invitation to be here today. I was looking forward to this, not because I am the expert on this, but because of the relevance of this subject area. We do share the last name, and who knows, right? So just maybe relatives somewhere in there. So a little bit about me first before I start, just to set a context. I am, more of a child, family, community advocate. I do all my work through a race-conscious lens, and my job is to always fight for social, racial, economic, and environmental justice, and to look at laws that has been disproportionately impacting our community through all those entities, whether it's public safety, healthcare, education, whatever that subject area is. And I've done a lot of work in many areas. And I found myself this session after the murder of George Floyd as the chair of our Posse Caucus, which is the People of Color Indigenous Caucus, and also as the chair of our United Black Legislative Caucus, to find myself being in this place where our Posse Caucus was leading on police accountability. And so I'm really appreciative of our Speaker of the House giving our Posse Caucus the ability to lead on police accountability, stating what that needed to look like. And so after the murder of George Floyd, and let me just say our chair of public safety, Carlos Mariani, had been doing some work around police accountability. But in the state of Minnesota, we are the only legislature that is a divided legislature in the country. The only. We have a Democratic House, and we have a Republican Senate, and our governor is also a Democrat. But as you know, in order to pass any bill, you have to have the partnership in the House and the Senate to move legislation. But we was able to do this, and I will just talk about what we did for right now. So our Minnesota Police Accountability Act of 2020 came out of the murder of George Floyd. And what we wanted to do is that we really wanted to show the breadth of what is needed to do around police accountability. We couldn't just move 1, 2, or 3 bills. We looked deep, and each member looked at what we believe needed to happen in order to create a comprehensive bill. And so we divided the bill into 3 sections. The first section was about reclaiming community oversight. And that was about putting the power into the hands of the people and neighborhoods that police officers are sworn to serve and protect. And under that, we had 4 bills. It was retroactive repeals of statutes of limitation, because, families are losing loved ones. And by the time that their case have come, and usually what has happened, the police is not charged, and then the family has to figure out now how they're going to take the police officer to court. Well, usually that time limit has expired, and you know, so families are sitting in that grief. And so we wanted to repeal that statute of limitation. Under that, we had the warrior training, you know, with this mentality, you kill before you be killed. So they seeing, you see communities and individuals in the community as the enemy. The chokehold bill, a duty to intercede, police residency reform, the data collection regulatory reform, and arbitration reform. The second category was reforming accountability, and under that was titled Restoring Confidence and Trust in the System that are meant to provide justice for all Minnesotans. And under those categories was the use of force bill, prosecutory reform, investigatory reform, and cash bail reform. And then the third was reimagining public safety, ending the unacceptable culture that is responsible for the murder of George Floyd and so many, and far too many others that looks just like George Floyd, that looks so much like me. And under those was 6 bills: public safety peer counseling debriefing, police officer critical incident review, community-led public safety, a mental health training, autism training, and restore the vote was under those categories, for a total of 18 provisions that we had moving through the body at one time. Of those 18 provisions, we was able to pass 11 of those provisions. And the 11 provisions that we was able to move through the body was the warrior training, which is prohibited. It had been prohibited, but we had like the Minneapolis union chief who were, you know, going outside of the training and hiring someone to come in to train police officers in that warrior type training. And now there's some accountability if that was to happen along with the warrior training. The chokehold ban was also passed, a duty to intercede. Representative Herron, you talked about that the whole duty to intercede. This was just like common sense stuff that we know has just been really excessive. Police residency reform. We really believe that, you know, we want to see police officers to be a part of the community that they are policing. They need to live in that community or live within a municipality of where they're going to be working. We did the regulatory reform and arbitration reform. Arbitration, we value and recognize unions, but when we look at the police and the union piece of not being able to hold police accountable, we set them aside and look at them through a different lens that is different from protecting, you know, your rights to work, making sure you have health insurance and livable wages, because police have the inherent right to serve and protect. And when that right is abused, there needs to be consequences for that. There needs to be some accountability put in place. And we was able to move some arbitration reform. The investigatory reform, we also passed public safety peer counseling debriefing. We recognize that being a police officer can be traumatizing. It's a job. So they need to be able to do some counseling without being looked at and saying, well, you're dealing with some trauma, and because, you know, it was a negative. We don't want it to be a negative. We want them to get the services that they need. Mental health training and autism training were both passed. Autism is different from mental health. And so we wanted officers to be trained because over 50% of the excessive use of force was used with someone who's going through a mental health crisis. And so we wanted officers to be aware of what that training needed to look like. There was something else I wanted to say in the midst of all of this. All the work that we did around police accountability, we did it through the lens of human rights and the sanctity of life. So we continue to bring up sanctity of life, sanctity of life. Yes, we believe that police officers in their work or we would like to see them go home with their family, but also the person that they encounter needs to also live another day, or they need to be put in a squad car, they need to be arrested, but we want to make sure that that life of that individual is preserved, is at the forefront of how we police across the state of Minnesota. And I would just stop there.
Thank you. One of the common threads I'm hearing from the three of you is the successful passage of bills, or in Ms. Conti in New York's case, the repeal of a problematic act, relatively in somewhat remarkably short time period after Mr. Floyd's death. And so I'm curious if any of our panelists want to weigh in on this. If you saw ways in which Mr. Floyd by no means is the first person or the first Black person to die a tragic death at the hands of police. The other panelists mentioned people in their own states as well, and those are just a few, of course. But if you saw a sort of a shift in motivations, or a way that Mr. Floyd's death in particular motivated the efforts that you were already engaged in, or that you engaged in shortly afterward, whether it personally motivated you, or whether you just saw a shift in the way people were talking about police accountability bills. If anyone wants to weigh in on there, I'd love to hear.
Well, let me start. Okay.
Okay, we'll have Representative Moran and then Representative Herod.
Yeah.
So as you know, George Floyd, we're ground zero.
Yeah.
And there was definitely an outcry. You know, yes, George Floyd was not the first person to be killed by a police officer. He was not the first person to be on camera to and seeing, you know, that incident happen. But I think that just the ability for us to see on camera, all our police officers, we passed a few years ago that they would all be equipped with cameras, and we paid a lot of money for that to happen, right? And believe it or not, we have this narrative going on now here in Minnesota saying maybe what we saw happen to George Floyd really was not what happened, right? So they want us to doubt what we actually saw. But for us to be able to visually see George Floyd with Chauvin's knee on his neck, take his last breath and die right there in front of us, where it really absolutely did not happen. And for the first time, I think for many of us who are Black, you know, that's something we know has been happening for centuries. But for our white population to see that and think, you know, in their head, well, you know, yeah, you know, that person was killed, but they did something wrong, which is why it happened. We was able to clearly see that George Floyd was on the ground and the police officer's knee was on his neck. And it did not have to happen. So it was, for many of us, it's just a clear murder. He intentionally kept his knee on his neck to ensure that he would not get up and move from that space again. And it was just a clear outcry. It was a clear outcry, the marching and the protesting that not only happened in Minnesota, but happened across the country, happened across the world. We were ground zero. And so as we went into negotiations with our Republican colleagues who were not on the same page that we were on, who were still focused on, you know, supporting law enforcement, who was still strong on public safety, it became really in the beginning very difficult to move them with a sense of empathy, right? To have them to feel something and to believe that something had to be done immediately because the world was watching us. And there was no way that we was going to move and introduce maybe one bill or two bills. We had to like do an overhaul, and we was really clear that within our bills that we had to have some systemic change that had to happen, some institutional change that had to happen, because racism is not just an individual problem. Our issue is an institutional racism that is happening within our systems. And so that piece came about when we worked with the post board to overhaul our post board, who have the power to suspend, to fire, to bring charges against officers, but had not done it, had not utilized that power that they had. And so the institutional change that happened within the post board, that we was able to add more citizens onto the post board. The Republicans wanted us to not do anything around most of those bills, from the use of force to the chokehold to revamping the post board. Instead, they wanted us to just hand that over to a post board and let them decide what needed to happen, because they had that inherent right to do it, but had not done it in 40 years, I believe. That was, or however long they have been around, had not happened. So our positive caucus, leading our House caucus, was really, really adamant that, one, we had to lead this conversation. The community has been impacted by excessive use from police officers, needed to be the one that was leading this conversation, leading the bills, negotiating with the Republicans on how we needed to create the outcomes that we felt that was needed for our community. And it was not an easy process. We went through a couple of special sessions before anything eventually happened. Our first session, the Republicans, we came together, we moved some bills, we came together, and the Senate called us together for our very first negotiating meeting, myself along with Representative Carlos Mariani, who was the chair of the public safety. And as we walked into that room, I just end with this, as we walked into that room, there was 3 Republicans, there were 4 Republicans present, 2 Republicans from the Senate and 2 Republicans from the House. And myself, as an African-American woman, walked into that room where we were going to negotiate, along with 1 Latina representative. And as we sat down, I could actually feel the arrogance that was in that room. It was so heavy as we walked in there, as they sat there, I can feel the arrogance exude from them. And so that inequity that we walked into was present there immediately. They walked in and they called us to meet with them. And immediately, no one is saying anything. You call us into this room. And so we're expecting you to open it up. But we found ourselves opening it up. And they said to us immediately as we open up, we're here to negotiate. Where are you with this process? And their statement to us was, we have not read your bill. Total disrespect that I felt as a legislator who have been called in to negotiate. And your statement to us is, we have not taken the time to read your bill. Why are we here? And so our statement to the Republicans at that very moment was, well, you need to go back. You need to take the time. You need to read the bill. And when you have read that bill, then you need to come with an offer to us about how we're going to move in this body. And several hours later, they came back with 5 proposals of what they could support. And they said to us, this is our only offer to you. And you cannot change any of the language. Here you go. We looked at them and we said, well, again, we want to reiterate, anything that we do has to be about systemic change. We said it 5 different ways because they seemed to did not understand what we were saying. We said it 5 different ways. And we said we will look at what you propose and we will get back with you. They said to us, how long would that take? We said, well, give us 2 or 3 hours and we'll see what we can do. And so we came back with some agreement around the 5 proposals that they put together. And we added probably about the other 12 initiatives that we put forward about what we needed to move on. And those negotiations went back and forth and through our and then we ended up adjourning because they did not respond to our counter offer to them. And so that led us into a second special session where eventually out of the 18 provisions that we put forward, we was able to come out with the 11, realizing that who we was negotiating with and recognizing that this was only a start in a bipartisan effort, but there was still so much more work that we must do, that we have to do, and that we still have a community of people who feel like it definitely did not go far enough. Sure, we believe that also, but it was a beginning under the circumstances that we were in, and that for us it was a huge victory because there was huge pushback from a Republican who said, we don't care about this issue at all. This really is not important to us.
Thank you. And Representative Harrod, I know you wanted to weigh in on this, and I'm curious about your potentially different experience. I don't want to put words in your mouth, but you talked about the remarkable passage of the Colorado Police Accountability Bill that had actually quite a bit of bipartisan support. So I'd love to hear from you on this question, how Mr. Floyd's death and the surrounding responses impacted your efforts.
Yeah. Well, I got to say that George Floyd awoken the nation, right? I mean, this wasn't an isolated incident anymore. And I believe it's because people were facing this dual pandemic of COVID and racism, right? And as Black folks experienced it more personally, we took to the street. So I'll say that I am not an attorney, although I do play one in the General Assembly sometimes. It did take the work of many attorneys to help me figure out a bill that would have a lasting and real impact on the way these cases proceeded and also on people's lives, right? But I will say I do have experience in the criminal justice system because my sister has spent about 30 years in and out of prison. And so this is really why I do this work. And so when George Floyd was murdered and the protests started, the General Assembly was actually on a temporary recess because of COVID. And we came back that week. And on Thursday, really, the protests started in Colorado. So we came back, I believe, on that Tuesday, and the protest started on that Thursday. I remember going outside. We adjourned early for the day because I think people were afraid of what might be going on outside the Capitol building, so they wanted to get out of town early. I went outside about 4:30 to participate in the small protest that was gathering. And in that moment, probably about 15 minutes after I got out there, someone shot 8 gunshots into the crowd. An agitator. We have seen quite a few of them in Colorado as of late. And I was, rushed into the Capitol, the Capitol was put on lockdown. A bullet did go into the building. And it was quite a traumatic moment. And in that moment, after it happened, we had a Zoom call, very similar to this. You guys know this Zoom life that we live in now. And my colleagues, my Democratic caucus colleagues, asked me if I was doing okay and what they could do for me and how traumatic it must be and all this stuff. And I remember telling them that I don't need their niceties. And I don't want to hear their stories about racism. What I wanted was a bill. And I wanted them to sign on as co-sponsors of the bill before introduction so that we could guarantee its passage. And to my surprise, and maybe to the chagrin of the speaker and the majority leader, they said yes. And that's when 217 started. However, I'm a House member, okay? And we only had a few days of session left to deal with the COVID pandemic. So making this a real priority and making it comprehensive was not easy. But because people were protesting, not only in Denver, but in Vail and in Aspen and in Grand Junction and literally across the state, we had members saying, I want to get my hands in this, I want to help out. But we also had those members who were a little nervous. And I think the nervousness came from both sides of the aisle, right? Not just Republicans, but Democrats too. But in the first protest that we had in Denver, because things erupted after the shooting, just erupted. There was one car that was targeted in the Capitol parking lot. It was a truck, and it was destroyed. And you could see pictures of people jumping on the truck and banging on it, destroying it. They thought it was a police vehicle. Instead, it was the president of the Senate's car, personal vehicle. And so when they're so you picture the next day, I'm outside, they're interviewing me about the shooting, and they're interviewing the president of the Senate, who typically is very conservative on these bills, but he's a Democrat. And they're asking him about his truck and, you know, the damage caused his property. And I was like, oh, here we go. And he turned to the camera and he said, I can replace my truck. We can't bring back the people who have died at the hands of law enforcement. And I turned to him and I said, I got a bill for you, sir. And I need you to start it in the Senate and just trust me on this. We went inside from that and we started working. Senate Bill 217 was born days later and passed within 16 days of introduction. So we started the bill in the Senate, and that took people very much off guard. The House was dealing with the budget at the time, and we did not have time to start it there. It took folks very off guard, but what they realized when they had some of the Dems that maybe were not so pro-reform, like the president in the past, he became a prime sponsor of the bill in the Senate. They realized that they had to negotiate. And with me, I only allow people to the negotiation table who are negotiating in good faith to make the bill stronger. If you want to kill the bill, you can do that and count your votes. But if you want to negotiate the bill, you can come in and let's have a talk. So that was a dynamic that we were working with. As it made it through the Senate, we did have a lot of support to make the bill stronger from the Republicans. And I do believe that they made the bill, that their involvement in the conversation made the bill better. And it did not weaken the bill at all. We lost 0 provisions of this bill. We lost 0. Instead, we had former officers saying, well, you know, you might want to be specific about that carotid hold, because sometimes we do the chokehold, but we also do the carotid hold. And you don't want to let anyone off on that. Or you might want to make sure that there is no intentionally covering of the body cameras, because, you know, some people spill coffee on their body camera or cover it up, and that should be included. And so that real practical application was extremely helpful. But I will tell you, there is 0 possibility of that bill passing if George Floyd did not happen, and then if the family members of those who were impacted in Colorado didn't step up and speak out in those protests. So then we started to see protests across the state just focusing on passing 217, because it was very concrete for people to chant for, right? That's probably one of the first protests I've seen, definitely of that scale, but where people had signs that said "in qualified immunity," right? What the frick is qualified immunity? Like, I cannot believe that this was in the conscience of everyday Coloradans. One of my colleagues said she received over 38,000 emails, okay? And also in that moment was when the Elijah McClain case came back to consciousness as well. And that is only because his mother had the courage to come stand next to me at a rally, take the microphone and ask why we didn't stand up for her son when he died. And that changed the conversation in Colorado. And so when the bill got through the Senate, we did a lot of negotiation. I'm talking everybody was hands-on, all hands on deck for 16 days. We had the lobbyist stationed in the Senate president's office for members to go in and out every single day, in the speaker's office to ask their questions, to get back to their local sheriffs about how this will apply, and making sure that they understood each provision. Never seen that happen before in all my years working in the Capitol, and I started as an aide at 20 years old. And so I found that really fascinating, but the best part of the moment was when we went to get, well, first of all, no clue we would get those Republican votes in the Senate. I didn't think they were going to actually vote yes, but I do believe that I laugh with one of the senators. I say, what Black woman got to you in your past? Who got to you? Because they knew, and no one was arguing that racism wasn't a thing. So they knew they had to address it, and they saw the videos too, right? And I was sick of people saying, well, George Floyd is bad, but that's not, that's not what we do. It's not normal, blah, blah. No, we have the cases in Colorado too, okay? So we need to address this. And then when the bill passed and that went through the House, we did not think we were going to have the Republicans sign on. And then the minority leader spoke, and he supported the bill. And then I took a break, again, to my majority leader's chagrin, and went outside the rules and stopped the debate and moved into proclamations, where we then gave a tribute to Shanine McClain, Elijah McClain's mother, and Devon Bailey's mother. And we talked about those cases on the floor, and they were there. And in that moment, you could tell the hearts and minds change and shift. And then we saw more Republicans sign on to support the bill. And so the thing was that we didn't give them multiple things to vote up or down. We said, you have one bill. Show where you're going to be on this one bill. And it had a lot of provisions in it, but you have to make your final vote on this entire bill. And they did, and we got their support. I tell my colleague, my co-sponsor for the bill, we had a lot of scenarios in our heads about what we were going to be willing to give up and what we weren't going to give up. And there was a lot more that we were not expecting to stay in the bill, or provisions to be weakened by some kind of qualifier. And we didn't do it. We didn't have to do it. And that's because of not only George Floyd, but the deaths in Colorado, the protests, number one, and then people just really stepping up and speaking out about their own personal experiences. And then allowing the conversation to happen a lot from the more conservative perspective too, and making sure that we were doing our best, not necessarily to bash the police, but to talk about integrity and how we can make the entire profession better. And I think that was hard for some folks to hear, but it's what we needed to do. At the end of the day, we got the bill passed, but also we did not provide any additional state funding outside of the original funding from the Colorado State Patrol for the bill, because we're in the middle of COVID, and I'll be damned if I'm growing police forces right now. Instead, what we need to be doing is reprioritizing the funding, and that's how we got that bill through. If we were to introduce the bill today, it would not pass in 16 days, and I don't think it would have passed in the way that it did right now. So we took a moment, we changed Colorado, we'll continue the work, but I think we took the heaviest, hardest hit and lift in the right time, and that's why we got it done.
Thank you. Thanks so much. We've got about 8 minutes left, so I'm going to give Ms. Conti Cook about 5 minutes to talk about how Mr. Floyd's death may have impacted efforts in New York. And then I'm going to ask everyone, if you've just got a 1 minute a tip for what's on the horizon for you. If you could accomplish one thing next, what would it be? So that'll be at the end. I'm just flagging for you now. That's the question I'm going to ask you to end really briefly with, but it's all yours, New York.
Thank you. And it's so helpful to hear about the experiences in other states as well. So in New York, 50A was repealed, I think on June 9th, which was within 2 weeks of when Mr. Floyd's death occurred. And it was, I don't think it would have happened without his death, without the coverage that specifically, even if there wasn't details available about the history of Chauvin's misconduct, the fact that there were news headlines that said that there were 18 misconduct complaints. New Yorkers understood in that moment, like, hey, we can't even find out a number about our cops. Like our cops that are killing people in New York, we couldn't even get like Pantaleo has X number of complaints here. And so the stark contrast between the meaning and the significance of those types of headlines and that kind of balance of the narrative that the availability of misconduct allowed made New Yorkers very acutely aware that 50A was no longer going to be accepted as status quo in New York State. And it was passed because of the protests. It was passed because there was already a bill, like you said, that people could like immediately start chanting. The pre-work that had been done before the protest to go to Albany on a regular basis and bring the families of police who've loved ones to misconduct, all of that pre-work was really just like teed up, and the protests like sparked it and really made it happen. But it was it was absolutely as a result of Mr. Floyd's death, a result of there being a scant amount of misconduct information available, the availability to contrast that in New York, and then the energy and the absolute ruthlessness of the protest energy in New York City, which I was, unfortunately, my father was in hospice at the time, and I was with him during that time. And so I was sort of very oddly distant from the middle of everything when it was happening, but of course, keeping up electronically and virtually and all of that. But it was 100% a result of the energy after Mr. Floyd's death. And I can start really quickly by saying what's on the horizon for me is really thinking about much more systemic transparency. So transparency around the amount of surveillance technology that's bought by police departments, and transparency around their budgets, and how those decisions are made about budgets. And I'll leave it there and let the legislators speak.
Thank you so
I mean,
much.
I can be really brief. And I'll just say, I agree with you 100%. And I forgot about the media coverage, because those journalists were out in the middle of it. And that made a huge difference too. I cannot forget about that. There's a lot more work to do. I mean, for so long, we were not appropriately looking at this entire profession in ways to make it better every single year. So we have so much more work to do. I also have an organization that I founded and created called Caring for Denver, which is the largest mental health and substance use foundation in the state. We have piloted a program called STAR, which is modeled after Eugene, Oregon, support team assisted recovery, where when you call 911 for someone who has a mental health crisis, you get a mental health professional and an EMT, not a cop. STAR has been in existence since June, and we have had 0 negative incidences and 0 reasons to call the cops for backup, but we have been called by the cops for backup multiple times. Most recently, the mayor of Denver has stepped out and said that they would match our $270,000 pilot with $3 million to expand the program to every single precinct in Denver by June of next year. And again, this is reallocating resources, not new money, which has been really exciting. And so what we need to do is we really need to reimagine policing, what that really looks like in our communities. But then on the other hand, we also need to make sure that the accountability is there when police break the law or violate the trust of the community. We need more statewide oversight. We need for the police to stop being able to police the police. And yes, I'm talking about DAs. And we really, really need to reform the entire training model. But make no mistake, we are not going to train our way out of this. This is generations of injustice that will not change through 1 or 2 trainings. We have to have the accountability mechanisms in order to really make sure that we're keeping our communities safe. So thank you so much for having me. I really appreciate the time. And I look forward to any questions y'all might have. Please feel free to reach out to me, State Representative Leslie Herod. Thank you.
Yeah. So for myself, there's a few things. One, we want to, first, let me just say, we need to come back and, we're working really hard to come back on the political side to get some majorities in the Senate and keep it in the House so that we can do some real reform that needs to happen around police accountability. We want to work on the restorative vote so that once a person is released from incarceration, they have the right to vote. We want to work on the cash bail for those low-level offense. People should not be locked up because they can't afford $50, $100 for a cash bail. It makes no sense at all. We want to continue to do some work around, as you talked about, making sure that for 50% of the excessive use, force of use, and so on in a mental health crisis, that we're not calling the police to come out for that. We're calling a mental health professional to come out and to respond to that and to de-escalate that process. And so I want to talk a little bit about our community-led public safety. And it's, never one time did we say in the legislation we want to defund police officers, because I personally believe, and there's so many of us believe that we need police officers. It's not like we don't need them still. But we can use this process to fund community advocates in the way that we are engaging community to be a part of what policing their community looks like. And you could do that easily, block by block, community by community, neighborhood by neighborhood. We have what we call in St. Paul community ambassadors. So we have a group of young people out in, in downtown St. Paul. And usually when those business owners want to call the police. Instead of them doing that, they'll call the community ambassadors that looks like them. They're Black folks who are from the community, who can give them the resources they need, who can make sure that they are doing okay in school and they are working with the family. That is a part of public safety, you know. So we're going to have to look at, again, how, as Representative Harris said, how we're going to reimagine public safety and what that looks like. And it does not always look like police officers showing up. It doesn't have to be that way. And so moving forward, we want to make sure that we're continuing to look at, to reimagine public safety and looking at what do a community-led public safety model look like, and have these deep, hard conversations, because for too long, we have created this really punitive process that we believe represent what we need to do to keep those people in order. And those people be like people that looks like me. You know, we can do this. And we need to really, I didn't mention that some of my work around the post board, that we also put more community folks on the post board. But we also created an advisory committee. And the advisory committee is, of course, made up community folk, police officers, those folks from the mental health. It was really intentional, but we had to work really hard to make sure that we had more community members on the advisory board than we had police officers on the advisory board who had the power, or have the power to bring some suggestions to the post board as part of their agenda when they meet. And that is really, really important, because community and law enforcement, we have to find a way to get them sitting down at the same table, listening, making decisions together. No one should have more power than the other, because if we continue this process where police officers are going to be policing police officers, we will continue to have oversight that does not work, that does not have the inherent power that they have to keep accountability, is not in place. So until we bring the two together to sit down, to hear and to listen and to learn from each other, I think unless we can do that, we will continue to have this tension between the two. I believe, and we believe in so much, that they definitely need to be at the table together to learn, to hear, and to learn, and to create policies together that not only support police officers and law enforcement, and maybe we can just also, by the way, get rid of the word policing. Right.
Representative Moran, I just want to thank you. I'm so sorry to cut you off, but I don't want to cut off the time of our next speaker. But can we just, if we were in person, I would be giving a loud round of applause for our three wonderful panelists. We did get a question from the audience about connecting with lawmakers. Feel free to reach out to me if you want to ask that question. I'm happy to try to field answers. And if our speakers are, I'll ask if they're willing to make their contact information available as well. But thank you again so much. Really appreciate your insights and the time you spent with us today.
Thank you so much for this opportunity. We appreciate it.
All right, so we will get started with our next speaker. For people who weren't here earlier, my name is Madison Fernandez. I'm a second-year law student here at the University of St. Thomas. I'm an associate editor for the Law Journal and a member of the Symposium Committee. It is an honor and a pleasure to introduce our next speaker, Judge Mark Bennett. Judge Bennett was a retired U.S. District Judge for the United States District Court of the Northern District of Iowa. He was appointed to the bench in 1994 after serving as a magistrate judge in the Southern District of Iowa. Before his time on the bench, Judge Bennett was a litigator in private practice, specializing in employment and discrimination law, constitutional law, civil rights and civil liberties, federal criminal defense, and representation of licensed professionals in ethical issues. Judge Bennett is now a law instructor at Drake Law School, the University of Iowa College of Law, Nebraska College of Law, and the University of Hawaii William S. Richardson College of Law. He is also an assistant professor at Western Illinois University and a visiting professor of political science and sociology, criminal justice program at the University of South Dakota. Judge Bennett graduated with a bachelor degree from Gustavus Adolphus College. He went on to receive his JD from Drake University Law School. Judge Bennett has presented at more than 500 CLE programs in 38 states and several foreign countries, and trained more than 2,500 state and federal judges on implicit bias across the country. His areas of expertise include federal and civil criminal litigation, implicit bias, federal sentencing, trial advocacy, and justice reforms and innovation. We are so happy that you can be here with us today, so please join me in welcoming Judge Mark Bennett.
Thank you so much for having me. Can you hear me okay? And is my screen sharing up?
Yep, you're good for both.
Okay, great. So I'm going to talk about Batson and why Batson, United States Supreme Court case, actually promotes systemic racism, and then what should be done about it. So Batson talks about preemptory challenges as distinguished from challenges for cause. And so preemptory challenges are those kinds of challenges where a lawyer can strike a potential juror basically for any reason or no reason, as long as it's not a constitutionally impermissible reason. And if you were to Google the Batson case, just Google Batson versus Kentucky, which I did this morning, you have about 380,000 hits. If you go to Westlaw and put in Batson and its sites, you'll have about 39,000 citing references. So just as a matter of comparison, Citizens United has only 12,000 citing references, and Miranda, of course, one of the most cited cases of all time, has about 137,000 references. So, looking at preemptory challenges under Minnesota state law, if there's a life sentence at stake, the state has 9 preemptory challenges, again, being able to strike a potential juror for any reason or no reason, the 15 for the accused. In other criminal cases, it's 3 for the state and 5 for the accused. In federal court, I've tried 2 federal death penalty cases, and the federal law allows 20 per side. I think in both cases, I made an exception and gave the defense double the 20. And then in non-capital cases in federal court, the government gets 6 preemptory challenges and the accused gets 10. So I want to talk about why are racially diverse juries important? And so what do we know from social science? There's not a lot of social science studies, but there are some empirical studies, and this is what we know about the benefits of racially diverse juries. Juries with more than one person of color, it tends to reduce inaccuracies in deliberation. It motivates the jurors to deliberate longer. It leads to fewer factual errors. And white jurors contribute more fact-based decision-making, and white jurors have less race-biased discussion, and it actually promotes more discussion about racism. So in criminal cases, the race of the jurors have a significant impact on the results. While convictions for white and black defendants with more than one black on the jury are fairly constant, black defendants are much more likely to be convicted with an all-white jury. And there's a really interesting empirical study out of North Carolina. I've been consulting with the state courts in North Carolina about what to do about Batson and implicit bias. And there's an interesting study that established that conviction rates for black defendants increase about 3 percentage points for every preemptory challenge used by the state. So getting back to Batson, it's, as you can see, it was a fairly fractured opinion. Justice Powell wrote the majority opinion, and the facts are pretty simple. James Kirkland Batson, and I always use the names of defendants when I teach my classes at Drake Law School, because it's important to remember that these are real people. It's not just the name of the case. This was a real person, James Kirkland Batson, and he was indicted in Kentucky, and the prosecutors used preemptory challenge to strike all 4 of the Black persons in the veneer and wound up with there's a spelling error, but an all-white jury. And defense counsel was very sharp and made a really good record, as you can see from the slide, arguing that the removal by the prosecutor of the 4 Blacks violated his constitutional rights. And the trial judge stated that, well, for a preemptory challenge, they can strike anybody they want. The jury convicted James Kirkland Batson on both counts. The Supreme Court of Kentucky affirmed in a 1-paragraph opinion, and Justice Paul wrote the majority opinion, his now kind of famous 3-part test that Justice Paul came up with. The defendant has to make out a prima facie showing of discrimination. Then the burden shifts to the prosecutor to come forward with a race-neutral explanation. And then the judge must determine if the defendant has established intentional discrimination. And the case was kind of hailed as a major breakthrough, but Justice Marshall's concurring opinion was very prophetic. And he talked about that the court's opinion cogently explains the pernicious nature of the racially discriminatory use of preemptory challenges. His opinion traces with some statistics how Blacks were excluded by the use of preemptory challenges from juries. And then Justice Marshall said that the decision will not end racial discrimination, that preemptory challenges inject into the jury selection process. And then he said something that really has come to be true, that the goal can only be accomplished by eliminating preemptory challenges entirely. And just 2 weeks ago, the Canadian Supreme Court did exactly that. They held constitutional a legislative enactment that precluded preemptory challenges in all criminal cases. So the problem, and this is what Justice Marshall pointed out in his concurring opinion, that it's so easy for a prosecutor to come up with a facially neutral reason for striking a juror. Courts are ill-equipped to second-guess those reasons. The courts tend to treat a prosecutor's statement that he struck a juror because the juror, oh yeah, this is an example he used. And he actually cited a case where the prosecutor's reason for striking the Black juror was because the juror had a son about the same age as the defendant. And the judge allowed that preemptory challenge, said it wasn't racially discriminatory. And he cited a couple of cases where a prosecutor said that a potential juror who happened to be African-American never cracked a smile or seemed uncommunicative. The courts have actually upheld all kinds of crazy reasons that prosecutors have given, including one case I recall in a law review article I wrote for Harvard back in 2010 on Batson. One prosecutor gave the reason that the Black female juror had blonde hair, and that he felt that she wasn't comfortable in her skin because she dyed her hair blonde. And the judge sustained that reason for the exclusion. So the real problem with Batson is that, well, yeah, let me back up here, I'm sorry. So the real problem with Batson is that it requires a judge to say to the prosecutor that I don't believe your reason that you're giving. And so particularly in smaller communities where the prosecutors appear in front of the judges maybe on a daily basis or on a weekly basis, and they have a long-standing professional relationship in the courtroom and maybe a friendship outside the courtroom, it's very difficult for some judges to say to the prosecutor, I don't believe your reason. and I'm going to put the person you struck with a peremptory challenge back on the jury. And so if you look at some states, the statistics are staggering. In North Carolina, there have been 252 appeals to the intermediate and state Supreme Court where a trial judge denied a Batson challenge. And the North Carolina courts had never, ever overturned a judge's decision to reject a Batson challenge. And I've got to regress for a minute and tell you about a very kind of bizarre situation. My first year as a federal district court judge was in 1994, and I was trying a case in Sioux City, Iowa. It was a methamphetamine case with a Hispanic defendant, and we had one Hispanic potential juror in the veneer, and that person was randomly selected. The assistant U.S. attorney didn't ask that potential juror a single question, asked questions of other jurors, and then exercised a peremptory challenge to remove that juror, which is really bizarre when you think about it, because they would have no basis for doing it. They didn't ask the juror a single question. So I said, you know, I was a new kind of trial court judge, but I was pretty familiar with Batson. So I said out loud, you know, in front of anybody, is there any motion that either party would like to make at this time after the peremptory challenges have been exercised by both sides? And the defense lawyer just sat there with his thumb up as you know what. So I called them to the bench, the AUSA and the defense lawyer, privately retained defense lawyer. So I said to the defense lawyer, and we had a great system with noise so that all the potential jurors couldn't hear what I was saying, but I looked at the defense lawyer and I said, I'm really surprised you didn't make a Batson challenge. And he looked at me very thoughtfully and he said, Your Honor, I know you think I should make a Batson challenge. And I said, well, you're right. Why aren't you making one? And he looked at me and said, because I don't know what it is. So I turned to the prosecutor and I said, what's your legitimate non-discriminatory reason for removing the Hispanic juror? You didn't ask that person any questions. And he mumbled something that made no sense because there was no good answer. And I said, I'm sustaining the sua sponte Batson challenge, and I'm putting the Hispanic juror back on the jury that had been excluded. So there's a lot of criticism about Batson. Hundreds and hundreds of law review articles criticizing Batson. You can count on one hand the number of law review articles that law professors have written saying that Batson was correctly decided and that has reduced racial disparities. And then there are a number of judicial opinions criticizing Batson, and several states have changed the Batson standard because they're allowed to do it. The federal courts, it's very difficult because federal judges are bound by it, but state courts aren't. Almost all states originally started off using the three-part Batson test. They've made major modifications. But the most dramatic development was 2 years ago. The state Supreme Court in Washington, and I was just on a panel on a Ninth Circuit conference last week with a Washington Supreme Court justice. So it was really interesting to get her perspective. But the Washington State Supreme Court appointed they had a very substantial committee looking at race discrimination and jury selection in the state of Washington. And they came up with this very dramatic court rule, GR 67. And it does a lot of things that are really, really significant in terms of jury selection. So it incorporates unconscious and institutional bias into the rule, and it substitutes, instead of the judge's view of the prosecutor's reason, it adopts the objective observer standard, which is a significant improvement. And it also indicates right in the rule that an objective observer is somebody who is aware of unconscious bias in addition to purposeful discrimination and realizes that that has resulted in unfair exclusion of potential jurors in the state of Washington. And then this is really, I think, for me, the most dramatic part of what the court did. It held certain reasons that are very common as presumptively invalid right in the rule. So for example, prior contact with law enforcement, that's often a reason that prosecutors give. Well, the jurors had this contact with law enforcement and they might have a negative view of law enforcement. So that's the neutral reason. Washington rule says no. Expression of distrust of law enforcement. That's presumptively invalid as a reason to exercise the Batson challenge. Expressing a view that law enforcement engages in racial profiling. The fact that the prospective juror lives in a high crime area. The fact that they have a relation with people who have been arrested, stopped, or convicted. And then it goes on, having a child outside of marriage. You'd be surprised at how many cases there are where a prosecutor offers that as an alleged neutral reason, and the courts have said, yes, that's a neutral reason. Receiving state benefits, not being a native English speaker. Those are all presumptively invalid. And this slide may be a little bit hard to read, but I just want to go through it with you. Another thing that the rule does, it says that the following reasons for preemptory challenges have historically been associated with improper discrimination and jury selection in Washington, so that if a prosecutor alleges that the potential juror was sleeping, inattentive, didn't make eye contact, that's a real common one in the case law, exhibited a problematic attitude, body language they didn't like, a demeanor they didn't like, or provided unintelligent or confusing answers, then that party, which would usually be, I mean, Batson now goes both ways, but it's almost always a prosecutor that's using it to remove a person of color, then they actually have to give notice of that to the parties. And so it gives an opportunity to actually kind of cure it. So the rule GR 37 is a major breakthrough, a huge reform. And just within the last week, the governor of California signed a bill that the legislature established, adopting almost verbatim Washington Court Rule 37. There are a number of judicial opinions now, often in dissent, over the last 2 years, suggesting that their state should adopt something similar to Rule 37. So I'm going to talk about my three-part solution if appointed the grand poobah of jury selection. I would abolish all preemptory challenges in both civil and criminal cases. But in exchange for doing that, I would lower the bar for challenges for cause. In federal court, there's no real definition of what a challenge for cause is. In states, it's sometimes defined, and it basically says that if a juror can't be fair and impartial, then a party can exercise a challenge for cause. I had a very, very low standard in my cases. I called it the whiff test. If I had a whiff, that's all it took. If I had a whiff that a juror couldn't be fair, I would sua sponte, remove that juror for cause. I'd always ask the lawyers, do you have any objection if so-and-so is removed in this case? And, you know, even though the government might not have wanted that juror removed, they never had the nerve to say no in front of the jury, and they never challenged me on it. So I would statutorily in the states have a very low bar for challenge for cause. Now, the reason why judges resist a low bar for challenge for cause is every time you sustain an objection or sua sponte dismiss a juror for cause, then you've got to put another juror in the box. So it takes longer for jury selection, and you obviously need more jurors if you have a very low bar. I think that's a very small price to pay to have a jury that is going to do a much better job, because you don't have put people on it who clearly cannot be fair and impartial. And then the third thing, and I feel very strongly about this, I would prohibit judges from rehabilitating potential jurors. So what does that mean? So let's say the defense lawyer is getting a potential juror to admit that, well, you know, it's unlikely that they could be fair to the person of color who's a defendant. And then either the prosecutor or the judge, often it's the judge, they jump in and they say to the potential juror, well, I understand what you just told the defense lawyer, but if I instruct you that you have to follow the law in this case, will you do that? Well, any potential juror is going to say yes to a person of authority wearing a black robe, usually elevated in the courtroom, sitting above everybody else. It would be the very rare juror who would say, well, Your Honor, if you tell me I have to follow the law, you bet I'll be glad to do it, after having just indicated that they didn't think they could be fair to the defendant, and maybe even volunteering that they couldn't be fair to the defendant because the defendant was a person of color. So those are the things that I would do to change the problem that Batson creates, because it's still a huge problem that it is so easy for lawyers, particularly prosecutors, to circumvent Batson. And even after Batson was decided, there are cases, but there's one out of Texas, where the Dallas County, whatever county Dallas is in, they must have a huge number of prosecutors. I would bet probably a couple hundred. They actually had a manual on what reasons to give to get around Batson. So how you can try and strike a black juror without appearing that you're striking the potential black juror because they're black. And there are other courts that have had training manuals, and then that's been kind of discovered in discovery when people have brought lawsuits against counties for kind of systemic discrimination. So I'd be glad to take some questions if there are any. You can just shout them out here. Anybody have a question? Well, I don't hear any. I just wanted to thank St. Thomas for inviting me today. And I grew up in St. Paul, just a stone's throw from St. Thomas University. I realize the law school is downtown. I'm a big fan of the law school. As I recall, it was created in 1999, and it's just risen. It's a wonderful law school. It has a wonderful faculty. I'd like to put in a plug for my dear friend, Professor Mark Osler. Professor Osler rescued me from a series of, I think I was reversed twice by the Eighth Circuit in bank, and maybe one other time in the same case called United States versus Spears, where I went from 100-to-1 crack powder ratio down to 20-to-1, reversed multiple times by the Eighth Circuit. Professor Osler took over the appeal to the Supreme Court, and the Supreme Court gave the Eighth Circuit an incredible slap in the face, thanks to Professor Osler, and said that I was within my discretion to go to a 20-to-1 ratio. And the day after Stephen Spears' case was decided, I went to a 1-to-1 ratio and never looked back after that. I just wanted to put in one other plug because I've got 1 minute left. For those of you who are law students or members of the community or even lawyers, you might want to Google the name Lena, L-E-E-N-A, Olive Smith. Lena Olive Smith was the first African-American female lawyer admitted to the bar in Minnesota. And she died in 1966. She was admitted in June of 1921. My mother died when I was very young, and I was raised by an African-American kind of second mother. I mean, she didn't have a romantic relationship with my father, but she raised me and my two brothers. And Lena Olive Smith was one of her best friends. And so when I was 10 years old, Tessie introduced me to Lena Olive Smith. And I met her on 2 different occasions. And she's who inspired me to want to be a civil rights lawyer and to go to law school. And so I've tried to carry my entire professional life the inspiration that I received from Lena Olive Smith. She was an incredible warrior for justice against all odds in Minnesota, and was just an amazing human being. So my time is up. Thank you so much for having me, and good luck with the rest of your conference.
Judge Bennett, thank you so much for taking your time to speak with us today. We will now take a quick break and come back at 2:45, where Brandon, my classmate, will introduce our next panel.
Welcome back, everyone. Our next panel this afternoon is moderated by my classmate, Sarah Williams. The panelists are a group of legal practitioners who are on the forefront of eliminating bias or prejudice in the legal profession. Each panelist has worked toward the elimination of injustice by protesting and organizing for change, leading the charge for legal reform, or educating others on the importance of diversity and inclusion. Thank you, and I will turn it over to Sarah.
Thank you, Brandon. Good afternoon, everyone. My name is Sarah Williams, and I am a 3L here at St. Thomas. I am excited for this panel discussion because my experience in the Community Justice Clinic has exposed me to some of the topics we will be covering. We will begin with a brief introduction of each panelist. I'm going to start with Ms. Dunlop. Sybil Dunlop works in an active litigation practice and is a national thought leader on diversity and inclusion issues. Sybil helped found Green Espol's diversity and inclusion practice. She also teaches an award-winning diversity and inclusion training, which receives rave reviews. Sybil has also served on the Infinity Project Board, an organization dedicated to increasing the gender diversity of the state and federal branch. Next, Jerry Blackwell is a founding partner, CEO, and chairman of the Blackwell Burke PA. He's a founder of the Minnesota Association of Black Lawyers. And in 2011, Governor Mark Dayton appointed Mr. Blackwell to serve as an at-large member of the Minnesota Commission on Judicial Appointments. He served 2 terms until 2019. Next, we have Mr. Gordon. Corey Gordon is an experienced trial lawyer. Previously, Mr. Gordon was a partner at Robbins Kaplan, Miller & Searcy LLP, and a deputy attorney general for the state of Minnesota. He is a frequent speaker at national CLE programs. He is an active leader in many community organizations, and he is enthusiastic and thoughtful about the cultural and symbolic purpose of posthumous pardons. Last but not least, Eileen Kaufman is a professor of law at Touro Law Center. Before joining the faculty, Professor Kaufman served as a managing attorney at Westchester Legal Services, where her work included major class actions and law reform relating to government benefit programs. Professor Kaufman has published primarily in the areas of civil rights, women's rights, and human rights. The collaboration of women lawyers nominated her to present their initiative. The Lawyers Justice Corps is an initiative to connect new lawyers with communities in need, provide alternative pathways to legal careers, and address inequalities. Right now, we're going to move into each panelist giving us an opening statement where they're going to be explaining their broad initiatives as change makers. We will follow this with a guided Q&A session. To begin our opening statements, we will start with Ms. Dunlop. Thank you.
Thank you. I'm making a note of my time here. With my 10 minutes, I am going to be wildly ambitious, and I'm going to aim to cover why the law is the least diverse profession, why it matters, and how we can change it. So of course, this is not going to be an in-depth tour, but I'm going to aim to hit at least those points. And I'm going to start with how I came to be interested in the topic of diversity and inclusion in the law. And it is embarrassingly at this point incredibly selfish. And it's when I realized that the perception that my opposing counsel had of me was not the same as my own perception of myself as a lawyer. Several years ago now, I was at a deposition in Indiana, and when my opposing counsel came into the room, he immediately took up all the space in the room. He started telling me about how he had been practicing law since before I was born, and the court reporter had babysat for his children, and he called me little lady. And he called me little lady 3 times, and the 3rd time he said, "Little lady, I'm gonna have to have a lot of bathroom breaks because I have old man disease. Do you know what that is?" And I couldn't help it. It welled up inside of me and it just came out of my mouth. And I said, "Is it that you have to be the center of attention at all times?" And he said, "No, I just need a lot of bathroom breaks." But then we started the deposition and I had prepared well. I was making good points, I thought. And he looked at me suspiciously at one point and said, "What law school did you go to?" Like, it just occurred to him I had gone to law school. And this is a form of bias too, right? Assuming that the ranking of someone's law school says something about the quality of lawyer they are. But at the end of the deposition, he came up to me and he shook my hand and he said, "You're a really good lawyer." And I was so mad. And I was mad because this man was surprised that I was a good lawyer. But then I got on a plane, I went home, I relaxed, I lost some of my anger, and I started thinking about why he was surprised. It wasn't based on animus. He just clearly had not seen a lot of lawyers that looked like me that he thought were good lawyers. And so I started reading about bias. And I started reading everything I could get my hands on about bias. And so I'll call out as I'm talking during my 10 minutes what I'm quoting from, whether it's Jennifer Eberhardt or whether it's Daniel Kahneman, but you'll get my little mini bibliography. But the reason that he was surprised I was a good lawyer is he hadn't, in his experience, seen people who look like me. And every time you have a moment of surprise, it's a moment of realizing you have a bias. And so if you think of the soup we live in, the soup that we live in says a good lawyer looks like Tom Cruise or Gregory Peck. If you're a woman, you've got Elle Woods, right, for famous movies. And if you're a woman of color, there's not a popular movie that comes easily to my mind where you have that sort of cultural touch point. So what does that mean in the law? And when I talk about bias in the law, I want to be very clear that I'm talking about explicit and implicit bias. Implicit bias is that moment of surprise. He was surprised I was a good lawyer, but it wasn't based on animus. But we also have explicit bias. And when there's studies that say that when we send out resumes or we request resumes and people send in resumes, the exact same resume with a white name and a black sounding name, we are more likely to call in the person with the white sounding name and hire them. I don't know, looking at that situation, whether or not that's unconscious bias or explicit bias. And I do want to point out that there's a real danger that in labeling everything unconscious bias, we are taking it out of the realm of being prosecuted because our legal system likes intent, right? And so I am, as part of what I'm doing, calling for a new narrative. And there is a tendency, I think, for us all to love unconscious bias. It's no one's fault. Let's label everything unconscious bias. But I do think there's a risk in doing that. And so when I talk about bias, I deliberately don't use unconscious and explicit unless I'm trying to make a distinction between the two. So here's my premise, and my premise is that our brains, and I'm going to start by talking about unconscious bias and then lead into how it's influencing the law, but also tie it with explicit bias. My premise is that our brains play tricks on us all the time. We know this happens, and we know it happens just with something as innocuous as a cup of coffee. If you hand someone the exact same cup of coffee in a white mug versus a clear mug, the coffee in the white mug tastes more bitter. And they think it's because of the color contrast, that the coffee in the white mug looks darker. And so it tastes more bitter because we expect it to taste more bitter. But it turns out the coffee in the clear mug looks less dark. So we think that we anticipate a smoother taste and we actually experience one. It turns out this happens in every realm of our life. And Daniel Kahneman explains this very well in his book, Thinking Fast and Slow, where he set out to prove that humans don't make decisions rationally. And he won the Nobel Prize in economics for his work in this arena, because of course the foundation of economics is that we are making rational decisions. So how does this play out in the law? And normally if I was doing a full 1 hour presentation, I'd walk folks through it, but I'm going to skip to the chase. And I'm going to tell you about a study that Dr. Erin Reeves conducted not too long ago, where she gave New York partners a legal memo with 22 errors in it. And she told half of them that it was written by a third-year associate named Thomas Meyer, who went to NYU. She told half of them that it was written by a third-year associate named Thomas Meyer, who went to NYU. And half were told that Thomas Meyer was white, and half were told that Thomas Meyer was Black. And the problem is that on a scale of 1 to 5, folks who got the Thomas Meyer memo and thought he was Black graded the memo 3.2, and they graded the memo a 4.1 when they thought Thomas Meyer was white. And here's why it happened. It is very similar to the cup of coffee. People were anticipating mistakes based on expectations, based on messages they've received their whole life about what a good attorney looks like. And so people literally found more mistakes when they were reviewing the memo of the person that they thought was African American. More troubling, however, even than that, which is incredibly disturbing, is that the comments that people received and gave when they thought Thomas Meyer was white were encouraging and also directed him as to how to improve. So white Thomas Meyer was told, great job, but you need to work on your analysis, or has potential. Whereas African-American Thomas Meyer was told, can't believe he went to NYU and average at best. So one comment, frankly, is just an insult, can't believe he went to NYU. And the other comment doesn't leave Thomas Meyer a pathway to success. And so when we are thinking about why our profession is the least diverse, we are 88% white as a profession, but even worse in law firms. One of the answers, I think, is exactly what this study shows us, that we are anticipating the failure of diverse candidates, and we're not supporting their success, and we're not giving them feedback. And a part of that is bias, a part of that is implicit bias, a part of that is explicit bias, a part of it is probably articles that were circulating when I was in law school about lack of mentorship. A part of it is pipeline, but pipeline doesn't make up for the numbers that exist in the law. And so I want to be very clear that this isn't just a pipeline issue. We can always improve pipelines, but the number of diverse folks coming out of law school does not reflect those folks succeeding at the top of our profession. So all of this is to say, I have 3 minutes left to talk about why it matters and how we can change it. But here's why I say that it matters. And I'm going to go to the core existence of our profession here. Right now, if you ask a Latina woman in LA if she thinks she can get a fair shot in front of the judicial system, she's going to say no. And she says no in these polls that they've done because no one in that system looks like her. And so if you have no one in a system that looks like you, you of course are going to doubt the legitimacy of that system. And at the point where we're doubting the legitimacy of our judiciary, which doesn't have the power of the purse and doesn't have the police power, we have a real problem because all it has is goodwill. And when we lose that, we have nothing. We are sitting on sand. And so my thesis statement today is if we don't fix this problem, we are looking at a judicial system that lacks true legitimacy. And I think we're probably already there in a lot of places, and we all need to do better. So my last thing is how can we change it? I don't want to leave anyone depressed because 10 years ago, there was no research on how to change it. And now we have actually some pretty good research about what to do. The number one thing I want to impress upon everyone, though, is that we can't just keep doing what we've been doing because we've been trying and having DEI programs at law firms for, since the 80s, and it hasn't worked. So we have to think really creatively and hard about how to improve things. I think there's 2 ways to at least think about getting rid of bias. And one of them is the way orchestras did. You put up a screen when you're interviewing folks. And so where are areas where we can put up screens? Can we do blind resume reviews? Can we review briefs blind before giving people feedback? There are places in the law where you can do that. There's also, of course, places in the law where you can't do that because we have oral arguments, we have depositions, you want to see people. And so in those areas, I encourage folks to always think about how they can engage in what I call system 2 thinking. That's when you slow down, you make decisions in the morning, you make decisions when you're not rushed, you're thoughtful, you have a list of criteria ahead of time, you write down your responses after an interview, because the faster we move, the more likely we are to rely on the bias, just like the lawyer I had in Indiana who thinks, what does a good lawyer look like? And as soon as you're thinking, what does a good judge look like? What does a good lawyer look like? We're falling back on biases about what the media has told us a good lawyer looks like and not what actual good looks like. So those are my 10 minutes. I am so excited to be here with the other panelists, and I look forward to hearing all of you too.
Wow, thank you so much, Ms. Dunlop. That was really inspiring. I definitely, as a young student attorney and about to enter into the work field, these are some of the concerns and thoughts that I have as well. So it's really exciting and encouraging to see that people out there are actually engaging and thinking about these issues. Next, we're going to have Mr. Blackwell do a 10-minute opening statement. Thank you.
Yeah, I feel like saying, may it please the court with my 10 minutes, my opening statement. But good afternoon. I'm glad to be a part of this panel this afternoon. I have to say to you all that I don't think I ever in my life decided that I wanted to devote myself to dealing with issues of race. It was never a decision. It's simply something I was born into. I've never had a single day where I got up to put on my coat and tie and thought to myself, a black man is walking out the door. You know, so it's never a thought. It certainly comes on you as an imposition based upon all the things that you see around you, and certainly at any intersection that involves money, resource allocation, opportunity, or power, all the time, and always have to deal with it. The thing about the issues of race and my engagements with it in the practice, and what mystifies me about it is the discussion that mystifies me generally about it in this country, is that each time there's a new instance of it in some other sector, there's always mystery around. You know, why do these things exist in the profession? I always ask, well, when didn't it exist in the profession? For that matter, when didn't it exist in America? Point to the point in history when it was equal. Just tell me where it was and we can drop the golf ball there and we'll start playing from there. It's always been there. And so part of the way it perpetuates is in sort of the mysticism around it. If it got to be February in Duluth, and every February in Duluth that we're cold, and every February we're mystified as to what this is. We don't understand, why is it cold here in Duluth in February? You think a crazy person. It's always cold. It's called winter. It's called winter. It's always been winter. Before there was Minnesota or the United States of America, there was winter. And so we all know that. When it comes to issues of race, older than the Constitution, embedded in the Constitution, come forward from the Constitution, you know, mysticism. And it makes it difficult to deal with. It makes it uncomfortable for any person of color, any lawyer of color has to live in this world of what I call a two-ness, as in two, where you have a certain perspective that you know would be acceptable to those around you, but you have certain truths that are real, that are raw, that can even be visceral, that you know you just cannot speak to, because you don't have the liberty or space or freedom, even though there should be equal opportunities. There should be a space for that under the banner of e pluribus unum, from many one, but there isn't. You sort of live in this sort of a two-ness space where we can talk about race, but it's more uncomfortable to talk about racism. And if we talk about racism, it's more uncomfortable to talk about racist. Because nobody wants to be a racist. There was a billboard up by the Ku Klux Klan, I forget what town in Arkansas, but even as the Ku Klux Klan has a billboard that says, we, you know, heart, our children, we love our children. Even the Ku Klux Klan didn't want to be called racist, because we understand that that's sort of a bad word. But it speaks to a history, it speaks to a culture, it speaks to an affront. To any notion of a meritocracy, equal protection, equality, and to me has to be addressed, to me, in the zone of what I call the zone of the of discomfort, in order to go to where it lies, and then to go to where the healing will need to take place. And so, when I came here from North Carolina in 1987. And I was convinced I'd only be here for at best 2 years in Minnesota. I started at was a good law firm. I looked around, and this firm wasn't unique. When I started in 1987, there wasn't any lawyer of color at any large law firm in the state of Minnesota that had lasted more than, I think the record was at least mine, 2.5 years where I started, 2.5 years. That was it. And the partners that existed in the top firms had, for the most part, lateraled in to the firms, and there were so few of them they could easily take a taxi together to the airport. But there were diversity committees, and there was a commitment to working on. Then the word was applicant flow. Then that we want to increase the applicant flow, which was a good thing. Now, once the applicants have flowed, what happens to them, it's a whole different issue. And I would watch generation after generation after generation go through. And it was, personally, for me, extremely stressful as a lawyer of color and one of only 2 or 3 out of hundreds of lawyers. It made you a very noticeable person there. You know, you might as well have been purple in the place. And if I did a memo, and I thought, well, I just answered the question in the memo. I felt I answered the question. I would get compliments from 3 floors up. Heard you did a good job on that memo. I said, well, why would you hear that, right? So you become sort of aware that you've been watched in a different way by people you don't even know, right? And so for me, it was stressful, but I figured, well, if you have an audience, you better give them a show because you are being subjected to a different level of observation and scrutiny. And the truth be told, I mean, I didn't walk away with some sense of either pride or arrogance or aboveness from those kinds of compliments because I didn't really internalize it. Because to me, it's like watching a a little dog that dances on his hind legs. It's not that it dances well; it's just that it dances at all. Was astounding, and so I got kind of used to that, but it wasn't new to me. Like this wasn't my first rodeo. I grew up in a town where the Ku Klux Klan marched in the Christmas parade, right? And you got to think, who in their right mind thinks to celebrate goodwill and charity, have a group march right through the town that stands for absolute hatred and division? Who thinks this way? What is the matter with people? But Merry Christmas. And all of you people like you, stay home. Don't come to the Christmas parade was the deal. So in any event, I found myself kind of jumping in and getting involved in issues of inclusion in the profession, diversity as really a way of me trying to make the world better, starting with where I am and trying to speak to the truths that I have. It is still fundamentally true that where people stand in the world depends on where they've been sitting. That's true for those in law firms. That is true for judges too, and judges are people too, and so they come and bring their own kind of background, their experiences, their mindsets, and so on, and that's a frame of reference for judges even when they judge, although they do their level best to apply the law, even in the best of things. There's all kinds of subjectivities, and the judge has a sort of visceral sense of what exactly is going on here, and on the rubric of trying to do justice and right. And so in my view, even in the judiciary, diversity matters, and not just for confidence in the system. It matters as a part of what is deemed merit, as an output from the justice system. That there are different perspectives that are brought to bear on issues that impact the content of justice depending on where you've come from. And what understandings do you have? If you are an African-American judge who grew up as I did, you don't automatically think that if a police officer is saying that this is what happened, that is necessarily true, because you've seen too many instances or had your own, where you felt less like an American citizen and more like you were simply sort of a subject of a carceral state, just waiting to be cataloged, you know, and you all get sort of harassed by the police. You have a different perspective, probably as a judge, and a reason to have some skepticism about some accounts that get told. So in any event, I had decided to start the law firm I'm in now. I made a partner in this firm. I had there were good lawyers there, good people there. Wouldn't have made partner without them. And by the time I was 31, I was a partner at a large law firm. And but had wanderlust, and part of what led to the creation of Blackwell Bird was my thought, you know, wouldn't it be wonderful if there were at least a law firm where lawyers of color could go, could do top-notch work for Fortune 500 companies, complex litigation, and not have to worry about the isms being a reason that you don't succeed. And more than anything, that was my motivation in trying to start the firm and trying to make the sacrifices to do it, to try to get it off the ground, to try to set up a demonstration where diversity can work if leadership takes it on as a leadership priority, and not just substituting programs for progress, because they aren't the same thing. And so far so good. I started out on my own in 2020. Duped Mr. Gordon here into joining me at some point as one of the partners, and I've been a feral cat ever since. So in any event, I'll stop there. And I don't have any time left anyway, so I'll stop there and go on to the next speaker. But glad to be a part of this, and that's a little bit of sort of the heart that I bring to commitment to diversity and inclusion.
Thank you very much, Mr. Blackwell. Kind of like what you said earlier, it almost feels like we need to say, may we please the court. I'm just in awe of all the excellence that's on the panel right now. So thank you very much. And thank you for sharing those insights. It is definitely interesting to just kind of hear your journey to get where you are now. And we're hoping to dive into that a little bit more when we do the guided Q&A, but thank you. Next, we will have Mr. Gordon. Thank you.
I was afraid that I'd follow Jerry, as I have done so many times. As he reminded me recently, we've been partners for 33 years. So don't let these youthful good looks fool you. Always a challenging act to follow. The way our topic is the role of lawyers in systemic change, and in thinking about what I want to talk about, I thought about, okay, there are really kind of two buckets to this. There's the issues we deal with in our profession, and Sybil has did a great job of talking about the implicit bias on a number of the issues that impact us within the profession, as did Jerry. There's also the external part of it, what we as lawyers do to either hopefully address or unfortunately sometimes perpetuate systemic racism. And perhaps my role on this panel is to bring to bear the perspective of a white male lawyer, because white male lawyer, what is the role of a white male lawyer in addressing systemic racism? And I think that it might be a little bit different than people who historically are on the receiving end of systemic racism. And so sounds like almost a 12-step program, but I think the first thing that you have to start with is accepting and really embracing the fact that there is systemic racism, that this country's foundational premise was racism, and it really has coursed through our country's body politic from founding to today. And we as lawyers, I as a white male lawyer, have an obligation, I believe, a moral obligation, an ethical obligation, a human obligation to address that. Obviously, you can't change. We can't change it individually or collectively, and even in this generation, but we sure as heck can't sit back and do nothing or let it perpetuate. It's my personal view. So doing my small part to bend the arc of justice. I think in one issue I want to mention in that external bucket is who we decide as lawyers we're going to work with for as clients or as co-counsel. There was a study last year in California where fictitious people submitted requests to, I believe they were criminal lawyers, seeking representation using characteristically white names versus characteristically African-American names. And the lawyers and criminal lawyers, you'd think, okay, criminal lawyers, you know, maybe you would have a little bit, maybe they'd be a little bit freer of systemic bias and racism than, you know, maybe some white shoe law firms. Guess what? You were 50%. I'm trying to remember. It was like 50% more of the white sounding names got responses from the lawyers than the characteristically African American names. So we as lawyers, I mean, it plays out in who we are willing to take on as clients. When we retain if we're in an in-house position and we retain outside counsel, or we're in a position as, say, a coordinating counsel and have an opportunity to hire a local counsel or co-counsel in other jurisdictions, who do we reach out to? Do we seek out people like me who look like us, or do we seek out people who bring diversity to the table? And do we really internalize the view that the diversity is a strength? It's a feature. It's not a bug. Juries are diverse, and if we bring to a litigation, which is what I do, if we bring to it just the inherent biases and the worldview of those of us who have managed to make it through 4 years of college and 3 years of law school and are now practicing law, we often miss the important things that are being picked up on by the jury. So I think it's really important that from an internal standpoint, that we have a deep commitment to diversity and inclusion, and they're related, and it's one of the excellent questions that Sarah and colleagues prepared for us. But I want to talk just a little bit with my remaining time about the external. What are some of the things we can do as lawyers to combat systemic racism and make this a more just society? One of the things is civic engagement, civic involvement. Jerry didn't mention it, but Sarah alluded to it. For several years, Jerry played a key role in the selection of the members of the Minnesota judiciary, and I know with absolute certainty that the Minnesota State Court has a more diverse bench today than it did before Jerry joined the Judicial Selection Commission. And that's a tremendous strength. The likelihood now of you getting in a judge, an old white guy who looks like me, is still pretty good, still pretty high. But the chances of getting a female or an African American or an Asian American or a Hispanic, or even Native American, I mean, it's dramatically changed, dramatically shifted, and that is just all for the good. But one particular area I want to talk about is the issue of posthumous pardons. Jerry and I were involved in a project that started a little over a year ago to obtain a posthumous pardon for an individual named Max Mason. 100 years ago, there was a traveling circus that came through Duluth, Minnesota, and a young Duluthian couple attended the circus and hung around after the circus, and many questions as to what actually happened after that. But the upshot of it was they accused, when they came home very late, they accused a group of African-American circus hands of gang raping this young woman. And I believe 15 of the African-American circus workers were rounded up, and because of the sheer number, only some ended up going to the Duluth jail. Others were housed elsewhere temporarily, which saved their lives, because 3 of the ones who were taken to the Duluth jail were dragged out through a hole broken into the wall in the jail, and lynched on a lamppost before a crowd of 10,000 Duluthians smiling and posing for unspeakable pictures that were later sold as postcards. Now, for anybody with experience in the South and with understanding of the history of lynchings in the South, that doesn't sound, well, yeah, I mean, it's terrible, but it happens. But I'm a lifelong Minnesotan, and I can tell you growing up that most white Minnesotans that I know had a view of Minnesota as being some sort of, racism free zone. We never had actual Jim Crow laws. We sure as heck had de facto actions that resulted in de facto segregation and a lot of discrimination. But the idea of just outright lynchings was something that wasn't on the right. I never knew about it growing up. I never heard about it. With the 100th anniversary of the lynchings coming up, it was June 15th. Jerry and I sat down with our partners and said, what can we as lawyers do? We want to raise the consciousness of our fellow Minnesotans about this horrific event. And we digging into it, we learned that there was one man who was actually convicted. He was not in the jail when the lynch mob broke in, but his name was Max Mason, and he was convicted. He was flimsy evidence, went to prison on a 40-year sentence. He was finally paroled after a little over 4 years on the condition that he get out of Minnesota and stay out of Minnesota, because they didn't want. I think the Minnesotans were embarrassed by his presence and reminder of the wrongs that had been committed. Anyhow, my time is up, but to make a long story short, we sought and obtained a posthumous pardon. I'm happy to talk about that in greater details. First and only posthumous pardon in the history of Minnesota. But the history of posthumous pardons in the United States is largely follows that pattern. The overwhelming number of ones we've been able to identify were African American and a handful of Native Americans who were clearly wrongfully convicted because of racism, and the posthumous pardon obviously does nothing for the wrongfully convicted, but it does something for society. It's a way of reminding us and holding up the mirror of systemic racism and making it harder for us white Minnesotans to say, hey, you don't have a problem here. Yeah, we do. Pat, I will yield.
Thank you very much, Mr. Gordon. That's really insightful. I didn't know about that history either until recently, until starting law school. And so this idea of Minnesota nice, yes, there's Minnesota nice, but sometimes people tend to ignore things that are uncomfortable, or we bury things that are uncomfortable. And it's important to acknowledge that history, that the hurt isn't just a Southern historic hurt, and that there are communities that are affected here. So thank you for that. Last but certainly not least, we are going to have Professor Kaufman give us her opening statement and presentation. Thank you.
Thank you, Sarah. So the idea of a lawyer's justice corps grew out of an effort to figure out how to license lawyers at a time when the need for lawyers was really never greater, but the pandemic was making sitting for a bar exam very dangerous, if not impossible. So we proposed the Lawyers Justice Corps to provide what we think is a better way to ensure lawyer competence, more on that in a minute, while simultaneously creating a corps of lawyers that who were committed to addressing both COVID-related legal issues, which are likely to ripple for years and years, as well as a whole range of social justice and racial justice and criminal justice issues that really cry out for lawyers. So our proposal really has two aspects. One is all about enhancing access to justice, and the other is about creating a just and effective method of licensing lawyers. And it turns out those two goals are significantly related. So let me just say at the outset that this proposal was generated by the group that Sarah mentioned. We call ourselves the Collaboratory on Legal Education and Licensing for Practice. We're a group of 10 scholars, all women, who have long studied and written about the bar exam, about licensing, about legal education generally. And at the very, very beginning of the pandemic, really before any of us had any clue what we were about to face, one member of the group, not me, said, we have to start talking about how 2020 graduates are going to be licensed, because sitting for bar exams, bringing hundreds and in some cases thousands of people to sit for bar exam is not going to be possible. So we started brainstorming and coming up with suggestions for jurisdictions as to how they could continue to license lawyers in the face of the pandemic. And one of those suggestions was the Lawyers Justice Corps. So what I'd like to do, and I think it may be another 10 or even 12 minutes, is describe the general contours of the Lawyers Justice Corps, how it has the potential, we think, to address issues of racial injustice. And then I want to talk about the Lawyers Justice Corps as a form of licensing that would eliminate the racial injustice of the traditional bar exam. So first, the Lawyers Justice Corps. The idea is to create a kind of AmeriCorps for lawyers committed to working to enhance access to justice. But we wouldn't want to actually house this project within AmeriCorps, because that's a bureaucracy that is far too cumbersome. Although I should add that I started my legal services career as a VISTA volunteer, as did so many of my colleagues, because in the mid-70s, that was one of the very few ways to do that kind of work. But our proposal really envisions a more nimble, less bureaucratic operation that matches new lawyers with legal services organizations that work with communities in need. And one of the big differences between this proposal and AmeriCorps or VISTA has to do with salary. So when I was offered my VISTA volunteer position, they told me I'd be paid $3,000, not because that's all the government could afford, but because I needed to be able to relate to my clients. And even as a very, very young person, I recognized how crazy that was, since virtually all of the problems my clients were encountering were problems of poverty. So in contrast, our proposal contemplates that salaries would be paid by the participating organization, presumably at the entry-level rate. We recognize that funding is a gigantic issue, but we think that in the COVID-19 world, there are opportunities for funding, both from governmental entities as well as foundations and other not-for-profits. Now, what type of organization would qualify would be determined on a state-by-state basis, because licensing, of course, is determined by each state. I personally would hope that the states would choose a very, very strict definition, one that focuses on organizations working with underserved populations, because if the state adopted a very general definition of public interest, it would include, the arts, it would include government offices, and while those might be very worthwhile placements, they really don't address the problem of, the perennial problem that less than 20% of the legal needs of the poor go unmet year after year after year. And we also hope that the creation of a Lawyers Justice Corps would lead to the creation of new organizations focused on very broad scale initiatives. Some of them were described in other panels today, designed to make the system less racist, like adoption of restorative justice initiatives as opposed to criminalization, or eviction prevention initiatives. We recognize the critical importance of networking with other organizations. One of the keynote speakers today talked a lot about collaboration, and we agree. So we've, for example, been in talks with the Equal Justice Works, which is doing such great work matching law graduates with poverty programs. And we've also been in touch with legislators who are working to enact a civil Gideon, a right to counsel for civil proceedings involving housing and healthcare and other basic human needs. So let me now turn to licensing. And that may seem like a strange topic to be raising in today's symposium, but I think after just a minute or two, you'll see that it fits perfectly. So lawyers who participate in our Lawyers Justice Corps would be licensed at the end of 1 year of service without taking a bar exam. And the participant supervisor would have to certify that the candidate performed competently and consistent with the state's rules of professional conduct. Why is this important? And what does licensing have to do with efforts to combat racial injustice? Let me start by saying that the bar exam is a poster child for institutional racism. I want to let that sink in because it's really true. When one looks at the history of the bar exam, you find that like many other aspects of the profession, it was originally designed to keep out minorities and other so-called undesirables. And I have to say the history of the American Bar Association is especially appalling, with overt efforts to limit minorities from access to the profession. If there's time later on, I can share one particular story that is really sordid and that demonstrates the point. But alongside those blatant acts of racism were initiatives that, while not overt, were just as effective at reducing the entry of minorities into the profession. And the most obvious example of that is where a jurisdiction sets its passing score, its cut score for the bar exam. And a study of that issue in California just came out on October 1st, just a couple of weeks ago. And that study definitively concludes that when a state chooses its cut score, it is choosing the profession's racial and ethnic makeup. And secondly, that the choice of a high cut score does not result in greater public protection. So there have been lots of other studies over the years that show the disparate racial impact of the bar exam. But this California study is particularly important because it was longitudinal. It wasn't looking at a snapshot, right? But it actually looked at more than 85,000 examinees who sat for 21 administrations of the California bar exam from 2009 to 2018, and the race and ethnicity of each examinee. So it was able to see never passers over that period of time. And as I said, the study concluded, and I'll quote from it, that maintaining a high cut score does not result in greater public protection as measured by disciplinary statistics, but does result in excluding minorities from admission to the bar and the practice of law at rates disproportionately higher than whites. So let's be clear what that means. California has historically chosen among the very highest cut scores in the country. If California would select a lower cut score, it would mean that California would have significantly increased the number of minority lawyers in California. And what makes the disparate impact of the bar exam so very infuriating is that it simply does not measure competence to practice law. And I could spend hours on that subject, but I won't. So I just want to very briefly outline what I think are the bar exam's major defects, and then conclude by referring to another very recent study that points the way towards a better, fairer, more just, less discriminatory way of licensing lawyers. So what's wrong with the bar exam, separate and apart from its disparate impact? First, it fails to measure the full range of skills that lawyers need. And bar examiners actually admit that. They concede that point, but they say those other skills are impossible to measure. Secondly, it rewards speededness and memorization. Neither is desirable in practice. And I would say that if one relies on his or her memory as opposed to looking it up, that's malpractice. Third, when it purports to test knowledge and critical analysis and issue spotting, all very, very important skills, it does so in a non-contextual, highly artificial way that bears no resemblance to how problems actually arise in practice. And finally, it drives a host of decisions within law school. Who gets admitted, right? There's an accreditation standard that says you lose your accreditation if your bar pass rate is too low over a period of time. So that means that schools that, it poses an existential threat for law schools, so they're going to be careful about only admitting students with a demonstrated track record of high scores on standardized tests, curriculum, what we offer, what we teach, how we assess. I mean, think about jurisdictions that have adopted the UBE, which is now a big majority of states. Students in UBE states are no longer taking courses in state and local law. There was a study recently in New York that told us that New York practice, a tremendously important course for students planning to practice in New York, you know, students don't enroll in it anymore. Why? Because it's not tested on the bar exam. So to tie this back to the Lawyers Justice Corps, one could say, why waste time studying for an exam that fails to measure the range of competencies that lawyers need when those months could be spent working with clients to prevent evictions, to access public benefits, to challenge conditions of confinement. The list goes on and on. And you could even say that now it's more than a matter of wasted time. This is a time when many debt-ridden law graduates are literally going hungry. They're facing food insecurity, they're facing housing insecurity because they can't start working because they're not licensed. And getting these students to work through a Lawyers Justice Corps could really help them survive financially. So let me end by just saying that we think that this Lawyers Justice Corps as a substitute for the bar exam is consistent with a recent groundbreaking study. The report has, I think it's going to be launched next week. I've seen the draft of it, and it's entitled Building a Better Bar, the 12 Building Blocks of Minimal Competence. This is a national research project sponsored by IALS, the Institute for the Advancement of the American Legal System. And the principal investigator was Ohio State University Professor Deborah Merritt. So the study was aimed at determining how can a licensing system really distinguish minimally competent lawyers from those who are not. And in order to do that, you have to define, what do we mean by minimum competence? The bar exam actually doesn't do that, right? So the researchers held 50 focus groups around the country. I participated in some of the groups in New York, and we brought new lawyers together, and we asked them, in your first year of practice, what did you have to do? And what did you need to know? And what did you need to know how to do? And we also interviewed supervisors of those new lawyers. And what this report came up with is an empirically based definition of minimum competence, which they say consists of 12 interlocking components. They call them building blocks. And then the report offers insights into how these competencies could be assessed. And the report concludes with 10 recommendations for how you could design a just bar exam that measures lawyers' competence while not creating barriers for racial and ethnic minorities. As I said, I think this report is really groundbreaking. It offers a blueprint for jurisdictions to follow if they want to create a licensing system that's truly linked to the competencies required in practice, while not contributing to and exacerbating the lack of diversity within the profession. So I hope I haven't run over too much. I'll stop there.
Not at all. Thank you very much, Professor Kaufman. You've definitely given us food for thought. In all of your opening statements, we had incredible buzzwords, and it's like diversity and inclusion, applicant flow. We're talking about the bar exam and all of these different ideas. So now let me use another cliche. Let's unpack this. Let's go into the guided Q&A part. And so for our audience, we're going to be listing a bunch of questions that we're going to be asking the panelists to address, but we will allow time towards the end. So feel free to use the chat function to input your question. So to start off with, what does it take to attract and retain diverse attorneys or legal professionals in the field? We'll start with Mr. Blackwell. You are muted, sir.
You know, I think to attract attorneys of color and women in the field, you fundamentally have to have a place that is attractive to people of color and or women and others. And by that, I mean, and I found this to be true. back when I was heavily involved in the recruiting and things at Robbins, it was almost sort of like clockwork. If we kind of did an outreach and first and foremost expressed an interest, a sincere, genuine interest in first wanting diverse peoples to be a part of the firm. Set up the cocktails, the meet and greets. You don't just wait for them to come to you. You go to, we went to recruitment conferences in various parts of the country to where the students were. And so we did things that were part of sort of, to me, the external facing part of it, the outreach. But then internally, we have to deal with ourselves in the sense that you've got to try to do an honest assessment about what are some of the reasons, the barriers that might be off-putting to lawyers of color, that might be the reason that they don't have many to start with. And in my view, with most large law firms, where the wheels fall off the wagon is when they have to deal with the fact that all the diversity champions as well as the diversity challenges both walk on feet. And you have to be willing to go into a courageous space to address practices that will tend to exclude. I find that in most firms, if you could do a blind survey and ask the lawyers of color kind of who might be some of the greatest impediments to diversity in there, that you'll see a lot of sameness across the list. But it's not televised, and nobody knows that because you can't really speak to that. So in my view, it is addressing the opportunity barriers. It's addressing the mentorship barriers. It is studying whether or not the criteria for advancement or partnership are fair, equitably given, are opportunities fairly given. And I come back again to money, resource allocation, opportunities, or power allocation. Historically in this country and in firms and everywhere else where there's diversity, if you're not looking at equality when it comes to me providing opportunities and resource allocation, then you're not really addressing meaningfully diversity to me. I mean, will you be the partner? When you head into the courtroom and there's a major hearing and you're taking along some younger lawyers to watch, do you notice that they all happen to be white male and are the newest people to arrive at your firm? Do you notice that? And do you get off the elevator to make sure you go back and include some of the other ones? That's commitment. I mean, that's what that means, in my view. And not, I was, won't talk out of school too much, but had been asked to facilitate a diversity discussion at a different large law firm in the Twin Cities, and the head of one of the practice groups in the firm, hundreds of lawyers, the head of the practice group stood up and he said, I'm just going to be honest. He said, when I have a problem, I look for somebody who looks like me, because I think if they look like me, they'll think like me. What he got was a round of applause for his candor and honesty, and that was it. Nobody said, appreciate your honesty, but that's at least a little problem. Can we talk about that? Didn't happen. So it is, to me, easier, obviously, to work on what we call applicant flow, to get lawyers of color in, and certainly in large law firms, back in my era, 20 years ago, there weren't so many opportunities that you didn't take notice of a law firm that seemed really to be interested. But once they arrive at the steps of the firm, then you've got to do some things institutionally to make sure it's a fair environment, there's the right mentorship, that you have the opportunity to learn and make mistakes. That when you're just learning as a green lawyer, as a lawyer of color, I mean, you already know you don't get much of a margin for error, because your mistakes are viewed as an issue of competency and not just simply learning. And then you have these cycles where people are just turned out every 2 or 3 and now maybe 4 years. So it's a long answer to a short question, but it is, to me, doing the outreach, and even more than that, that's the easy part. It's the working on the improvement of self as the law firm as institution.
Thank you. Absolutely. Definitely. We need to give these buzzwords teeth. We can't just keep on throwing these words around. And to that end, Ms. Dunlop, I wanted to ask, what happens if the current diversity statistics do not change in the next 10 years?
So I think two things happen. One, I talked earlier when I was giving my presentation about how I think we lose institutional legitimacy, and I think it's already happening. I think you see people throughout history being more willing to protest in the streets when they don't think that the courts are actually going to change something. The other thing that I think happens, though, is that we lose out on better outcomes. And I feel like I am doing this more and more when I do these presentations, but I have not realized that I needed to sell the value proposition of diversity as much as I needed to. And so I've been working with clients where I realized that they think they're doing this as something good for society without realizing that it actually, I've realized that maybe I need to tell businesses what a benefit it is to them to get diverse inputs. And the reason is you get better outcomes. If you're a court and you have more diverse opinions coming in, you are going to get a better outcome because you've wrestled with lots of diverse ideas. That is just true. Same thing if you have diverse district court judges. They're creating a portfolio of law that becomes the law of our state. And if you have diverse inputs, you're going to get better outcomes. There's this great research at Google that shows that the teams that perform the best are diverse teams, but also inclusive teams. So if you have one really smart person who doesn't let anyone else talk, you can't outperform that one really smart person's IQ. But if you have a diverse team with lots of people that share ideas, they can outperform each single individual's IQ and get a better result as a team. And whenever I'm in litigation, you can think of that jerk on the other side that doesn't let anyone else talk. And you think, well, my team, if I'm inclusive, we're going to beat that person. I find that inspiring. And I just think that one of the things we have to talk about is the fact that we're not going to be the best we can be unless we fix this problem. And so both, I think we risk losing legitimacy of our institutions, and also we just risk not being as good as we can be.
Absolutely. Absolutely. Thank you so much. Just kind of following up on that, Mr. Gordon, in your opening statement, you said that inclusion matters. It's a critical piece. Do you believe that diversity without inclusion is shallow marketing?
Absolutely. I don't know. I may be dating myself, but there was a movie a number of years ago with Paul Newman, The Verdict. I don't know if the storyline isn't important, but there was a major trial scene where this white shoe law firm defending this big corporation noticed that a couple of the one or two of the jurors were African American. So they said, we got to have a get somebody at the council table who's African American, and so they got somebody out of Trust and Estates or something who happened to be black, who's just sat at the table for the trial. And that, to me, that scene stuck with me for a long time because it's paradigmatic of, okay, there's diversity and look at who's sitting at council table, but who's really being included. And it touches on all of the issues that both Jerry and Sybil mentioned about how do you recruit somebody? Well, it's one thing to recruit somebody. It's another thing once they're there. Are they getting real opportunities, or are they getting limited opportunities? And it's a self-perpetuating thing. If you're giving people of color, women, LGBT lawyers real opportunities, and putting them out there and giving them an opportunity to learn and to grow and to develop. When you try to recruit more, they're going to talk to people like that, and they're gonna say, hey, this is a place that I get real opportunities. And the converse of that is absolutely true. You got to give real opportunities, and you got to encourage participation in the affinity bars. You've got to and be supportive of the affinity bars. All those things have real meaning, and you also have to remember, everybody wants to hire somebody who's in the top 10% in on law review, but 90% of the people weren't in the top 10%, and there are plenty of white male lawyers who were in the bottom 90% who had spectacular careers. Remember that when you're hiring. That doesn't have to be the top 10% and on law review. And my one final comment, because the team's discussion really resonated. I will repeat an oft heard quote in our firm: if you want to go fast, go alone. If you want to go far, go as a group.
Thank you. One of the keynote speakers, Leslie E. Redmond, actually said that quote as well, and it's really inspiring. So Mr. Gordon, just like from what you're saying, I'm going to add another saying that I've heard, which is that diversity invites people to the table, but inclusion empowers your voice to be heard while you're at the table. And so from what you're saying is, let's add teeth to this. Let's not just hire people without actually making sure that they're empowered. So thank you for that. I'm going to shift gears a little bit, and I want to ask Professor Kaufman, how can lawyers who are not directly working in public interest play a role in systemic change, especially given your Lawyers Justice Corps initiative to connect and provide alternative pathways?
Yeah, I think that no matter where you are, you have countless opportunities to do just that. So in my career, I started as a legal services lawyer, so that was easy. That's why I was there. That was our goal, and we did what I felt was a terrific balance between heavy caseload, but also real impact litigation, where we challenged the institutional abuses of the system. When I moved into academia, I started working for legislative initiatives, actually through bar associations. So even though I've been kind of at odds with the Bar Association in this recent fight over the bar exam, there were wonderful collaborations there, and we got enacted in New York what was called the Equal Access to Justice Act, which was a fee shifting statute that in actions against a government agency, the prevailing party, it was very hard for the government agency to get fees, but that the prevailing party would get fees paid by the governmental agency. And that was really important because it's very hard to, unless you can find a legal services lawyer, it's very hard to get lawyers to handle some of these actions, and fee shifting made that possible. We also got some legislation passed that made it much easier to bring a proceeding in forma pauperis. So it streamlined the procedures for allowing low-income people to actually bring their cases to court. And apart from those sorts of things in academia, there are so many issues of accreditation, not to mention the bar exam, that really call out for efforts to address the bias and the institutional racism within academia and within the profession. And there's a wonderful organization of law professors called SALT, the Society of American Law Teachers, whose one of its primary missions is working to diversify the profession. And SALT has been involved in countless initiatives dealing with this issue, very involved with fights to promote and protect affirmative action. Yeah, I'll stop there. But I think, if you're in a position where you can't see a way to try to initiate this kind of change, I think it's a failure of imagination, because there are so many opportunities out there. And some of them are through organized professional organizations, whether it's bar associations or others. I just want to put in a plug for, I'm not sure this directly relates to your question, Sarah, but I'm going to say it anyway. One of the wonderful byproducts of the work that we've done since the pandemic started on the bar exam is to start working with phenomenal law students around the country who, one of the umbrella organizations is called United for Diploma Privilege, but there are lots of these organizations in different states. And I have to say, I feel more confident about the future having met these law students, because they are phenomenal. They are so energetic, they're so engaged, they get it, they recognize they're dealing, it's not just they don't want to take the bar exam, it's they have highlighted the various ways in which populations of color are being hurt so much more during this pandemic, and they're bringing their stories to light. They've done some surveys of students in different states and actually have statistics about the housing insecurity, the food insecurity facing students. They are a force to be reckoned with. And if that's the future face of the profession, I'm feeling good.
That's very encouraging. I'm definitely excited about that as well. I kind of want to go around our panelists. There's a lot of legal excellence among you, and I know that this is a tough question to try to have you distill it in a few minutes, but can each of you explain or tell us, how did you set the stage for systemic change in your sphere of influence? We'll start with Mr. Blackwell.
I alluded to this a little bit before, and I have sort of a general sort of philosophical orientation really to the question that when you talk about introducing change within your sphere of influence, I think for all of us, the change first starts just kind of within you, that if you could manage to reform yourself, you would reform thousands of other people. And without that, then you probably won't see much reforming anyway. That you never eliminate the shadows by cursing at them. You must bring to them light, and that light is historical knowledge to start. That light is courage to stand up. That light is to be willing to stand within your vision, to be willing to stand even when around you are all sorts of attitudes that are dark. How that translated for me as even a young lawyer, second or third year, was looking at the challenge within the large law firms, and we started an organization, the Twin Cities Committee on Minority Lawyers and Large Law Firms, to implement a number of the changes that had been recommended by the Minnesota Minority Lawyers Association, but had been rejected by the large law firms because they felt that none, virtually none, of the members of the Minnesota Minority Lawyers Association actually had jobs within the large law firms, because that's how bad it was in 1987. So we created this organization to make a change, to make a difference. Now Judge Leung was there, former U.S. Attorney Todd Jones. There was a whole nucleus of us. And we decided that listening to the law firms say things like, we can't find, in quotes, qualified minorities. We heard that a lot. So we started the Twin Cities Minority Recruitment Conference to bring lawyers of color from all over the country to Minnesota. So then there wasn't that reason that we can't meet students. The students now come here. And we did that for 4 to 5 years. What we then called the TCC existed, bringing attention and exposure and light. There's Twin Cities Diversity in Practice now, but long before that, there was the TCC. And it was a testament too about the importance of sort of the commitment of leadership. The Hennepin County Bar Association took over the recruitment conference. And as some of us sort of graduated and transitioned to other things, well, the TCC waned over the years. And we went in to form a number of the other bar associations. It was a nucleus of no more than 10 of us that in the same period in the 90s were instrumental in starting the Asian Bar Association, the Hispanic Bar Association. I was one of the founders of the Black Bar Association, and as well as the American Indian, Minnesota American Indian Bar Association, to address these issues. And so again, it's just a part of bringing together like-minded people who share a similar vision and being willing to step into the space to make a difference, to make a change.
Thank you. And as well as Mr. Gordon said earlier, your work on the Judicial Selection Committee definitely goes towards making that change. So thank you.
I'll maybe in a minute be able to say a little more about the Judicial Selection Commission, because that was pretty extraordinary.
Yes, definitely. Next, just to find out how you've set the stage for systemic change in your sphere of influence, Ms. Dunlop.
I hope I still am. I hope I am. So you are, one is always hopeful, but I'm going to start by echoing Mr. Blackwell and say that I think self-awareness is the first step. And I will say that when I teach bias in the law, I share my own IAT scores, which show that I am slower at pairing Black faces with good words than white faces with good words. And I share that because that's not a value that I want to have. It's not a value that I want to live by. And yet I find it troubling, and hopefully it also lets the audience know that, you know, here's where I am. I'm being completely honest with you about where I am, and here's how I'm trying to fix it and address it in my profession and my personal life, et cetera, et cetera. So self-awareness, 2, I think it's really important to speak up, both for yourself and for others. In my law firm, I remember when I was a young attorney, a senior partner didn't want me to go to the oral argument, even though I'd worked on the brief, because it was a female judge, and he thought if I was there and not speaking, he was giving the oral argument, the judge might not appreciate that. So he said, you should stay back. And I agreed at the time, but then I found out that a junior guy on the case had just gone, who hadn't worked on the brief at all, and I was outraged. And so I thought I have to go and confront this person. And I had planned on saying, hey, no big deal, you know, just next time I'd love to go, because that didn't feel fair that I was excluded because I was a girl. Except that I was so angry by the time I said something that I said, hey, no big deal. And then I started sobbing because I was furious. And this partner has said that I can share the story with anybody, because he said, oh my gosh, I had a blind spot, you're right. And so I'm so glad I had that conversation, but it's also good to have it when you see it happen to others. When you're in a hiring committee place and people are like, I don't know, they just don't seem like they'd be a good fit here. You know, you got to call that out. And I have had colleagues get mad at me because I suggested that they might be making a decision based on bias. And that's okay. I try and do it nicely, but I still think it's important to say it. And the last thing I'll say is that I think it's important for me sometimes to sit down. I have junior colleagues now who are awesome, who are people of color, who can totally run with this stuff. And so sometimes when I get an invite, I'll say, hey, you know, you don't need me to do this. You need so-and-so to do it. Interestingly, I started doing this work, as I said, selfishly. People were not hiring women to lead cases, and I love leading cases. And so I thought, well, I'll just have to teach people about bias, and then they'll hire me to lead their cases. Crazily enough, now 25% of my practice is teaching bias and helping folks with these issues. So in a way, you know, there's the universe is crazy how it works. But if I could do one thing with my career, it would be to be a really great lawyer and to make our profession look different. And I think it's good to set what you want to do with your career and ask yourself every year, has it changed? What do I want to accomplish? What matters?
Absolutely, the self-reflective learning and that, you know, kind of keeping yourself accountable with like your own kind of personal board of directors is what one of our professors here, Professor Hamilton, likes to say. Mr. Gordon, how have you set the stage in your sphere of influence?
I guess in recent years, my sphere of influence, if you will, would have been would be in hiring and then mentoring younger lawyers, I guess I've been involved in the hiring of quite a few lawyers over the last 20 years or so, and I'm going to admit something. Even though I know this is public, but I will admit that I have a hiring bias, and I feel very strongly about it. All other things being equal, I give the nod to a candidate who is diverse, whether that be gender, color, gender, sexuality, and it's not because I'm anti-white. It's that I believe that I believe very strongly in a couple of aspects to the practice of law, particularly the practice of litigation, which is what we do. Litigation is about overcoming challenges, and to me, a candidate who has made it through college and made it through law school, when maybe they're the first in their family to have done so, when they are a person of color, when they are female, they're overcoming some challenges that the third or fourth generation young man who was captain of the lacrosse team at his grandfather's alma mater probably didn't have the same challenges and didn't have to overcome them. Maybe they're equally intelligent. Maybe, who knows, maybe the white guy's even a little bit smarter, but I want somebody who knows how to overcome challenges. The second thing is that whole, and Sybil touched on this, in terms of selling it to the client, the diversity of thought that you get when you have a diverse group of people trying to overcome a challenge and identify the best pathways forward. There's a phenomenon I've seen it play out many times. We like to call it the family feud situation, where somebody comes up with some thought and everybody else sits around the table, goes essentially, good answer, and it may be a good answer, or it may be just a lead balloon that maybe a good answer to a bunch of comfortable white privileged lawyers, but it may not be a very good answer to the vast majority of people, and the vast majority of people are where the jury pools come from. So you get a diversity of thought, you get a diversity of approaches and a diversity of reactions that I believe is a tremendous strength. And then again, once you have somebody in the door, you got to give them real opportunities. You got to work with them. You got to give them opportunities to fail and learn, and opportunities to be out there.
Absolutely. Thank you. I hope all of my classmates, 3L class, you just heard Mr. Gordon talk about hiring. I hope you're listening, and I hope that you are going to follow up on that. Next, we're going to talk to Professor Kaufman. Can you let us know how you've set the stage in your sphere of influence?
So I think in my last answer, I addressed some of those efforts. One thing I didn't talk about is teaching, and that should be a part of the answer. I really try to emphasize justice whenever I can, and talk about law in service of justice. When you read cases, so I just retired from full-time teaching about a year ago, but I taught for a lot of years, and teaching first-year law students is just such a wonderful privilege. It's so much fun. They are, so wide open to ideas, and I think it's so important at the very beginning of students' legal education to try to get them to always think about justice when they're reading cases. One of the other speakers today, I think it was the judge, named the defendant in a case and said, you should never forget that this isn't just, a dry case, you're reading the distilled facts and whatever. These are real people here, and think about the human stories. And think about law in service of justice. Whenever you read a case, ask, we all teach students how to brief cases. And I always said, at the end of your brief, don't finish your brief without a piece that is your evaluation, was in your opinion, right? I don't care what the person in the black robe said, in your opinion, was justice done here? Why or why not? And the other part, the law school part of it is, I think that you may be asking a question later on, Sarah, about mandatory pro bono, so I won't address that now, but I absolutely believe that law schools have a critical role to play as part of legal. We get to choose what is the required curriculum. What do we think is most important? And I think that what is part of that answer is teaching students that as lawyers, they have to be public citizens. And in fact, that report that I mentioned that's just coming out that attempts to define minimal competence says that that's one of them. To be minimally competent, lawyers must be cognizant of their professional responsibility for promoting justice. And that's tremendously important. I think that law schools can do a lot with that. That report recommends at least 3 credits in direct teaching of what that means for lawyers to be a public citizen. But there are so many other things. My law school, I was the vice dean to Dean Howard Glickstein for several years, and he's a giant in legal education. He was in the Justice Department in the 60s, helping to write the major civil rights legislation of that era. And he cared so deeply about pro bono work and instilling that ethic in students. So we would have, most law schools have a distinguished jurist in residence. They bring, judges, we had Supreme Court judges and others, but we also had a program called Distinguished Public Interest Practitioner in Residence. So we'd have a lead, Brian Stevenson, someone like that, come to the school, spend 2 days going to classes with our students, interacting, not just in front of a podium, but really one-on-one with students. And the students were every year so motivated, so totally motivated by hearing what you can do with a law degree. We required students to do 50 hours of pro bono work before the state required it. Of course, clinics contribute to this a lot. Summer fellowships in public interest. So I think that even within, the cloistered confines of legal education, there's much that can be done.
Thank you. We have a little under 10 minutes left, and I want to make sure that we get a chance to have you guys dive a little bit deeper into some of the areas that you've been change makers. So Mr. Blackwell, in 2 minutes, and I know that is nowhere near enough time, would you be willing to share about serving on the Minnesota Judicial Selection Committee?
Probably for me, the most rewarding service I've had as a lawyer under the Dayton administration. And Governor Dayton appointed during his 8 years in office, roughly kind of half the judges in the state of Minnesota, given retirements and things. And diversity was so important to him and the Merit Selection Commission that he, through his appointments, increased the overall racial diversity by 89% since 2011. And it is still behind, even sort of with that. So it was extraordinary for the 170 or so judges he appointed. I myself looked over 2,000 applications, so I would know a lot about what people say applying to be a judge at different levels between trial court and then the appellate courts. So in a nutshell, that's what was achieved through the Dayton administration. It was unseen in the history of the state in terms of both the number of judges he appointed and the number of diverse judges he appointed and the number of first he appointed, whether it's the first American Indian to the Supreme Court, the first Hispanic lawyer in Judge Reyes on the Court of Appeals now, the first African-American woman, and Judge Wilhelmina Wright was appointed to the Supreme Court. So just extraordinary first, and what's still amazing in diversity in our profession, that a lot of the first are still walking around. So you have a chance to, at some point, even sit down and have lunch with history. So I'll stop there.
Thank you. The last question that I want to ask, and I will get Professor Kaufman, Ms. Dunlop, and Mr. Gordon's input on, is what are your thoughts on pro bono? There's people who discuss it as being a fair surcharge for the windfall that accrues from the legal monopoly. Some oppose it on the grounds that the burden of distributing legal services to the poor should be borne by society as a whole and not by individual lawyers. So I just want to give you briefly about 2 to 3 minutes for each of you to just let us know what are your thoughts on pro bono, and we'll start with Mr. Gordon.
I am in favor of a pro bono requirement. I'm admitted in other jurisdictions besides Minnesota, and at least a couple of them have a mandatory pro bono requirement. I can't tell you which ones, because it's never, for me, it's never been an issue of compliance. But where the ones that I'm thinking of allow as an alternative that you can write a check to a public interest law group or a legal services organization, which is all fine and good. Obviously it's better to have somebody giving of themselves willingly and really having their heart in it. And I think that's particularly true if you're going to represent people. If you're doing it because you're being forced to and your heart's not in it, are you really going to give them the representation that they deserve? But that said, I think that it's probably better to have a mandatory minimum pro bono requirement than not. I just would like to see a day where you don't even have to ask for it, because it just it's part of the profession's DNA. It should be part of the profession's DNA.
Thank you. Ms. Dunlop?
Yes, 2 thoughts. Easy answer, of course. But more than that, I mean, I'm on the board of CCLI, which is an organization that helps recent law school grads set up at their own solo practices serving low bono folks. And so those are folks who fall within the justice gap where they don't qualify for pro bono services and yet can't afford someone at a firm usually. And so it's not, yes, we have to help people, but there's a whole world of people that need help beyond who's even targeted by pro bono. And, you know, I love the idea of setting up legal incubators to help people serve those folks. But it needs to be, I think as a society, we need to think about how we're failing these folks. And I will close with just a story. A friend of mine was living in Baltimore, and the landlord just decided to sue everyone for failure of rent payment. And he had all the receipts that he could print out showing that he'd made the rent payment. But he got to court that day and no one else had an attorney, and a lot of folks didn't speak English. And he ended up, he's not an attorney, just helping everyone throughout the day prove that they had done it. And, you know, there needs to be people at court helping folks in those instances. There's so much more we could be doing. And I think if it's systemic, if it's attorneys doing it, but also there are institutions playing a role in it, we will better catch everyone. And so I will say, yes, our safety net's terrible. And so we need more resources on it.
Absolutely, thank you. And Professor Kaufman, we'll end with you. What are your thoughts on pro bono?
So the panel is unanimous in favor of mandatory pro bono. In my mind, it just comes with the privilege of having a law license, and I think it is a privilege. This issue has been so bitterly fought in New York, where I was involved in some of the task forces about this. Really, the idea of mandatory pro bono was fought so fiercely by the organized bar, who really considered it to be involuntary servitude. So what New York came up with was mandatory reporting, which has no teeth. You know, you just have to, on your biennial registration, you have to report how many hours you did. I'm very much in favor of mandatory pro bono, but I would permit, I know this is controversial, but I would permit payments in lieu of actual service, because I worry about the quality of the representation. You know, if you assign lawyers who don't have either the knowledge or the attitude, the willingness and sensitivity to work with clients in need, I would much rather have legal services lawyers do it. So I would permit lawyers to, you know, give money to a legal services organization to satisfy their pro bono requirement.
Thank you very much. To all our panelists, I mean, to whom much is given, much is expected, and you've all exceeded that. Honestly, you're so inspiring. Thank you for sharing your journeys. Thank you for sharing your insights. And the mandatory pro bono motion passes unanimously. We would like to thank you all for joining our panel on the role of lawyers in systemic change. I'll pass it on to Dean Vischer. Thank you.
Thank you, Sarah. I want to thank Rachel Hampson, all of the Law Journal editors, and our speakers who made today possible, along with the able assistance of Professors Mark Osler and Ben Carpenter. This is such an important topic to talk about and to keep talking about, and to ensure that we are accountable for concrete steps forward as a result of these conversations. It's important for universities to be at the center of these conversations, to convene experts, to leverage resources, to expand human knowledge in ways that shed more light than heat. That's something that we can do. We have to do more of this than we have before, but it's not enough. The killing of George Floyd galvanized attention to racial injustice in a way that few events have. But attention does not invariably lead to change. That's always been the case, of course, but it's especially true now. And I'd like to briefly explain why that might be. We are witnessing the sorting of America. We are seeing more and more alignment between ideology, geography, religion, race, education, sexuality. Those demographic traits, rather than overlapping and intersecting among political affiliations, are increasingly becoming sorted into political mega identities. Our national divide is not just about political disagreement, it's fundamentally about social identity. The political scientist Liliana Mason explains that, quote, a single vote can now indicate a person's partisan preference as well as his or her religion, race, ethnicity, gender, neighborhood, and favorite grocery store. Bridging the divide will not happen by providing more and better information to those who disagree with us. Dan Kahan has written extensively about what he calls identity protective cognition, which means we think about things in ways that protect our social identity. We all want to stay connected to the groups that are important to us. And one way to do that is to subconsciously resist factual information that threatens our defining values. Kahan explains that what we believe about the facts tells us who we are. And we have a powerful psychological imperative to protect our idea of who we are and our relationship with the people we trust and love. By way of quick illustration, let's take climate change. For an individual American, being right or wrong on climate change will not affect the risks posed by climate change. What they do as individual consumers or individual voters is not going to have a meaningful impact. But taking a position that is in conflict with their cultural group could have a significant impact on their lives in terms of social support or sometimes even financial support. So while the cost to a person of having a view that is in conflict with scientific consensus is very low, the cost to a person of having a view that is in conflict with their group could be very high. Positions on climate change or gun control or abortion or immigration or mask mandates or systemic racism have come to signal what cultural group we belong to. Our views on those issues are driven in significant part by our cultural group, not just our independent analysis of the issue. That's one reason why a diverse and inclusive university matters so much. Our nation's divide regarding racial injustice is not simply a product of opposing moral claims. It's a product of cultures that shape and sustain opposing moral claims. We need to learn how to build trust across cultural boundaries and pierce through the social media algorithms that are embedding us deeper and deeper into our cultural bubbles. Universities need to be part of this work. We have an ability greater than most institutions to bring people together from both sides of the divide, to live, work, and learn together. A willingness to talk about difficult issues like we've been doing today is important, but it's not going to be sufficient. It will also require humility. I heard Representative Moran speak earlier today about walking into a room where she could discern an atmosphere of arrogance. And that's also a pressing problem in the academy. Right? We are the experts. We will bestow knowledge upon you. What society needs most is more of what we have been doing all along. Arrogance is not conducive to growth, and we need to grow. Humility requires us. Humility requires me to take to heart the experience that my friend and former student Leslie Redmond described as having had at St. Thomas, and the pain it still causes today. It doesn't permit us to give up, but it cautions that our next step forward must be made with a willingness to listen and learn from our mistakes. The divide in our country is a costly one. Martin Luther King Jr. recognized nearly 60 years ago that segregation scarred the white man's soul too. As we look to the future, we have to remain accountable for the actions we take to promote justice in our legal system. But we also have to remain accountable for the actions we take to promote a sense of belonging in our own schools, workplaces, churches, and neighborhoods. Those two efforts are closely related. Law is usually downstream from culture. If we neglect the culture, meaningful legal reform becomes even more elusive. Can we work together for the common good in the absence of meaningful relationships across the divide? The Pew Research Center released a study showing that trust is in sharp decline in our country, especially among young people. 73% of American adults under age 30 believe that people just look out for themselves most of the time. 71% say most people would try to take advantage of you if they got the chance. 60% say most people can't be trusted. This is a product, no doubt, of what Pope Francis refers to as the globalization of indifference. The principle of solidarity offers a contrasting vision, reminding us that our differences and disagreements do not define us, and that we flourish only when we are fully present with and for each other. We need to equip our students and our colleagues to engage and even embrace our complicated, messy, often tragic world. If we can encourage an encounter with the world through the lens of solidarity, what difference would that make in the lives of our students? What difference would our students then make in the lives of those they encounter? So my prayer as we conclude for all of us gathered via Zoom right now is that any person we encounter who is inclined toward distrust, toward fear, toward alienation, that we would serve as a living data point to the contrary. That by our presence, our encouragement, our engagement, we would cause that student or that colleague or that neighbor or that political opponent to pause and reflect on what amounts to a glimmer of solidarity in practice, even if they have never heard the term. Pope Francis, in explaining Jesus' instruction to love your neighbor as yourself, puts it this way. He said, amid the thicket of precepts and prescriptions, Jesus clears a way of seeing two faces, that of the Father and that of our brother. He does not give us two more formulas or two more commands. He gives us two faces, or better yet, one alone, the face of God reflected in so many other faces. As we carry the legacy of George Floyd forward, may we never forget to notice the face of God in those we encounter. Thank you for joining us today.